Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. For today's stream, we're going to be doing a very deep dive indeed into the recent decision by the U.S. Supreme Court relating to Trump's and future presidents' immunity. So we're going to read all this. We're going to read the opinion, and we're going to read the concurrences, and we're going to read a dissent, for if no other reason for me to try to figure out more precisely what I think. So I have read the syllabus and I have read the initial description of the thing. And I am going to, so I've read the syllabus and I've read significant parts of the opinion already, but we're going to reread the whole thing and try to figure out exactly what this says and what we think about it. Excuse me. All right, let's go ahead and get started with that. Justice Roberts delivers the majority opinion for the court. This case concerns the federal indictment of a former president of the United States for conduct alleged to have involved official acts during his tenure in office. We consider the scope of a president's immunity from criminal prosecution, of course, not just Trump, but all presidents. From January 17th, from January 2017 until January 2021, Donald J. Trump served as president of the United States. On August the 1st of 2023, a federal grand jury indicted him on 4 counts for conduct that occurred during his presidency following the November 2020 election. This is the special counsel's indictment for charges coming out of D.C., to be distinguished from his cases in New York, Georgia, or Florida. So this is the 4 cases that were filed by Special Prosecutor Smith. The indictment alleges that after losing the election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obscure the counting, collecting, and certification of election results. According to the indictment, Trump advanced his goal through 5 primary means. First, he and his co-conspirators used knowingly false claims of election fraud to get state legislatures and election officials to change electoral votes for Trump's opponent to electoral votes for him. Second, Trump and his co-conspirators organized a fraudulent slate of electors in 7 target states and caused these fraudulent electors to transmit their false certificates to the vice president and other governing officials, with the intent, at least, that they be counted at the certification proceeding on January 6th. Third, Trump and his co-conspirators attempted to use the Justice Department to conduct a sham election crime investigation and to send a letter to targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. Fourth, Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. And when that failed, on the morning of January 6th, they repeated knowingly false claims of election fraud to gather supporters, falsely told them the vice president had authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceedings. Fifth, when a large and angry crowd violently attacked the Capitol and halted proceedings, Trump and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the election. Based on this alleged conduct, the indictment charged Trump with 1. Conspiracy to defraud the United States in violation of 18 U.S.C. 371. 2. Conspiracy to obstruct an official proceeding in violation of 512K. 3. Obstruction of an attempt to obstruct an official proceeding in violation of 512C2, which we discussed earlier, relating to the January 6 people. So that charge would have been dismissed anyway because of that decision, but we're not discussing that right now. We're discussing immunity. So that charge basically no longer existed prior to this decision, but for the purposes of our analysis, we'll pretend it does. And fourth, conspiracy against rights in violation of 241. Trump moved to dismiss the indictment based on the fact of presidential immunity. In his view, the conduct alleged in the indictment, properly characterized, was that while he was president, he made public statements about the administration of the federal election, communicated with senior Justice Department officials about investigating election fraud and about choosing leadership of the department, communicated with state officials about the administration of a federal election and their exercise of official duties with respect to it, communicated with the Vice President and members of Congress about the exercise of their official duties regarding the election certification, and authorized or directed others to organize a contingent slate of electors in furtherance of the attempt to convince the Vice President to exercise his official authority in a manner advocated for by President Trump. Trump argued that all the indictment allegations fell within the core of his official duty, and he contended the president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities to ensure he can undertake the especially sensitive duties of his office with a bold and unhesitating action. So right away, we come up with this idea of basically three concepts. We have core presidential duties. These would be ones that are explicitly named by the Constitution. For example, the power to pardon would be an example. He doesn't need any authorization from Congress, and in fact, Congress can pass no law to augment or otherwise control it. It is what we sometimes call a plenary power, which is to say it's an absolute power that is lodged within one branch of government. For example, the power to impeach would be considered a plenary power of Congress, although in that situation, you have both the House and Senate. But as long as we're speaking about Congress as a whole, that would be an example of a plenary power. It is uncheckable power. It is unilateral power. So that is what we're talking about, right? So the president is given some power by the Constitution to do things. And what the Constitution gives, no act of Congress can take away. So that makes pretty well sense. So that's core power. The other part of the executive power would be all the other things that the executive does. All the agencies and administration and apparatuses of the executive government pretty much are not core power because, there is no EPA, there is no FTC, there is no ATF, but for an act of Congress that makes it so. So that would be an example of non-core power because, the president can only administer it because Congress has created it, and Congress could choose to uncreate it if they so chose. And with respect to some of those agencies, some of you people might support such a bill, but I digress. But that would be an example of non-core power. Cool. Let's keep reading. I'll answer super chats, but otherwise I'm just going to keep reading to keep the flow going. So I hope you don't mind. We'll have time for questions at the end, assuming I still have energy at that point. The district court denied the motion to dismiss, holding that former presidents do not possess absolute federal criminal immunity for any acts committed while in office. So the district court said no immunity for you across the board, which is a pretty bold proposition by the district court, but that's what they said. Thank you, Chuck in Tennessee, for the 20 gift memberships. And thank you, Scooter54, for becoming an uncivilian. The district court recognized the president is immune from damages liability in the civil case to protect against the chilling effect that such exposure might have on carrying out the responsibilities. See Nixon versus Fitzgerald. But a reason that the possibility of a vexatious post-president litigation is much reduced in the criminal conducts in light of the robust procedural safeguards attended to federal criminal prosecutions. I am less persuaded by these robust safeguards, particularly by a sufficiently motivated DOJ. Yeah. The district court declined to decide whether the indicted conduct involved official acts at all, which is also a pretty bold take. $5 from Fiery Patriot says, as an official act, I super chat. Thank you very much for your support. The DC Court of Appeals, of course, affirmed, citing Marbury versus Madison, holla, the court distinguished between two types of official acts, discretionary and ministerial. Ministerial act is just something you have to do as a matter of course. You have no discretion. So a good example of a ministerial act would be going to the DMV to get a driver's license. assuming that you meet all the qualifications, there's no choice. The clerk doesn't get to say no. They can say that you don't have the right paperwork as authorized by law. They can say that you didn't fill out the form as authorized by law. But assuming that you have everything and you did everything, they can't say no. There is no discretion in it. Another example would be, for example, a court clerk with respect to a marriage license. Again, they can require that you fill out the form. They can require that if you're divorced, present copies of your final resolution to show that you're divorced. They can require to show that you're of age and other requirements, but in the end, they have no discretion. They must say yes. They must say yes. There's no choice. Whereas opposed to a discretionary act, even if you meet all the requirements, they can be like, nah, which is a lot of what the president can do. For example, signing a bill would be a good example of a discretionary act. Congress can go through all the mechanisms, and the president can just be like, no, that's okay, I'm good. Or the power to pardon. Not that there are any requirements in the first place, but if there were, right, that you can have all the credentials in the world, and the president can be like, nah, fam, I'm good. So there are some ministerial acts by the president, although probably not many. More to the point, there are a lot of ministerial acts by the bureaucracy, but not as many by the president, but there probably are some. But I digress. But those are two kind of categories that we could fall into. It observed that although discretionary acts are only politically examinable, the judiciary has power to hear cases involving ministerial acts, which is fair enough, because you have no choice. So this is just a do your job. This is a writ of mandamus. Hey, you have no choice, do your job. Cool, that makes sense. From this distinction, the DC Circuit, conclude that separation of power doctrine, as expounded by Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of prosecution means the former president has allegedly acted in defiance of law. Okay. In that court's view, the fact that Trump's actions allegedly violate generally applicable criminal law, it meant that those actions were not properly within the scope of his lawful discretion. Thank you, Aussie Overlord, for the raid. I do appreciate it. Thank you very much for your support. It's extensively appreciated. All right. The DC Circuit thus concluded that Trump had no structural limitation from the charges. Like the DC Court, the DC Circuit declined to analyze the actions described in the indictment to determine whether they involved official acts, which is one hell of a take. Incidentally, we don't even care if they're official acts or not. We're just going to avoid the question. I suppose it makes sense because to our view, it doesn't matter. So why bother trying? So yeah, no, if it doesn't matter, why bother doing the analysis? So I guess fair enough. Still kind of a bold proposition. You know, that makes more sense to my mind if this was more of a routine thing that's more well established at law. Right. So if a judge was like, you know what, I'm just not going to do analysis in this perfectly routine thing because it just doesn't matter either way. So why bother? It would make more sense because we're just following the flow chart. Right. And you're like, OK, I want to bring up this issue. And you're just saying it's not on the flow chart. So why would I do it? It's a waste of my time. But here we're trying to invent the flow chart as we go. So it's kind of a bolder move in this proposition. But anyways, that's what they did. We granted certiorari to consider the following question: whether, and if so, to what extent, what if any, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? So whatever it means, it definitely doesn't mean anything that happened after he left office with respect to this case. So for example, this case would not impact the classified documents case out of Florida, because the entire theory of because every act alleged in that relates to things that happened outside of his office, namely the keeping of records when he wasn't president anymore. So this decision wouldn't impact that, but it would impact the case in Georgia, as we'll discuss, and it would impact the case in New York, as we'll discuss. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. In other words, it's a case of first impression. Which, yeah, no one's ever tried to do this before. So we don't have a lot to work with. I feel that. I feel that. $5 from Pinkin 554. People who don't like Trump need to think about this. Do we need to tie the hands of the president for making split-second decisions? One wrong, one in jail. Yes. Whatever you do, I think you need to think about this beyond Trump. That is definitely correct. So you need to really do your best to put Trump out of your mind for a second and think about the next president, the next 5 presidents, the next 20 presidents, the next 100 presidents. Because we're trying to set up a legal standard here that will survive Trump or Biden or the 5 people who come after them, whoever those happen to be. So we need to think about this, as I would say, in a more systemic way, in a more universal way. I agree. Doing so requires a careful assessment of the scope of the presidential power in the Constitution. Okay. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is to invoke to promote, but instead focus on the enduring consequences of the structure. So, not atypical here, we don't look for the motive for the power to exist. We simply look for the power. And we've done this before, perhaps most notably in recent memory in the case of Heller, wherein we determined the preamble was a preamble. In order to, so that the prefatory clause does not have operatory effect. So see, for example, Article 1, Section 8, Clause 8, which has a similar clause to promote the progress of the useful arts, the intellectual property clause, and for that matter, see the entire preamble of the Constitution, we the people, which likewise has not been held to have any operative effect. So this is fine and normal there. A well-regulated militia being necessary to the security of a free state was the exact phraseology of the prefatory clause of the Second Amendment, now that my brain started working. Great, I finally got there. So, as kind of per normal, we don't look at the motive of the thing, we just look at the thing and the scope of the thing. We're not trying to figure out why it exists, just what it is. Fair enough. The parties before us do not dispute that the former president can be subject to criminal prosecution for unofficial acts, which is to say acts taken in his personal capacity, which it must be true. This is the distinguishment between the man and the office. This is the distinguishment between Donald Trump and the office of the president. These are different concepts. Obviously, Donald Trump is not currently within the office of the president, so they must be different concepts. So Donald Trump continues to exist as a person, even if he's also the president at the same time. He has a personal life that exists outside the presidency, and he's responsible for that personal life. And that makes logical sense. So, fair enough. They also agree that some conduct described in the indictment includes actions taken by Trump in the unofficial, which is to say personal capacity. They disagree, however, about whether a former president can be prosecuted for the official actions. Trump contends that just as a president is absolutely immune from civil liability for acts within the outer perimeter of his office, which is what Fitzgerald held, he must be absolutely immune for criminal prosecution for such acts. And Trump argues that the bulk of the indictment involves conduct involving his official capacity. Although the government agrees that some official actions are included in the indictment, it maintains a former president does not enjoy immunity from criminal prosecution for any actions, regardless of how they're characterized. So some of them might be official, but we just don't care, which is also what the D.C. Circuit said and also what the D.C. trial court said. The U.S. Supreme Court now writing, we conclude that under our constitutional structure of separated powers, the nature of the presidential power requires that as a former president, have some immunity from criminal prosecution for official acts during his tenure in office, which again is to distinguish the man from the office. Just because he's no longer president doesn't mean he wasn't, and those actions weren't authorized. They don't become unauthorized out because he's no longer president, right? He had power for a time, and now he doesn't, and the acts in which the time he had power are lawful, and, you know, if not, then not. That's perfectly fine. Nothing magical there. All right. As at least with respect to the president's exercise of his core power, this immunity must be absolute. Okay. As for his remaining official action, he's also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether the immunity must be absolute or instead whether the presumptive immunity is sufficient. Elena Stansby gives £50 to say grateful for this work, love from across the pond. Well, thank you very much. I appreciate you joining us as we try to figure out how much power or immunity our president has. Yeah. Article 2 of the Constitution provides that the executive power shall be vested in a president. That much is clear. This is the unitary theory of the executive, which, as the Constitution just said, the executive is vested in the president. So the president is the executive. He is all the executive. He is all of it. Now, other parts of the executive are therefore fractions of his power. So they are simply agents of his, and he's the principal. The principal has all the power that the principal has. The principal can give no more power than the principal has, and he can give as much of his power to any of his agents as he chooses, or in this case, as the Constitution or the laws of Congress may choose. But, you know, they are all operating within parts of his power. So that makes sense, logically. They include, for example, commanding the armed forces of the United States, granting reprieves and pardons against the United States, appointing public ministers and consuls, the justices of this court, and officers of the United States. The president also has important foreign relation responsibilities, making treaties, appointing ambassadors, recognizing foreign governments. Does the UK still exist? Better ask the president, he'll tell you. Meeting foreign leaders, overseeing international diplomacy and intelligence gathering, and managing matters relating to terrorism, trade, and immigration. Domestically, he must take care that the laws be faithfully executed, and he bears responsibility for the actions of many departments and agencies within the executive branch. Some would say he should bear them all, but that's another discussion for another day. He also plays a role in lawmaking by recommending to Congress the measures he thinks wise and signing or vetoes that bills that Congress passes. No matter the context, the presidential authority to act necessarily stems either from an act of Congress or from the Constitution itself. Fair enough. If you want to know if the president has authority, go read the authorizing documents. If the Constitution, great. If not, go check an act of Congress. Great. In the latter case, the president's authority is sometimes concurrent, conclusive, and preclusive. So if the Constitution gives it to him, then that's all there is, because it gave it to him and no one else. Okay. When the president exercises such authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. Citing Youngstown's sheet. Old case. Economouth for $5 says, if you get to it, doesn't the Posse Comitatus Act mean Sonia Sotomayor's SEAL Team 6 hypo is ridiculously unrealistic? It's been a while since I read the Posse Comitatus Act, but the Posse Comitatus Act doesn't apply to all branches of the government or all branches of the military. So if not SEAL Team 6, then Air Force Special Forces maybe. But that's a minor point for another day. We can press on. All right. So yes, here we're talking about if Congress passes a law that makes it illegal, but the Constitution gives it to the president, Congress can't make a law that makes it illegal. Congress cannot pass a law that says you can only pardon U.S. citizens, for example. No pardons for non-citizens. Congress can't pass that law. If you do it, we're going to send you to jail for 20 years. No, you're not. Because you can't do that. Because the Constitution gives them the power and you can't change it. So he can act directly against a bill of Congress because in that context, it would be unconstitutional. Because it's his power alone. The exclusive constitutional authority of the president disables Congress from acting on the subject, and courts have no power when they act pursuant to the power invested in him. There is no check. It is an absolute power reserved to him. Fair enough. As of 2021 applies to all except the Coast Guard, fine. Coast Guard Special Forces then. Whatever. Pressing on. If the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so. In Youngstown, for example, we held that President Truman exceeded his authority when he seized most of the steel mills. It's World War II. There is going to be a strike at the steel mills. Okay, and the U.S. government's like, we really need steel because World War II. And they're like, we're going to go on strike. So President Truman's like, no, you're not. I'm going to seize all the steel mills and nationalize them. And now every steel mill is federal steel mill, and they all work for me. U.S. Supreme Court said not so much. No, you can't do that. But that's what they tried. But once it's determined the president acted within the scope of the exclusive authority, his discretion in exercising such authority cannot be subject to further examination. The Constitution, for example, vests the power to grant reprieves and pardon for offenses against the United States in the present. During and after the Civil War, President Lincoln offered a full pardon with the restoration of property rights to anyone who had engaged in the rebellion, but agreed to take an oath of allegiance to the Union. But in 1870, Congress enacted a provision that prohibited using the pardon as evidence of restoration of rights. Chief Justice Chase held the provision unconstitutional because it impaired the effect of the pardon and thus infringed on the power of the executive. To the executive alone is entrusted the power of the pardon, and the legislature cannot change the effect of the pardon any more than the executive can change a law. The president's power to pardon, in other words, is conclusive and preclusive, which disables Congress from acting upon the subject. Some of the president's other constitutional powers also fit that description. The president's power to remove and thus supervise those who wield executive power on his behalf follows from the text of Article 2. We have thus held that Congress lacks authority to control the president's unrestricted power of removal with respect to executive officers of the United States who's appointed. We mean here, of course, political appointees, as opposed to the bureaucracy. The officers of the United States. The power to control recognition determinations of foreign countries is likewise exclusive. So the president can decide a country does or does not exist if he wants to. So that's interesting. Congressional commands contrary to the president's recognition determination are thus invalid. Congress cannot act on and courts cannot examine the president's actions with subject within its conclusive and preclusive constitutional authority. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not criminalize the actions within his constitutional power. I mean, that makes pretty logical sense. You can't possibly criminalize what the Constitution expressly gives the president. That doesn't make sense. Neither may the courts adjudicate a criminal prosecution that examines such the actions. We thus conclude the president's absolutely immune from prosecution for conduct within his exclusive sphere of authority. I mean, that kind of makes sense. I buy that much. Rebecca Zachivsky gives $4.99 to say, good morning, Kurt. Hope you're having a good day. So far, so good. Thank you for joining us as we try to read through this and try to figure out what's going on. Delicious coffee. All right, let's see what else we got. But of course, not all presidential official acts falleth in his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the president sometimes acts pursuant to express or implied authority, which is to say basically every federal agency, because they only exist because there's a bill somewhere that gives them power to exist. Or he in its zone of twilight when he may have concurrent authority. So maybe Congress didn't do a thing, but they both kind of have authority on the subject. The reasons that justify the president's absolute immunity from criminal prosecution within the scope of his exclusive authority do not extend to conduct in which his authority is shared. Okay. We recognize that only a limited number of our prior decisions guide determination of the president's immunity in this context. That is because proceedings directly involving a president have been uncommon in our nation, and decisions in this court of area have been rare and episodic, and pretty much dealing with civil law. So we're not dealing with a lot in our case law. So that's fun and exciting. To resolve the matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers, our precedent on presidential immunity in the civil conducts, and our civil cases in which a president resisted prosecutorial demands for documents. Okay. The president occupies a unique position in the constitutional scheme as the only person who comprises a branch of government. True. The framers sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single, constitutionally indispensable individual in the ultimate authority that, in respect to other branches, the Constitution divides among many. All right. They deemed an energetic executive essential to protection of a community against foreign attacks, the steady administration of laws, the protection of property, and the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of government. The framers accordingly vested the president with supervisory and policy responsibilities of the utmost discretion and sensitivity. He must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional scheme. I mean, yeah. There accordingly exists the great public interest in providing the president with the maximum ability to deal fearlessly and impartially with the duties of his office. Appreciating the unique risks to the effective functioning of government that arise when a president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his duties, we've recognized the president's immunities and privileges rooted in our constitutional tradition of the separation of powers and supported by history. Thank you, Team Brittany, very much for the 5 gift memberships. They are, of course, extensively appreciated. Yeah, that looks better. All right, let's read on. In Nixon versus Fitzgerald, for instance, we've recognized as a fully functioning mandate incident of the unique office, a former president is entitled to absolute immunity from damages liabilities predicated on official acts. Here, civil damages, but, whatever. Sledge and Wedge gives 314 to say, hooray, ding dong, the Chevron deference is dead, which old witch, the Chevron deference, ding dong, Chevron deference is dead. Thank you, Sledge and Wedge, for the 314. It is appreciated. Chevron still is the most important case of this term to me by far, but I have special priorities, so that's okay. That case involved a terminated U.S. Air Force employee who sued former President Nixon for damages, alleging that Nixon approved an Air Force reorganization that wrongfully led to his firing. In holding that Nixon was immune from the suit, our dominant concern was to avoid diversion of the president's attention during decision-making process caused by needless worry as to the possibility of damage actions stemming from any particular official decision. The singular importance of the president's duties in implicating matters likely to arouse the most intense feelings, coupled with the sheer prominence of his office, heightened the prospect of private damage suits that would threaten the diversion. We therefore conclude the president must be absolutely immune from damages liabilities for acts within his outer perimeter. They're talking about civil liability here, but noted. By contrast, when prosecutors have sought evidence from the president, we've consistently rejected claims of absolute immunity. For instance, during the treason trial of former Vice President Aaron Burr, Chief Justice Marshall rejected President John Thomas Jefferson's claim the president could not be subject to the subpoena. Marshall reasoned that the law does not discriminate between the president and private citizens. Because the president does not stand exempt from the general provisions of the Constitution, including the Sixth Amendment guarantee that those accused shall have compulsory process for obtaining witnesses for their defense, a subpoena could issue. Marshall acknowledged, however, the existence of a privilege to withhold certain official papers that ought not on like ground to be forced into public view. And he noted that a court may not require to proceed against a president as against an ordinary individual. Similarly, when a subpoena issued to President Nixon to produce a certain tape recording and documents related to his conversations with aides and advisors, this court rejected the claim of absolute privilege, given the constitutional duty of the judicial branch to do justice in a criminal prosecution. But we simultaneously recognize the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, as well as the need to protect communications between high government officials and those that advise and assist them in the performance of their manifold duties. Because of the president's need for complete candor and objectivity from advisors calls for great deference from the courts, we held that presumptive privilege protects the presidential communications. That privilege, we explained, relates to effective discharge of a presidential power. We thus deemed it a fundamental to operation of government and inexorably rooted in separation of powers. Okay. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on authority and functions of the executive branch than simply seeking evidence in his possession, as in Burr and Nixon. The danger is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damage liability, that the president would be chilled from taking bold and unhesitating action required of the independent executive. Although the president might be exposed to fewer criminal prosecutions than the range of civil damage suits that might be brought by various plaintiffs, the threat of trial, judgment, and imprisonment is a far greater deterrent, which I would tend to agree. I don't want to be put in jail either. So that sounds like one hell of a deterrent to me. Potential criminal liability and the peculiar public opprobrium that attaches to criminal proceedings are plainly more likely to distort presidential decision-making than potential payment of civil damages. Fair. The hesitation to execute the duties of his office fearlessly and fairly, that might result when a president is making decisions under a pale of potential prosecution, gotta love the alliteration, raises unique risks to effective functioning of government. A president inclined to take one course of action based on public interest may instead opt for another, apprehensive that his criminal penalties may befall upon him upon departure. And if a former president's actions are routinely subject to scrutiny in prosecutions, the independence of the executive may be significantly undermined. Yeah, I mean, this is true. And we've seen this in some degree within other countries in the world and even arguably within some states of the United States. With, political opponents, criminally going after their predecessors, and then it just winds up in a negative spiral that lasts forever. So there's definitely some cautionary tales, arguably, from modern world history, let alone ancient history. So, yeah. All right. Let's see. The framers' design of the presidency did not envision such counterproductive burdens on the vigor and energy of the executive. We must, however, recognize a countervailing interest at stake. Countervailing is a great word. Federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in a fair and effective law enforcement. The president, charged with enforcing federal law, is not above them. Chief Justice Marshall's decision in Burr and our decision in Nixon recognized the distinct interest present in a criminal prosecution. Although Burr acknowledged that the president's official papers may be privileged and publicly unavailable, it did not grant him an absolute exemption from responding to a subpoena. Nixon likewise recognized a strong protection for the president's confidential communications a presumptive privilege, but it did not entirely exempt him from providing evidence in a criminal proceedings. Oh dear. All right. Taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitates at least a presumptive immunity from criminal prosecutions for president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and enable the president to carry out his constitutional duty without undue caution. Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his power when a prosecutor merely seeks evidence of official papers and communications, it is certainly necessary when a prosecutor seeks to try, charge, and imprison the president himself for official actions. At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying the criminal prohibition to that act would pose no danger of intrusion upon the authority and function of the executive branch. And here's where I have a bit of a problem, because I don't really know exactly what this means. Because the Supreme Court at no point clarifies what this means here. Or I apologize, the Supreme Court does not clarify what this means. Where they say the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to the act would pose no danger of intrusion on the authority and function of the executive branch. The Supreme Court unfortunately provides no further guidance as to what that means or how hypothetically, as a district court, I am meant to apply that. And I find that very annoying. Because I'm not exactly sure what you want me to do with this, Supreme Court, and that's a bit irritating. But as we explained below, the current stage of proceedings in this case do not require us to decide whether this immunity is presumptive or absolute. Because we need not decide the question, we of course do not. One case in more than 2 centuries does not afford enough experience to definitively and comprehensively determine the president's scope of immunity from the criminal prosecution. As for the president's unofficial acts, there is no immunity. The principles we set out in Clinton v. Jones confirms as much. When Paul Jones brought a civil lawsuit against then-President Bill Clinton for acts he allegedly committed prior to the presidency, we rejected his argument that he enjoyed temporary immunity from the lawsuit while serving as president. Although presidential immunity is required for official acts to ensure the president's decision-making is not distorted by the threat of future litigation stemming from those actions, the concern does not support immunity for unofficial conduct. The justifying purpose of the immunity we recognized in Fitzgerald and the one we recognize today are not that the president must be immune because he is the president. Rather, they're to ensure the presidency can undertake his constitutionally designated functions effectively, free from undue pressure or distortion. It is in the nature of the function performed, not the identity of the actor who performs it, that informs the analysis. This separation of powers does not bar a prosecution predicated on unofficial, which is to say, personal acts. Okay, fair enough. Determining whether a former president is entitled to immunity from a particular prosecution requires applying the principles we've laid out to his conduct at issue, which, I could have used a little bit more information on, to be quite fair, Supreme Court. The first step is to distinguish his official from unofficial actions. In this case, however, no court has thus far considered how to draw the distinction in general or with respect to the conduct alleged in particular. Despite the unprecedented nature of the case and the very significant questions it raises, the lower courts have rendered their decision on a highly expedited basis. Because those courts categorically rejected any form of immunity, they did not analyze the conduct, which, makes sense as far as it goes, but then, of course, we wind up in the problem that we're at. Neither party briefed the issue because, of course, it wasn't an issue, although they did respond to questions about the issue during oral argument. And like the underlying immunity question, the categorization raises multiple unprecedented and momentous questions about the powers of the president and the limits of the authority under the Constitution. As we've noted, there's little pertinent precedent on those subjects to guide our review of this case, a case that we too are deciding on an expedited basis, less than 5 months after we grant the government's request to construe Trump's emergency application for a stay as a petition for certiorari, grant the petition, and have answered the question, which is pretty fast for the Supreme Court, although they can ball faster when they really want to. Let me take a brief break just to have some water and see how you guys are doing in chat, generally speaking. How you guys doing? And you guys doing okay so far? Everything sort of making sense? It doesn't 100% make sense to me yet. That's one of the reasons I'm reading it, so that I can explain it back to you. So I might be like, I'm not sure yet, but how are you guys doing? You doing okay? Yes? Good. Zimmy gives me some hand waves. Hello, streamer. Hello, tax cut. Joined but loving it. Great. All right, we're happy. Great. I need some more allergy medicine. I ran out, and it's showing. That's what's happening right now. I ran out of allergy meds, and I'm paying the price for it. That's what's happening in my life right now. Lame. All right, let's press back on. Let's see where were you. All right. $9.99 from Drip Bayless, who says, thanks, Kurtz. Just started watching from the beginning, but I've been waiting for your analysis. Just started watching the beginning, but I've been waiting for your analysis of this. Well, thank you very much. I'm working on it. I'll get back to you. As we've noted, there's little pertinent precedent on those subjects to guide our review of this case, a case that we too are deciding on an expedited basis. Given all these circumstances, it's particularly incumbent on us to be mindful of our own frequent admission that our court is final review and not a first review. Critical threshold questions in this case are how to differentiate between official acts and unofficial acts, and how to do so with respect to the indictment's extensive and detailed allegations regarding a broad range of conduct. So although it's harder, well, no, that's wrong. Although it's hard, I at least conceptually understand the idea of separating official from unofficial. So it might be difficult to do, but I get it. The immunity issue is I'm still working on. So I at least conceptually sort of get the idea of, okay, I need to separate his personal acts from his official acts. When is he present and when is he just the guy? That's the question, right? When he does a thing, is he the president or is he just a guy? That's the question. And that might be a bit difficult to resolve, but we understand it. We get it. It might be a little bit difficult to figure out in the facts, but at least we understand what we're trying to do. Or at least I understand what we're trying to do. In the issue of immunity, I'm still a little bit vague. The Supreme Court didn't give me a lot to work from. In the middle ground, they didn't give me a lot to work from. They just have one sentence, which is not particularly helpful. Anyways, pressing on. Critical thresholds in this case are how to differentiate between official and unofficial acts, and how to do so with respect to the indictment's extensive and detailed allegations. So, a pain in the ass, but I sort of get what we're trying to do. We offer guidance to those issues below, which I appreciate giving me guidance. I wish I had had that on the immunity issue where you didn't really give me any. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are radically categorized in the light of the nature of the official relationship to the office held by the individual. At least in this context. I'm not sure that's a universal statement, but at least in this context they are. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present a more difficult question. Although we identify several considerations pertinent to classifying those allegations and determining whether they're subject to immunity, the analysis is best left to the lower courts, which, fair enough, but at least you gave me something to work with. Disseminate says it's easy. The principle is easy, but actually doing it is a little bit more complicated. And I'm sure that you can figure out some scenarios without me having to spell them out. You could imagine some scenarios where it'd be a little bit unclear. you know, if it's personal or if it's professional. The blend of the personal and the professional might be a bit muddied. So yes, what we're trying to do is trying to figure out if it's personal or professional. That's what we're trying to do. But actually doing that in particular situations, it might be a little tricky, man. It might be a little tricky. And if you can't imagine a scenario where it might be a little bit tricky, you know, I don't think you're thinking hard enough. You know, but I'll leave it to you to figure that one out. Although we identify such considerations pertinent to classifying those allegations and determining whether they're subject to immunity, that analysis is best left to the lower courts. Cool. Distinguishing the president's official actions from his unofficial ones can be difficult. Also, this is apropos of nothing, but I got a new printer. I just wanted to share. My old brother printer, my old brother laser printer, which I've had, I don't even know, for a decade at this point or something, finally gave up the ghost. And I have a new exciting brother laser printer. I think it prints on both sides of the page now. That's kind of cool. It's a black and white laser printer because that's all I want in my life. I don't want color. All I want is black and white laser. That's exactly what I got. I think it prints on both pages now. And it also has Wi-Fi, which is kind of cool. So I could print from my phone, which I couldn't do before. So hey, that's neat. I just thought I'd share. It was very inexpensive. It was like 100 something bucks. You know, 120 bucks or something. It prints black and white laser print. What more do you need in your life? MS Cassie for $10. Yeah, I guess I could have gotten a scanner and stuff, but that's okay. I don't scan enough documents to make it worth it. If I need to scan something, I just use my phone. I use my Microsoft Lens and take a picture, and it basically scans the document for me. It's good enough. And I don't need to make copies, so I'm fine. MS Cassie says $10. If a POTUS acts illegally, impeach and then bring criminal charges. That's true. They can absolutely do that. The POTUS can't seem seal and rival. Soldiers have moral codes and confuse illegally unethical kills. Yes, I agree, but even then you would think about a potential charge of attempted murder or attempted solicitation, right? So if I try to solicit you, well, that's just solicitation. That's not even attempted solicitation. That's a solicitation. If I come to you and be like, hey, I really want you to kill a guy for me, that's solicitation. And possibly attempted murder, depending on how generous the prosecutor feels that day. So, yes, you might say no, but that doesn't necessarily get me off the hook. So, yeah. Yeah. Distinguishing the president's official actions from his unofficial ones can be difficult. When the president acts pursuant to constitutional and statutory authority, he takes official action. Determining whether an action is covered by immunity begins with assessing the authority. But the breadth of the discretionary responsibilities and laws of the United States in broad areas of laws make them highly sensitive, frequently difficult to determine with his innumerable functions encompassed in particular actions. Yeah, that could be tricky. And some of the president's conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official, even when it's obviously not connected to a particular duty. For example, the President Biden gave a speech, I think yesterday, about how he hates this decision. Does the Constitution require him to do that? Nope. Is he allowed to? Yeah. Is he acting as president when he does that? Sure. Why not? You know, it's fine. So yeah, I get it. That makes sense to me. In dividing official from unofficial, courts may not inquire into the president's motives. Now I just need to figure out what to do with the old printer. So now I need to figure out where to take it to get it recycled. Surely there must be some recycling option. And now I have to figure out what that is. Anyways, such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on Article 2 interests that immunity seeks to protect. Indeed, it would be seriously crippling of the proper and effective administration of affairs as entrusted to the effective executive branch of the government if, in exercising his functions of office, the president was under an apprehension that his motives may at any time become subject to inquiry. We rejected these inquiries. The plaintiff therefore claims he was dismissed for the Air Force for retaliatory reasons. The Air Force responded that reorganization led to the dismissal was undertaken to promote efficiency. Because under Fitzgerald's theory, an inquiry into motives could not be avoided, we rejected the theory, observing that inquiries of this kind could be intrusive. Bare allegations of malice should not suffice to subject government officials either to the cost of trial or the burden of broad-reaching discovery, which incidentally, by the way, this has parallels in general criminal law. We don't typically, for example, go look into motives of a police officer, right? We just ask, did the police officer have legal basis? So if and not even did they have legal basis, but could they have legal basis? Because maybe they didn't notice something, but it was true, right? So if the police officer in fact pulled you over because they hate you, and somehow during it did not notice that you had a taillight out, because why would he be looking? Because he was just doing it for the hell of it, right? But you did in fact have a taillight out. Well, then he would have a valid basis to pull you over, and that's all we care about. We don't look into motives for law enforcement action. We simply look into whether or not they have a basis. Some minor exceptions apply, but, see store for details. Typically, we do not look into motive as a general proposition. Ellen Parker gifted 20 gift memberships. Thank you very, very much. We would potentially look into motive, for example, for retaliatory arrest or retaliatory prosecution, but yeah, no, just no. That is not you. It will never be you. It's never RICO. Staples will take all computers, printers, and etc. to recycle. Well, thank you. That makes my life easier. Thank you. I will take it to Staples, and they will recycle it, and it will make the environment happy. Thank you. All right. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. For instance, when Fitzgerald contended that his dismissal, I raise a problem and you guys super chat and give me money and help also solve my problem. This is the greatest thing. I should have more problems more frequently. This is awesome. You know what problem I'm having a lot right now? I just don't really have, how can I phrase this properly? My car isn't as good as it could be. And I'd really like a Bentley. Okay, great. Moving on. Otherwise, presidents would be subject to trial on every allegation that the action was unlawful, depriving immunity of its intended effect. With these principles in mind, we turn our conduct to allegement in the incident. The indictment, broadly alleges that Trump and his co-conspirators sought to overturn the legitimate results of the 2020 election. Georgia says it's RICO. Yes, they do. Yes, so if we're talking federal, it's never RICO. If we're talking Georgia, it's always RICO. Let's not talk about that any further because it's just sadness. Let's not dwell. Thank you, Alan Parker, for the 20 gift memberships as always. Alan deserves a little extra love because he gives so much to this channel. He's an incredibly prolific donator, and it is appreciated. Thank you, Alan. All right, where were we? Okay, it charges that he conspired to obstruct the January 6th congressional proceeding at which electoral votes are counted and certified, and the winner of the election is certified as president-elect. Also, not for nothing, but my car is perfectly fine. It's a great car. I have a 2009 Infiniti FX35, and I love it. The only problem it has at the moment is that the door's mirror is, the electronics on it are broken. That's the only problem it has. It's a great car. I love it. It's fantastic. And squeaking a little bit now because it's got like 150,000 miles on it. So it's got a little squeaky squeak, but hey, it's a great, reliable car. I love it so much. I love the way it's designed. I think it looks really, really cool. It's got this like wavy front grille that I really like. Since then, they've moved to more of a flat grill look. I don't like as much. They called it the electric catfish. I think it looks fantastic. So, and it's a fantastically reliable car, and it's great. Love it. I'm going to drive it till the wheels fall off. As part of this conspiracy, Trump and his co-conspirators allegedly attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with fraudulent slate of electors. According to the indictment, Trump met with the acting attorney general and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending a letter from the department to those states regarding such fraud. The indictment further alleges that after the acting attorney general resisted their request, Trump repeatedly threatened to replace him. You assume Bentleys are always in the shop like Jaguars? I'm not sure if that's true for Bentley, but it's a fair consideration. $2 from Hamilton Burger says, for your door mirror electronics and WD-40 fund. That's cute. Appreciate it. I'm not sure WD-40 will get the job done, but I do appreciate the sentiment. It's very thoughtful. Investigating and prosecution of crimes is a quintessential executive function. An executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. Okay, the president may discuss potential investigations and prosecutions with the attorney general and other Justice Department officials to carry out its constitutional duty to take care of the law be faithfully executed. And the attorney general is head of the Justice Department. I liked it better when they called him Secretary of Justice. That was a cool title. They used to call the Attorney General Secretary of Justice, and then they started calling them Attorney General, which is a lamer title. I'm just saying. I want to be Secretary of Justice. That sounds badass. If I ever become Attorney General, I wonder if I can just rename it myself. Can I do that? I guess if I'm the Attorney General, I'm the head law enforcement officer. So who's going to stop me? I'll get back to you on that one. And the Attorney General, as head of the Justice Department, acts as the president's chief law enforcement officer who provides vital assistance to him in the performance of the duty to preserve, protect, and defend. Although, strictly speaking, I don't want to be Attorney General. I'd want to be Solicitor General, which is not as high ranking, but at least in my view, it's a better job because I get to argue in front of the Supreme Court all day. So Solicitor General might be fourth ranking within the DOJ, but it's first in my heart, damn it. Investigation and prosecutorial decision-making is the special province of the executive branch, and the Constitution invests the entirety of the executive power inside the president. For that reason, Trump's threatened removal of the acting attorney general likewise implicates conclusive and preclusive presidential authority. As we've explained, the president's power to remove executive officers of the United States to whom he's appointed has not been regulated by Congress or reviewed by the courts. The president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties, which, duh. So he can fire him. I mean, that's fine, no problem. And that's been established, forever. So, yeah, that's been established forever. In Myers was the case that established that? It might have been. Okay. The indictment allegations that request investigations were sham or proposed for improper purpose do not divest the president of authority over the investigation and prosecutorial functions of the Department of Justice and its officials. And the president cannot be prosecuted for conduct within his exclusive authority. Trump is therefore immune from prosecution for alleged conduct involving discussions with the Department of Justice. Please note, by the way, here, just for the sake of clarity, this does not preclude suing the Department of Justice or suing the Attorney General for actions that the DOJ might do, either civilly or even potentially criminally, but probably not so much with a criminal. Let's go after the Department of Justice for the criminal violations that the Department of Justice itself investigates and prosecutes. But, at least in principle. But yes, the issue here is, so this does not mean that, the DOJ or the FBI can necessarily do anything to you. It just immunizes the president. So you can't sue the president. You might be able to sue lots of other people, but that's a different discussion for another time. Okay, so don't get too overtly concerned about this. You can still sue the AG and the FBI and everyone else to the same degree you could before, and actually a little bit more now, because of the end of Chevron. So hey, a little bit extra suing for you. The indictment next alleges that Trump and his co-conspirators attempted to enlist the vice president to use his ceremonial role at January 6th proceeding to fraudulently alter the election results. I've said this before, and I'm going to say this again. I believe that the vice president's role here is ceremonial. I am well aware of what the Constitution has to say on the subject. You don't have to quote it to me. I am well aware of the issue. I believe that the vice president's role is ceremonial. And I will note that, of course, to the extent you don't believe that, that would also be true of all vice presidents, including, for example, the current one. So before you wish too hard that Mike Pence had, done something with respect to our electoral votes, just a friendly reminder, what is true for Mike Pence must necessarily be true for Kamala Harris. So if you really believe in your heart of hearts that Mike Pence had the power to throw out electoral votes and force the issue back to the states and so forth and so on, you also believe Kamala Harris has that power. Do you really want to give Kamala Harris that power? Just saying, check yourself before you wreck yourself and make sure that you're being intellectually consistent. But I think it's ceremonial, so I don't have this problem. In particular, the indictment alleges several conversations in which Trump pressured the vice president to reject the state's electoral votes or send them back, which the vice president can't do. Yeah. The government explained at oral argument that although it had not come to grips with how it would the interactions with the vice president, there is support to characterize the conduct as official. Indeed, our constitutional system anticipates the president and vice president will remain in close conduct regarding their duties. Not sure that the Constitution really contemplates that, but let's pretend it does. These two officials are the only ones elected by the entire nation. The Constitution provides the vice president shall become president in the case of removal of the president from office or his death or resignation. It also empowers the vice president together with the majority of the principal officers of the executive department to declare president unfit. See, for example, 25th Amendment, which I notice is making some increased chatter recently. I noticed that there was some increased discussion of the 25th Amendment. I wonder why. Can't figure it out. And Article 1 of the course names the vice president as president of the Senate and gives him a tie-breaking vote. It's thus important for the president to discuss official matters with the vice president to ensure continuity within the executive branch and to advance the president's agenda and to Congress and beyond. The vice president may in practice also serve as one of the president's closest advisors, or, not. The Office of the Legislative Counsels explained that within the executive branch, the vice president's sole function is advising and assisting the president, which is basically whatever the president wants him to be. Yeah. So if it's nothing, then nothing. Nothing is an option. Which, you get paid for it. So, nothing works too, I guess. You should just go golfing all day and still get paid. I mean, that's cool. Maybe that's a good gig. I don't know. Indeed, the 12th Amendment, which was brought about to avoid the manifestly intolerable situation in which we had a president and vice president of different parties, because that didn't really work out very well when we had presidents and vice presidents of different parties. That didn't go great. The president and vice president together are senior officials of the executive branch and therefore must formulate, explain, advocate, and defend policies of the president's administration. Cool. As the president's second in command, the vice president has historically performed important functions. I don't think that characterizing the vice president as second in command is really either fair legally or really historically. Chief of staff would be a much better position for the second in command than the vice president. I'm hard pressed to think of a time in recent memory in which the vice president might be accurately characterized as being second in command versus the chief of staff. I'm not sure if that's ever been true. And I'm not sure if it's been true at any time within, basically my lifetime or beyond. I'm not sure it's ever been true. So let's press on and pretendo. President Woodrow Wilson, for example, presided over a few cabinet meetings while Wilson was in frank negotiating. Oh, that's nice. The assistant teacher is here. $10 from Jason said, didn't Obama successfully argue his branch has unreviewable power to curb what they unilaterally deem a threat to the United States. In so much as he's acting as commander-in-chief, yeah, basically. Isn't the Supreme Court basically reaffirming that ruling? With respect to that aspect, yes. Yeah. The president has broad power as commander-in-chief. And yes, so yeah, that's broadly true. Correct. Okay, let's see where we were. During President Franklin Roosevelt's administration, the vice president became a regular participant in cabinet discussions, a practice that's been continued by each succeeding president. Sure, I get to go to the meetings and watch. That's cool, I guess. Just send me a notes. I'll read it. Just send me a transcript. I'll get an artificial voice to, translate the transcript into AI, and I'll just listen to it on a podcast as I'm on my bike or something. I have better things to do with my time, but I'm okay. And when President Dwight Eisenhower suffered 3 major illnesses while in office, Vice President Richard Nixon consulted with the cabinet and developed a procedure for relaying important matters to the president. Cool. At the president's discretion, the vice president may engage in activities ranging from the highest levels of diplomacy and negotiation and may do so anywhere in the world. Domestically, he may act as the president's delegate to perform any duties coextensive with the scope of the power of the president. So the president can give the vice president all the power he has, or none, or any amount in between. Cool. I mean, Joe Biden named Kamala Harris border czar, and look what she's done with that position. Yeah. Whenever the president and vice president discuss their official responsibilities, they engage in official conduct. Sure. Presiding over the January 6th certification proceeding at which members of Congress count the electoral vote is a constitutional and statutory duty of the vice president. It sure is. The indictment alleges that Trump attempted to pressure the vice president to take a particular act in connection with the role at the certification, thus involving official conduct, and Trump is at least presumptively immune. $5 from Pinkin 554. I think it happened under Biden with his colonoscopy that he had to go under. I thought Harris was present during that time. That's probably true and is not atypical, at least in modern practice. So that is true. When the president is under general anesthesia, the general practice has been to give the power of the president to the vice president under the 25th Amendment. So that is almost certainly true, and that has been true for the at least I think since George Bush Sr. and possibly before. So yes, if the president is under general anesthesia, he signs a memo that gives the vice president the power of the president for the hours that he's under general anesthesia. That is standard practice these days. So yes, Kamala Harris was probably president of the United States for a couple hours. God help us all. But we lived through it, so I guess it's okay. The question then becomes where the presumption of immunity is rebutted under these circumstances. When the vice president presides over January 6th, he does so in his capacity as president of the Senate. Despite the vice president's expansive role in advising and assisting the president, expansive lol, the vice president's Article 1 responsibility of providing over the Senate is not an executive branch function because it's a legislative function, because it's the Senate. Makes sense to me. With respect to the certification proceeding in particular, Congress has legislated extensively to define the vice president's role, which is, not much, and the president plays no direct role in that process. So the government may argue that consideration of the president's communications with the vice president concerning the process does not pose a danger of intrusion. Cool, fine. Yeah, a heartbeat away and second in command are two different things. I agree. Yeah, they're not the same concept. Yeah. At the same time, however, the president may frequently rely on the vice president in his capacity as president of the Senate to advance the president's address agenda in Congress. So we're pulling a Sarah Palin when she was asked what she would do as vice president, and saying, I'm going to get in there with those senators and I'm going to really work on legislation, which, to be fair to Sarah Palin, is probably the most constitutionally sound answer, even though she has no real power. But she was mocked for it. So, because it seemed like maybe she didn't know that she had no real power. But, you know, she can preside over the Senate. It's been a long time since that's been true. I'm trying to remember when the last time there was a vice president who routinely presided over the Senate. It might have been like Eisenhower or something. It's been a hot minute since the vice president routinely presided over the Senate. But they can. There's nothing in the rules that present it. They just don't bother. Because why? But they can. If you just want to show up and, you know, look pretty on camera. And you got nothing better to do with your time, so maybe, I don't know. Applying criminal prohibition to the president's conversation discussing such matter with the vice president, even though they concern his role as president of the Senate, may well hinder the president's ability to perform his function. It is ultimately the government's burden to rebut the presumption of immunity. We therefore remand the district court to assess in the first instance, with appropriate input, whether the prosecution involving Trump's attempts to influence the president's oversight would pose a danger of intrusion on the authority of the executive branch. Okay, fine. The indictment's remaining allegations cover a broad range of conduct. Unlike the allegations describing Trump's communications with the Justice Department and the vice president, these remaining allegations involve Trump's interactions with persons outside the executive branch, state officials, private parties, and the general public. Many of the remaining allegations, for instance, cover at great length events arising from communications that Trump and his co-conspirators initiated with state legislative and executive officials in Arizona, Georgia, Michigan, Pennsylvania, and Wisconsin regarding those states' certifications. Specifically, the indictment alleges that Trump and his co-conspirators attempted to convince those officials that election fraud had tainted the popular vote in their states, and thus the electoral votes need to be changed to votes for Trump, which at the time I'm not sure was illegal, to be honest. But okay. As Trump failed to convince those officials to alter their state processes, he and his co-conspirators allegedly developed a plan to marshal individuals who would serve as Trump's electors had he won the popular vote, and cause those individuals to make and send to the vice president false certifications. If the plan worked, the submission of the fraudulent slates would position the vice president to open and count the votes at the certification proceedings and set up a fake controversy that would derail the proceedings. And the vice president basically looked at the statute and said, here's how we determine whether or not certifications are authentic or not. Because there's a process spelled out in law for this. And he's like, here's some things that say they're certifications, but they're not, because the law says they're not, so they're not. And so that's the end of that discussion. So, yeah, pretty, dumb, but, fine. It's just like, I'm just literally reading the words on the page and be like, it has to meet these things. It doesn't meet these things. Therefore, it's not the thing. It's logic. It's fun. All right. On the same day that the legislative electors met in their respective jurisdictions, the indictment alleges that Trump, fraudulent electors, convened sham proceedings in the 7 target states to conduct fraudulent election ballots. These ballots were mailed to the President of the Senate, the Archivist of the United States, and others. They were cosplaying, and they were fools. At argument, Trump appeared to concede that at least some of these acts involving private actors who helped implement a plan to submit fraudulent slates of electors entail private conduct. He later asserted that asking the chairwoman of the Republican National Committee to gather electors qualifies as official conduct because the organization of alternate slates of electors is based on, for example, the historical example of President Grant as something that was done pursuant to an ancillary and preparatory to the exercise of a core power. And apparently, there is precedent of Grant sending troops to Louisiana and Mississippi in 1876 to make sure the Republican electors got certified in those cases. which, okay, is this just like a civil rights thing? Then, probably fine. But okay. He also argued that it's absolutely an official act for the president to communicate with state officials on the integrity of the federal election. To be fair, the Constitution of the United States does say the United States shall guarantee to the states a Republican form of government, which the Supreme Court has never clarified what that means at all, ever. But if Grant was sending troops to support authentic electors because they were being intimidated or whatever, and he was boistering real people, then he's probably acting under that clause. But I digress. That's a finer point of some stuff. So yeah. All right, pressing on. On Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity of the election. Of course, the president has the duty to take care the law be faithfully executed, and the president's broad power to speak on matters of public concern does not exclude his public communication regarding the fairness and integrity of the election simply because he's running for re-election. Similarly, the president may speak on and discuss matters with state officials, even when no specific federal responsibility requires his communication, to ensure them to act in a manner that promotes the president's view of the public good. Okay. As the government sees it, however, these allegations encompass nothing more than Trump's private scheme with private actors. In its view, Trump can point to no plausible source of authority enabling the president to not only organize alternate slates of electors, but also cause those electors unapproved by any state official. And that's sort of the key there for me, is they're unapproved by any state official. So we're not trying to foster or promote the state apparatus. We're trying to do something outside the state apparatus. So that's sort of the problem there, for my mind. To transmit the votes to the president of the Senate for counting at the certification proceeding, thus interfering with the votes of the state's properly appointed electors. Indeed, the Constitution commits the power to the states to appoint the electors in such manner as they may direct. Fair. Article 2's, Section 1's appointment power, we've said, gives the states far-reaching authority over presidential electors, absent another constraint. So ultimately, they can just do whatever the hell they want, but it's up to them to do whatever the hell they want. So that's the key. Although Congress may be able to restrict it to doing whatever the hell they want within certain deadlines and so forth and so on, but that gets into the finer points of whether the revised Electoral Count Act is constitutional or not, which we do not have time for. So the Congress has attempted to constrain the state's ability to make this choice by saying effectively they have to make it before Election Day. So if they want to just appoint the electors themselves, they still can do it. But if they say we're going to do it by a vote, then they're bound by that decision. So they say they can't change their mind after a certain date, which, is that constitutional? I'd say yes, but, maybe someday we'll have a fight over it. Who can say? All right. By contrast, the federal government's role in appointing electors is limited. Congress may prescribe when the state-appointed electors shall meet and certify the votes. So they can say, okay, the electors have to meet on this date and cast the votes. And, so there's some authority for Congress to say, all right, that's it. And you can't change it after that because that's the date. So, fair enough. That's some authority. The president, meanwhile, plays no direct role, nor does he have authority to control what state officials will do, which, is generally speaking true. This federal government generally doesn't have authority to control what state officials will do. And the framers, wary of cabal, intrigue, and corruption, specifically excluded from service as electors all those who might be too devoted to the president. So there are some exclusions, but, not many. But it's in the Constitution, so it's fine. Determining whose characterization may be correct and with respect to which conduct requires a close analysis of the indictment, extensive and interrelated allegations. Unlike Trump's alleged interactions with the Justice Department, this alleged conduct cannot be neatly categorized as falling within a particular function. The necessary analysis is instead fact-specific, requiring assessment of numerous alleged interactions with a wide range of officials and private persons. and the parties' brief comments at oral argument indicates they starkly disagree on the characterization of these allegations. The concerns we noted at the outset, the expedition of this case, lack of factual analysis, and absence of pertinent briefing thus becomes more prominent. We accordingly remand, which means very likely that Trump will probably never go to trial, because trying to figure out what all this means is going to take forever. And then the appeals will take forever, and then those will take forever. So I don't think Trump is ever going to trial in DC or Georgia, as we will discuss eventually, I assume. What was the split on this? 6-3, exactly what you'd expect. 5-3 for the core opinion. Amy Coney Barrett dissented on, well, I guess dissented on one part. Well, dissented is wrong. She concurred on one part. She came up with a different theory. So 6-3 principally, 5-3 for one particular section, which when we get to care, but we don't care really for the purpose of counting, thank God. So I don't have to count to 5. Because if I had to count to 5, I don't want to count to 5. That's a Marx thing, and that makes my life difficult. So I don't have to count to 5. Principally 6-3. As to whether or not she's right or not, I'll let you know when I read her opinion. All right, where were we? All right, blah, blah, blah. Finally, the indictment contains various allegations regarding conduct in connection with the events of January 6th itself. It alleges that leading up to January 6th certification proceeding, Trump issued a series of tweets encouraging his supporters to travel to D.C. Trump and his co-conspirators, well, according to the indictment at least, addressed the gathered public that morning, asserting that certain states wanted to recertify their votes and that Vice President had the power to send the states back, which he absolutely does not. Trump then allegedly directed the crowd in front of him to go to the Capitol to pressure the Vice President to do so at the certification proceeding. When it became public the Vice President would not use his role as that which he can't do, the crowd gathered at the Capitol, broke through the barriers, and eventually broke into the building, leading to our Capitol riot series and a lot of criminal actions. The alleged conduct largely consists of Trump's communications in the form of tweets and public address. The president possesses extraordinary power to speak to his fellow citizens and on their behalf. As the sole person charged by the Constitution with executing the law of the United States, the president oversees, and thus will frequently speak about, a vast array of activities that touch on nearly every aspect of American life. Indeed, the long-recognized aspect of a presidential power is using the office's bully pulpit to persuade Americans, including by speaking forcefully or critically in ways the president would believe advances the public interest. He's even expected to comment on these matters of public concern that may not directly impact the activities of the federal government. For instance, to comfort the nation in the wake of an emergency or tragedy. For these reasons, most of the public comments are likely to fall within the outer perimeter of his office. There may, however, be context in which the president, notwithstanding the promise of his position, speaks in an unofficial capacity, perhaps as candidate for office or party leader. And I think that this is correct. You know, the president giving a speech at the RNC is not an official act, despite the fact he's president. So yeah, I tend to agree. And trying to figure out where January 6th falls exactly in that is challenging at best. So yeah, but you know, at least in principle, we understand what we're trying to do. Q squared, in answer to your question, the Constitution excludes certain people by definition. It says it in the constitutional text, who cannot be electors. I could look it up, but yeah, it's defined. It's not ambiguous. The analysis, therefore, must be fact-specific and proven and challenging. The indictment reflects these challenges. It includes only selected cheat tweets and brief snippets of speech Trump delivered on the morning of January 6th, omitting its full text or context. Whether the tweets, the speech, and Trump's other communication on January 6th involving official conduct may depend on the content and context of each. Knowing, for example, what else was said contemporaneously to the excerpted communication or who was involved in transmitting the communication and organizing the rally could be relevant. We therefore remand. So we still have to figure out whether Jan's 6th speech was official, unofficial, or something in between. So that could get fun and exciting, I'm sure. The essence of immunity is that possessor's entitlement not to have to answer for his conduct in court. Presidents therefore cannot be indicted based on conduct for which they're immune, which would be generally speaking of all immunity. As we've explained, the indictment here alleges at least some conduct. On remand, the district court must be careful to analyze the indictment's remaining allegations, determine whether they too involve conduct for which the president must be immune from prosecution. And the parties and the district court must ensure that sufficient allegations support the indictment's charges without such conduct. The government does not dispute that if Trump is entitled to immunity for certain acts, he may not be held criminally liable for those acts. But they nevertheless contend the jury could consider evidence concerning official acts for the limited and specific purpose, and such evidence would be admissible to prove, for example, knowledge or notice of the falsity of his election fraud claims. That proposal threatens to eviscerate the immunity we've recognized. It would permit a prosecutor to do indirectly what he cannot do directly, invite a jury to examine acts for which a president is immune from prosecution to nonetheless prove the liability for those charged. And the government's position is untenable in light of the separation of powers. And as Destiny sort of mentioned yesterday when I was briefly on stream with him discussing this, excuse me, as Destiny briefly mentioned as I was on stream with him, this might, for example, prevent the president from being tried for a bribe to give out a pardon. Because since pardon, as the Supreme Court just noted, is within his core role, which it is, because the Constitution gives it to him, if we can't use it even as evidence in a charge, then how do we prove bribery? Because, well, we prove the money was given, but what is the quo to the quid, right? If the charge is bribe for pardon, if we can't mention the pardon, how do we prove the bribe? This, I think, is a fair concern. I do not have a good answer to this concern at this time. All right. But the Constitution deals with substance, not shadows. And the government's position is untenable in light of separation of powers we have outlined. If official conduct for which the president is immune may be scrutinized to help secure his conviction, even on charges that purport to be based only on unofficial conduct, the intended effect of the immunity would be defeated. The president's immune conduct will be subject to examination by a jury on the basis of generally applicable criminal law. Use of evidence about such conduct, even where the indictment alleges only unofficial conduct, excuse me one second, my voice just got real scratchy. Yeah, we're not talking about impeachment. I'm not talking about impeachment. Impeachment is, I'm still of the opinion that they can impeach him for anything. We're not talking about impeachment. In my question, I'm assuming the president is not impeached. So, yes, if he's impeached, then obviously, but I'm assuming he's not. That was my question. So, yeah, I don't have to re-explain it. You get it. The president's immune conduct will be subject to examination by a jury on the basis of generally applicable law. Use of evidence about such conduct, even where the indictment alleges only unofficial conduct, would therefore heighten the prospect that the president's official decision-making will be distorted. The government asserts that these weighty concerns can be managed by the district court through the use of evidentiary rulings and jury instructions. But such tools are unlikely to protect adequately from the president's constitutional prerogatives. Presidential acts frequently deal with matters likely to arouse the most intense feelings. Allowing for prosecutors to act or suggest that the jury probe official acts for which the president is immune would thus raise a unique risk that jury's deliberation will be prejudiced by the views of the president's policies and performance while in office. The prosaic tools on which the government would have the courts rely are an inadequate safeguard against the peculiar constitutional concerns implicated in the prosecution of the former president. No worries. Sometimes it's difficult to know who's talking to who. So I apologize if my comment was unduly concerning. I sometimes it's difficult to know who's talking to who. So I apologize. It's one of the difficulties with just coming halfway in chat and just like reading one line, because I'm just like reading a line to try to respond to something. So yeah, that's one of the challenges. Sometimes you read something that's not meant for you. So what can you do? All right. Although such tools may suffice to protect the Constitution, I suppose I could just ignore anything that doesn't, say @Uncivil or something. I could just ignore anything that doesn't have my name. Maybe that's the solution to the problem. I don't know. But okay. Anyways, pressing on. Trump has asserted a far broader immunity than the limited one we've recognized. He contends that the indictment must be dismissed. Thank you, Janet F., for the 5 gift memberships. They are extensively appreciated. Thank you very much. He contends the indictment must be dismissed because the impeachment judgment clause requires the impeachment and Senate conviction precede a prosecution. The text of the clause provides little support for SEP's absolute immunity. I agree with this. I never really thought the impeachment clause did anything with respect to what happens if he's not impeached. It's very clear what happens if he is impeached, but I didn't think it provided any support for what happens if he's not impeached. So I agree with the Supreme Court in dismissing this idea. This never worked for me. It states that an impeachment shall not extend further than removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. It then specifies the party convicted shall nevertheless be liable to subject to indictment, trial, judgment, and punishment according to law. Answer to a bribe for a pardon is impeachment. That's an answer. Whether or not it's the only answer is my concern. Is it the only answer? It's an answer. Is it the only answer? But thank you for the $2. And if it is the only answer, I'm not sure that's necessarily satisfactory. So I'm, never mind. We can press on. I'm thinking it through. Let's see. All right. The clause both limits the consequence of an impeachment judgment and clarifies, notwithstanding such judgment, subsequent prosecutions may proceed. By its own terms, the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached. Historical evidence likewise lends little support to Trump's position. For example, Justice Story reasoned that without the clause's clarification that indictment, trial, judgment, and punishment may nevertheless follow the Senate conviction, it might be a matter of extreme doubt whether a second trial for the same offense could be had either after an acquittal or conviction in a court of impeachment. I don't think the double jeopardy clause is implicated at all, because it's not legal, it's political, but I suppose you could have a debate over it. And so it clarifies the debate. Fine. James Wilson, who served on the committee that drafted the clause and later as a justice of this court, similarly concluded that no acquittal of impeachment charges bars a subsequent prosecution. And contrary to Trump's contention, Alexander Hamilton did not disagree. The Federalist Papers on which Trump relies concerns the checks available against a sitting president. Hamilton noted that unlike the King of Great Britain, the president would be liable to be impeached and removed from office and would afterward be liable to prosecution and punishment. Okay. Hamilton did not endorse or even consider whether the impeachment judgment clause immunizes a former president from prosecution. The implication of Trump's theory is that the president, who invades impeachment for one reason or another during his term, can never be held accountable for his criminal conduct in the ordinary course of law. So if a president manages to conceal certain crimes throughout his presidency, or if Congress is unable to muster the political will to impeach, then he must forever remain impervious. Impeachment is a political process, not legal. So, thank you for that. Impeachment is a political process by which Congress can remove the president who's committed treason, bribery, or other high crimes and misdemeanors. Transforming the political process into a necessary step in the enforcement of criminal law finds little support. I appreciate that. It is a political process, not legal. Please do not conflate the two. Get off my lawn. That's fine. I have no problem with that. All right. Excuse me. All right. The government, for its part, takes a similarly broad view, contending the president enjoys no immunity from criminal prosecution for any action. It maintains this view despite agreeing with much of our analysis. For example, the government does not dispute that Congress may not criminalize presidential conduct within the president's conclusive and preclusive authority. See, for example, oral argument, quote, core powers can't be regulated at all, like the power to empower and veto, unquote. And it too accords protection to the presidential conduct if subjecting that conduct to generally applicable law would raise serious constitutional concerns regarding the presidential authority or cause a possible conflict with the president's constitutional prerogative. Indeed, the executive branch has long held that view. The Office of Legal Counsel has recognized, for instance, that a federal statute generally prohibiting appointments to any office or duty of any court of persons within degrees of consanguinity, nice word, to the judges of such court would, if applied to the president, infringe on his power to appoint federal judges, thereby raising serious constitutional questions. So it's viewed such statute as not applying to the president. Likewise, as narrowly construed criminal prohibitions on grassroots lobbying to avoid constitutional issues that would otherwise arise, reasoning that a statute should not be construed to prohibit the president or executive branch officials from engaging in general open dialogue with the public in the administration programs and policies. The government thus broadly agrees that the president's official acts are entitled to some degree of constitutional protection. And with respect to the allegations in the indictment before us, the government agrees that at least some of the alleged conduct involves official acts. Yet the government contends that the president should not be considered immune from prosecution for those official acts. On the government's views, as applied challenges in the course of trial are sufficient to protect the Article 2 interests. And review of the district court's decision on such challenge should be deferred until after trial. Yeah, so is it unconstitutional? Well, an as-applied challenge will be fine, and if he's convicted, he can always appeal. It's like on the basis that it was unconstitutional. Yeah, no, man, that's a little unsatisfactory. It's a little unsatisfactory when it comes to the president. All right. If the president is indeed immune, instead, a district court's denial of immunity would be appealable before trial, because that's how that works. The government asserts that the robust safeguards available in a typical criminal proceeding alleviate the need for a pretrial review. Do they now? Do they? Really? Okay, I'm not sure about that one. First, it points to the Justice Department's longstanding commitment to the impartiality of enforcement of law. Yeah, but this is kind of like you change the fundamental presumption and you somehow think that the thing is going to continue doing the way it always did. So this reminds me a little bit about the housing crash. Okay, of 2008. All right, why did the housing crash occur? Fundamentally, why did it occur? Well, there's a lot of reasons, but here's what I think is the principal reason the housing crash occurred, okay? In the beginning, there were mortgages, and people had mortgages, and people paid their mortgages, and they tended to default at a fairly predictable rate. This was a reasonably tried and true rate that was understandable. And so mortgage-backed securities were, reliable within their bounds, right? They had a predictable failure rate. They gained interest because you're paying interest on the thing, right? So if you bought a mortgage, right, and you got all the interest, then, you're plus all the interest. Hooray for you, right? And if a few mortgages fail, no big deal, because although you're out that money, well, first of all, you're not out all the money because the house itself is security. So you're only out some of the money. And for the rest, you built that into the cost of doing business, and it's fine, right? So this was fine. And then, the market sort of took notice that these things were relatively secure. And it's like, what we need is more mortgages. So it's like, okay, what we're going to do is we're going to give more mortgages along the lines we typically have been doing, but we're going to give more of them. And so they did that for a while, and that was fine for a while. But then basically they ran into a problem. all the people who would traditionally qualify for mortgages had mortgages. So there were no more mortgages to give. We have given all the mortgages and there is no more market. So it's like, okay, what do we need to do? We need to create even more mortgages. All right, how do we do that? What we're going to do is we're going to change the conditions under which people qualify for a mortgage. We're going to change it so that we don't need as much evidence of their income. We don't need as much evidence of their assets. We don't require as much. We're going to grant these mortgages in a posture that this person is less financially secure. And then they somehow assumed that having done that, the mortgage default rate would remain the same. That was the thought. That was the problem. Right? They assumed that having granted mortgages to people who are no longer as financially stable and granting them to people who are less financially stable, the less financially stable people would pay the mortgages at roughly the same rate the financially stable people would, which if you think about it for 5 seconds, you're like, that doesn't make sense. They're less financially stable. There's got to be some negative delta here. But they went on the presumption that there was no negative delta. And then just to make it even worse, then to make it even worse, there was basically a race to the bottom to see who could grant the most unsecure mortgages. So how about like a no income, no asset loan? You know, no income, no job, no asset. What they sometimes called a ninja loan, which I like that. No income, no job, no asset, ninja loan. I like that. So we have no security in this person whatsoever. They have no income, no job, and no assets. And we're going to give this person a mortgage. And surely they're going to pay mortgages, the Barrett mortgage, at the exact same rate as the guy who had a job, an income, and assets. And amazingly enough, this did not work. They changed the fundamental presumption that the whole thing was built on and somehow expected the thing to continue under the same terms. Okay, so this is reminding me of this. This is what the DOJ's argument is reminding me of. The DOJ is like, okay, we have a long-standing commitment to the impartiality of enforcement of law. It's like, okay, assuming that premise to be true, for the sake of argument, assuming that premise to be true, if you got your way and you were able to prosecute presidents now under these much more exciting definitions that you used to, would a future DOJ necessarily be as reserved as the DOJ has historically in the past, having gotten this new exciting power to potentially go after our political rivals? Because we've never done it before. We've never done it before, but now we want to. And now, and we want you to tell us we can. So we want to be able to do what we've never done before, and we want to tell us you can. But don't worry, now that we've never done it before and you've told us we can, don't worry, we'll never abuse it. And you don't have to worry about what's going to happen through future administrations and future DOJs. The same tried and true safeguards will remain in place, and you don't have to worry about it because it's always been true in the past, even though we've changed the fundamental understanding of the thing. This is like some deep bullshit hubris right here. It will surely continue, even though we've changed a fairly fundamental presumption. And like, okay, no, not so much, not so much, not so much, no. It's because the banks used loans that were made up of bad loans. Yeah, but that's what I said. You've just moved it one step. Why were they bad loans? They were bad loans because they were based on bad mortgages. Why were they bad mortgages? Because they weren't based on security. So yeah, you just said the exact same thing I said, except it's one step more abstracted. So your actually doesn't work. Please apologize. Yeah, it was the banks using the shorted loans. Yeah, but why were the loans bad? You're actuallying me in a way. I'm like, you're correcting me, and I'm like, I'm not sure this correction works, guys. So if you want to bail, now would be fine. Yeah. Anyways, pressing on. First, it points to the department's longstanding commitment to impartiality enforcement of the law, as well as the criminal justice system's further protections, grand juries, defense procedural rights during trial, and the requirement the government prove its case beyond a reasonable doubt. Okay. Next, it contends existing principles of statutory construction and as applied constitutional challenges adequately address the separation of powers concerned involving applied generally applicable criminal laws to the present. Finally, the government cites certain defenses that will be available to the president, in particular prosecutions such as a public authority defense or the advice of the attorney general. These safeguards, though important, do not alleviate the need for pretrial review. They fail to adequately address the fact that under our system of separated powers, criminal prohibitions cannot apply to certain presidents' conduct to begin with. As we explained, when the president acts pursuant to his exclusive constitutional powers, Congress cannot, as a structural matter, regulate such actions and the court cannot review them. And he is at least presumptively immune from prosecutions for other official actions. Questions about whether the president may be held liable for particular actions consistent with separation of powers must be addressed at the outset of the proceedings. Even if the president were ultimately found not liable for certain actions, the possibility of extending proceedings alone may render him unduly cautious in the discharge of his duties. Vulnerability to the burden of a trial and the inevitability of the danger of the outcome would dampen and or the ardor of all but the most resolute. The Constitution does not tolerate such impediments to the effective functioning of government. As to the government's assurance that prosecutors and grand juries will not permit political or baseless prosecutions, those assurances are available to every criminal defendant and fail to account for the president's unique position in the constitutional scheme. We do not ordinarily decline to decide significant constitutional questions based on the government's promises of good faith. Nor do we do so today. As for the dissent, they strike a tone of chilling doom that is wholly disproportionate to what the court actually does today, concluding that immunity extends to official discussions between the president and the attorney general, and then remand to the lower court to determine, in the first instance, whether and to what extent Trump remaining alleged conduct is entitled to immunity. The principal's dissent starting premise that unlike the speech and debate clause immunity, no constitutional text supports immunity, is one that the court has rejected decades ago as unpersuasive, although to be fair, they only rejected it in the civil law context. A specific textual basis has not been considered a prerequisite to the requisition of immunity. Nor is that premise correct. True, there is no presidential immunity clause in the Constitution, but there's no separation of powers clause either. Yet the doctrine is undoubtedly carved in the constitutional text by its 3 articles separating powers and vesting the actual power solely in the president. Does this mean President Biden can arrest MAGA? I'll get back to you. Let me say this. It would mean that the president it definitely means the president could ask the DOJ to bring any criminal charge that is even plausible. So it definitely means at least that much. So if he ordered the DOJ to bring charges for whatever, then he probably could. So yeah. Let's press on. And the court's prior decisions, such as Nixon's and Fitzgerald, have long recognized the doctrine as mandating certain presidential privileges and immunities, even though the Constitution contains no explicit provision for immunity. $1.99 from Alleged News says there's also no judicial immunity in the Constitution. I agree. Same kind of problem. Very true. Neither the dissent nor government disavow any of these prior decisions. The principal dissent then cites the Impeachment Judgment Clause, arguing it clearly contemplates a former president may be subject to criminal prosecution. But the clause does not indicate whether a former president may, consistent with the separation of powers, be prosecuted for official conduct in particular. And the assortment of historical sources the principal dissent cites are unhelpful for the same reason. As the court has previously noted, relevant historical evidence on the question of presidential immunity is fragmentary character. Okay. The most compelling arguments, therefore, arise from the Constitution's separation of powers and the judiciary's historic understanding of the doctrine. The court's prior admonition is evident in the principal dissent citations. Some of its cherry-picked sources do not even discuss the president in particular, and none of them indicate whether he may be prosecuted for his official conduct. The principal dissent's most compelling piece of evidence consists of excerpts of Charles Pinckney from an 1800 Senate debate. But those statements reflect only the now discredited argument that any immunity not expressly mentioned in the Constitution must not exist. And Pinckney is not exactly a reliable authority on separation of powers. He went on to state the same day it was wrong to give the nomination of the judges to the president, in an opinion expressly rejected by the framers. Given the framers' desire for an energetic and vigorous president, the principal dissent's view that the Constitution they designed allows all his actions to be subject to prosecution in the exercise of powers it grants exclusively defies credulity. Okay. Thank you for the 883 of you tuning in for this discussion. This is some pretty deep dive constitutional stuff, and I appreciate you coming here as I try to digest all this and figure it out. It's a lot. And I hope my explanations along the way are somewhat helpful. Chuck in Tennessee gives 10 gift memberships. Unable to muster any meaningful textual or historical support, the principal dissent suggests there's established understanding that former presidents are answerable for their official acts. Conspicuously absent is the mention of the fact that since the founding, no president has ever faced criminal charges, let alone for conduct in his office. And accordingly, no court has ever been faced with this question. All that nation's practice established is silence, which, yeah. Coming up short on reasoning, the dissent repeatedly levels variations of accusation the court has rendered the president above the law, which I will contend is a bit of a rhetorical nonsense, to be honest, because the president does have authority that no one else has, and for that matter, so do you. You have authority, for example, to drive your car if you own it, right? You own the car, you have the right to sell it, drive it, lend it out to somebody, right? No one else can do that. You can. You have a power that literally everyone else lacks. You get into your car and drive it away. It's legal. Literally anyone else does it. It might be illegal. So, so to say that you can drive your car, put you above the law would be a bit ridiculous, right? Why is it that I can do it and no one else can? Well, you have unique authority. And in the context of the president, obviously those authorities differ, but same concept. So to say the president it would be like saying the president's above the law because he can grant a pardon. It's like, well, no, that's just a power he has because the Constitution gives it to him. It doesn't put him above the law. So I think saying he's above the law is rhetorically a bit empty. Not a band count gives $1.99. Say, everyone, please like and subscribe to show support. It would be appreciated. Thank you very much. I do my best for you. All right. As before, the rhetorically chilling contention is wholly unjustified. Like everyone else, the president is subject to prosecution in his unofficial capacity. But unlike anyone else, the president is a branch of government and the Constitution vests in him sweeping powers and duties. Accounting for that reality and ensuring the president may exercise those powers forcefully, as the framers anticipate he would, does not place him above the law. It preserves the basic structure. I think that's a better way of looking at it. We can disagree about what it is, but having done it, it is not putting him above the law. It's just giving him what the law demands. So that's fair. All right. The dissent positions in the end boil down to ignoring the Constitution's separation of powers and the court's precedent, and instead fear-mongering on the basis of extreme hypotheticals about a future president feels empowered to violate the law. The dissent overlooks the more likely prospect of an executive branch that cannibalizes itself, with each successive president feeling free to prosecute his predecessors, yet unable to boldly and fearlessly carry out his duties for fear they may be next. Thank you, Caligulov, nice name, for the 5 gift memberships. They are appreciated. I appreciate all your support. We do have some cool merch, by the way. I know it's been a while since we talked about our merch store, but we do have some cool merch, including some Karen Reed stuff. But that CSI sticker is going to be going away real soon. So if you want that CSI sticker, you better get it soon because it's going away. And we have cool mouse pads and cool shirts and other cool stuff. So you should definitely check it out. And I hope you like it. I hope you like the stuff. I think it's pretty cool. I'm getting myself a mouse pad, and I'm pretty excited about it. I'm going to get myself a learning from the misfortune of others. Big ass mouse pad. It's going to be great. All right, where were we? All right, so let's see. All right. For instance, Section 371, which has been charged in this case, is a broadly worded criminal statute that can cover any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of the government. I mean, that's pretty broad. Virtually every president is criticized for insufficiently enforcing some aspect of federal law, such as drug, gun, immigration, or environmental law. An enterprising prosecutor in a new administration may assert that a previous president violated the statute. Without immunity, such types of prosecutions could become routine. The enfeebling of the president and our government that would result from such a cycle of fractional strife is exactly what the founders intended to avoid. I'll be very interested to see if the dissent deals with this parade of horribles in any way other than let's trust the DOJ. I don't know if they have an answer other than let's trust the DOJ. I'm more than happy to hear it, because this is a real concern on the other side. There are problems in giving the president immunity, and there are problems in not giving him immunity. And this concern is real, in my view. And if you need evidence of that, we can point to other countries in the world where this is kind of routine. Even countries that are relatively allies to us, have these problems to some degree. So it's not just the third world countries. There's some first world countries that have problems that are comparable to this. In fact, some states arguably have problems comparable to this, but I digress. Not a banned account says, does this mean impeachment is no longer a remedy? No, this has nothing to do with impeachment. Impeachment is still a remedy. It's just political, not legal. Yeah, impeachment's still a remedy. It's just political, not legal. It has legal implications, but it's not legal in itself. Oh, Alabama Rose gives 20 gift memberships. Thank you very much, Alabama Rose. Which, as I've said before, and I'll say again, by the way, I think that the Constitution allows the House and Senate to impeach and convict for literally any reason they want. And they are not required to give any kind of process to do so. They can do whatever they want at any time they want, with no particular notice, no particular process, no particular right to be heard. Due process is not a thing. They are God. But it's political. So, that's what it is, at least in my humble view. And having done so, well, then there are legal implications, such as you can no longer be in office, you can't hold office in the future, and also we get to prosecute you for all the things. But that's what the Constitution says, so, fine. Thank you, by the way, to our mods. Our mods are fantastic. Thank you, Alabama Rose, for being here. And thank you to all our other mods who help to keep this a nice and friendly place. Alan Parker, I don't know if you have any interest in being a mod because you're here like all the time anyway. But if you do, if you want to contact us on Discord and let us know if you have an interest in potentially modding, let me know, because hey, you're always here anyway, so it's always good to have a potential another set of eyes. So let me know if you're interested in that. But you can't be a mod if it means that you won't donate anymore. because I do appreciate your donations. So you have to keep donating. I love you. All right, where are we? All right. Okay. All right. Ignoring the risks, the dissent are instead content to leave the preservation of our system up to the good faith of prosecutors. Yeah, that's really troubling. That's no good. Finally, the principal dissent finds it troubling the court does not designate any course of conduct alleged in the indictment as private. Despite the unprecedented nature of the case, the significant constitutional questions it raises, the expedited treatment in lower courts and this court, the lack of factual analysis in the lower courts, and lack of briefing, the principal dissent would go ahead and declare all to be unofficial, which is, one hell of a thing to do on first review. The other dissents, meanwhile, analyzed the case under comprehensive models and paradigms of its own concoction and accused the court of providing no meaningful guidance about how to apply the new paradigm or how to categorize the president's conduct, which I wouldn't agree with that. As to official versus unofficial, I think we have some pretty good ideas about what we're looking for. As to having decided it's official, what that means for the presumptive immunity, I tend to agree. It's not quite clear what we mean by that. Yeah. It would have us exhaustively define every application of presidential immunity. Our dissenting colleagues exude an impressive infallibility. While their confidence may be inspiring, the court adheres to time-tested practices instead, deciding what's required to dispose of the case and remanding after reversing on the threshold question. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? Not a Banned account says Manhattan prosecutors just delayed hush money case. Yeah. And the case he's convicted of almost certainly has to be vacated. So his conviction almost certainly has to be vacated because they used a lot of evidence that they're not allowed to use. So the Court of Appeals really should vacate it. Quickly would be helpful. But yeah, they have a real problem. All right. Our nation has never before needed an answer, but in addressing the question today, unlike the political branches and the public at large, we cannot afford to fixate excessively or even primarily on the present issue. That much is for sure true. Please stop looking at the immediate and think a little bit more long-term. Think, people, think. In a case like this one, focusing on the transient results may have profound consequences for the separation of powers and for the future of our republic. Our perspective must be more farsighted, for the peculiar circumstances of the moment may render a measure more or less wise, but cannot render it more or less constitutional. Our first president has such a perspective. In his farewell address, George Washington reminded the nation that a government as much vigor is consistent with the perfect security of liberty is indispensable. A government too feeble to withstand the enterprises of faction, he warned, could lead to the frightening despotism of alternate domination of one faction over another, sharpened by the spirit of revenge. Yeah, that much is true, for sure. And the government powers remained properly distributed and adjusted. It is these enduring principles that guide our decision in this case. The president enjoys no immunity for unofficial acts, and not everything the president does is official. I agree with that. The president is not above the law. I agree with that. But Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. And the system of separated powers designed by the framers has always demanded an energetic, independent executive. The president, therefore, may not be prosecuted for exercising his core constitutional power and is entitled, at a minimum, to presumptive immunity from prosecution for all official acts. That immunity applies equally to all occupants of the official Oval Office, regardless of politics or party. That much is for sure true. The judgment, of course, is therefore reversed. All right, let's turn our attention to the concurring opinions. We are currently on page 52 of 119, so we're about halfway through. Now is a good time to hit that like and subscribe, by the way. If you haven't already, now would be a really good time to subscribe to the channel and like the channel and all the things for the channel. We do appreciate everyone who's done all those things of recent memory. You guys are great. We love you. I was just checking out our exact subscriber numbers so I could give you an exact count, in case you're wondering why I'm stalling for time. The exact count as of right now is 142, 121. Thank you very much to the 142,121 of you who are currently subscribers. You make me happy. 150,000 hopefully in the very near future, which will be very exciting for me. I am thrilled. Good times. Let's do some concurring opinions and dissents. All right. Let's read some more. Few things, Justice Thomas concurring. Few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts. Fortunately, the Constitution does not permit us to chart such a dangerous course. Thank you very much, Mr. E409, for being a member for 16 months. To conclude otherwise would hamstring the vigorous executive that our Constitution envisions. While separation of powers may prevent us from righting every wrong, it does so to do that we do not lose liberty. I write separately to highlight another way in which this prosecution may violate our structure. In this case, the Attorney General purported to appoint a private citizen as special counsel. Really, we're going to do this thing? Okay, fine. But I'm not sure that any office for special counsel has been established by laws the Constitution requires. By requiring that Congress create federal offices by law, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. Okay, I'm not 100% sure that's true, but fine. If there is no law establishing the office the special counsel occupies, then they cannot proceed with the prosecution. A private citizen cannot criminally prosecute anyone, let alone a former president. Okay. No former president has faced criminal prosecution for his acts while in office in more than 200 years. And that is so despite numerous past presidents take actions that many would argue constitute crimes. If this unprecedented prosecution is to proceed, it must be conducted by someone duly authorized to do so by the American people. The lower court should thus answer these essential questions concerning the special counsel's appointment. Okay, sell me. Anna Paraski gives me a pair that's doing a mic drop for $4.99. I like your mic. I like your pair dropping. I like your mic dropping pair. It pleases me. Thank you for the mic dropping pair. I appreciate it. It's awesome. The Constitution sets forth how the office may be created and how it may be filled. The appointment clause provides. Okay, he's going to do some stuff over here. That's fine. The president shall nominate and by the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and other officers of the United States whose appointments are not herein established, provide for, and which shall be established by law. But Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of the department. The constitutional process for filling an office is plain from the text. The default matter for appointing officers of the United States is a nomination by the president and confirmation by the Senate. But the clause provides a limited exception for the appointment of inferior officers. Congress may by law authorize one of three specified people to appoint inferior officers without advice and consent. As relevant here, the head of the department, such as the Attorney General, is one such actor that Congress may appoint by law to appoint inferior officers without confirmation. Before the president or department head can appoint any officer, however, the Constitution requires the underlying office be established by law. The Constitution itself creates some offices, most obviously that of the president and the vice president. Although the Constitution contemplates there will be other officers of the United States whose appointment are not herein provided for, it clearly requires that these offices shall be established by law. And established by law refers to the office that they create by statute. The limitation on the president's power to create offices grew out of the founders' experience in the English monarchy. The king could wield significant power both by creating and filling offices as he saw fit. He was emphatically and truly stylized the fountain of honor. He only appointed the offices, but could create offices. Okay. That ability to create offices raised many concerns about the king's ability to amass too much power. The king could both create a multitude of offices and then fill them with supporters. Okay. In fact, one of the grievances raised by the American colonists in declaring the independence was the king had erected a multitude of new officers and sent hither swarms of officers to harass our people and eat out their substance. Mr. E gives $409 gets $5 to say, for love of the best Supreme Court breakdowns and the most based Justice Clarence Thomas. I'm not sure whether or not he's most based. My favorite justice remains Justice Gorsuch, but we can have our different preferences. But he's doing some like hardcore thinking right now on a question no one's asking, but he's here to write about it anyway, so that's fine. All right. The founders broke from the monarchical model by giving the power of the president to fill officers, but not the power to create offices. They did so by imposing the limitation that a new officer be established by law rather than the king-like custom of the head magistrate unilaterally creating the office. The legislature creates the office, defines the power, limits its duration, and annexes a compensation. The Constitution thus gives Congress broad authority to establish and organize the executive branch. By keeping the ability to create offices out of the president's hands, the founders ensured no president could unilaterally create an army of officers' positions then fill with his supporters. Instead, our Constitution leaves it in the hands of the elected people to determine whether the new offices should exist. Long-standing practice from the founding to today comports with this original understanding that Congress creates offices by law. The first Congress, for example, routinely created offices by statute. Okay, fine. Still today, Congress creates offices the executive branch may fill. For example, Congress has created several offices within the Department of Justice, including the Attorney General, Deputy Attorney General, Assistant Attorney General, Solicitor General, and Assistant Attorneys General. For some agencies, Congress has also granted the agency head the power to appoint such officers and his employees as is necessary to execute the function. In the past, Congress has at times created offices similar to the position now created by special counsel. Congress created an office for special counsel to investigate the Teapot Dome scandal and pursue prosecution. And the statute provided for the appointment of independent counsel that we addressed in Morrison versus Olson, which, although the Supreme Court said it was constitutional, now everyone agrees is unconstitutional. So, everyone agrees it's unconstitutional now, which is pretty funny. That statute has since lapsed. We cannot ignore the importance that the Constitution places on who creates a federal office. To guard against tyranny, the founders required that a federal office be established by law. As James Madison cautioned, if there's any point in which the separation of legislative and executive powers ought to be maintained with greater caution, is that relates to office and officers. If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to create it. Okay. It's difficult to see how the special counsel has an office established by law. When the Attorney General appointed the special counsel, he did not identify a statute that clearly creates the office. Nor did he rely on a statute granting him authority to appoint officers as he deems fit, as heads of other agencies have. Instead, the Attorney General relied on several statutes of general nature. Okay. None of the statutes cited by the Attorney General appears to create an office of the special counsel, and especially not with the clarity of typical statutes. Section 509 and 510 are generic provisions concerning the function of the Attorney General and his ability to delegate authority to any officer, employee, or agency. Okay, Section 512 contemplates an attorney specifically appointed by the Attorney General under law, suggesting that the attorney's office must have already been created by some other law. As for 553, it provides the Attorney General may appoint officials to detect and prosecute crimes against the United States. It's unclear whether an official is equivalent to an officer. Okay. Regardless, the provision would be a curious place for Congress to hide the creation of an office of special counsel. I think Justice Thomas is thinking about this way too hard. The Attorney General has the power to basically create people to do prosecutions. And he just gave it a title. It's like, because it exists outside the normal chain of command. So it's special. I think Justice Thomas is thinking about this too hard. Yeah. To be sure, the court gave passing reference to cite statutes as supporting the appointment of a special prosecutor in U.S. versus Nixon, but provide no analysis of that text. Okay. Perhaps there's an answer for why the statute created an office of special counsel. I'm not sure there is an office of special counsel. I think you're thinking about this too hard. But before the consequence proceeds, we should at least provide a full explanation of why it is. Even if the special counsel has a valid office, questions remain as to whether the Attorney General filled that office in compliance with the appointment clause. For example, it must be determined whether the special counsel is a principal or inferior officer. He's not a principal officer. That's dumb. If the former, its appointment is invalid because it wasn't nominated by the president. Even if it's inferior, the attorney general could appoint him without nomination only if Congress by law vested the appointment in the attorney general. Whether special counsel's office is established by stat law is not a trifling technicality. I think it is a little bit. I think you're thinking about this too hard. Yeah. Given the special counsel's purports to wield executive branch power to prosecute, the consequences are weighty. Our Constitution separates powers, including the separation of powers to create and fill offices, is actually separate guarantee of just government. I think you're thinking about this too hard. The Attorney General clearly has the power to prosecute. And if you let's keep this simple. He's hired someone as an employee and delegated them authority, if you want. Which, yeah, so fine. I think he's thinking about this too hard. In this case, there's been much discussion about ensuring the president is not above the law. But as the court explains, immunity from prosecution for acts is the law. The Constitution provides an energetic executive because the executive is essential to security of liberty. Respecting the protections that the Constitution provides, the office of the presidency secures liberty. In the same vein, the Constitution also secures liberty by securing powers to create and fill offices. And there are serious questions as whether the Attorney General has violated that structure by creating an office of special counsel. You are thinking about this way too hard. These questions must be answered. We must respect the Constitution's separation of powers. You are thinking about this too hard. If the Attorney General has employed someone, he is given proxy power to prosecute, and they're prosecuting basically using the Attorney General's power by proxy. You're thinking about this way too hard. So I'm going to go ahead and disagree with you on that one. There's a reason that he's only writing for himself, I think, Yeah, no, I know. Justice Barrett concurs. For the reason I explained below, I do not join Part 3C of the court's opinion. The remainder of the opinion is consistent with my view. The Constitution prohibits Congress from criminalizing a president's exercise of core Article 2 power and closely related conduct. Then he's not independent? Correct, he's not. Yeah, that was the problem in Morrison versus Olson, and why it's no longer allowed for. Yeah, the problem was the independence. So he's not independent. That's true. He reports to the Attorney General. That's true. So he's not independent. That's true. But he's not. He's not independent. He reports to the Attorney General. So we're good. It's fine. Why do we even bother to confirm the U.S. attorneys that the AG can just hire them as well as inferior officers? Well, because those particular positions have been created by statute. But the statute also gives the Attorney General the power to create other people, which they do. And there's a whole bunch of people within the DOJ who have the authority to prosecute, despite the U.S. attorneys, for a whole bunch of reasons. Usually they do it in concert with the U.S. attorney, but yeah, the U.S. attorneys are there for your typical everyday federal prosecution. But there's other people within the DOJ who have authority to prosecute other than the U.S. attorneys. So, who are not, independent, they just exist. So, yeah, that's why. Statute says those 94 people exist. That's why. So those 94 people exist, and they generally have the power to prosecute crimes in their jurisdiction. But the Attorney General is the boss of them all. So the Attorney General can come in and usurp them. That isn't typically what happens, but it can happen because he's the boss. So that would be why. Moving on. Yeah. Jack keeps saying he's independent. He's not. He can keep saying it, but he's not. Yeah. All right. Anyways, Justice Barrett writing. That said, I would have framed the underlying legal issue differently. The court describes the president's continuing constitutional protection from certain prosecutions as an immunity. As I see it, the term is shorthand for two propositions. The president can challenge the constitutionality of a criminal statute as applied to the official acts alleged in the indictment and can obtain interlocutory review of the trial court's ruling. There appears to be substantial agreement on the first point. Like the court, the dissenting justices and special counsel all accept that some prosecutions of the president's official conduct may be unconstitutional. As for interlocutory review, our precedent recognizes that resolving certain legal issues before trial is necessary to safeguard important constitutional interests. Properly conceived, the president's constitutional protection from prosecution is narrow. The court leaves open the possibility that the Constitution forbids protecting the president for any official conduct, instructing lower courts to address that question in the first instance. I would have addressed it now. Though I agree the president cannot be held criminally liable for conduct within his conclusive and preclusive authority and closely related acts, the Constitution does not vest every exercise of executive power in the president's sole discretion. Congress has concurrent authority over many functions, and it may sometimes use that authority to regulate the president's official conduct, including by criminal statute. Article 2 poses no barrier to prosecution in such a case. I would thus assess the validity of the criminal charges predicated on most official acts, those falling outside the president's core function, in two steps. The first question is whether the relevant criminal statute reaches the president's conduct. Not every broadly worded statute does. For example, 956 covers conspiracy to murder in a foreign country and does not expressly exclude the president's decision to say, order a hostage rescue mission abroad. The underlying murder statute, however, covers only unlawful killings. The Office of the Legal Counsel has interpreted the phrase to reflect a public authority exception for official acts involving the military and law enforcement. Okay. I expressed no view about the merits of this interpretation, but it shows that the threshold question of statutory interpretation is a non-trivial step. If the statute covers the alleged conduct, the prosecution may proceed only if applying it in the circumstances poses no danger to the intrusion of the authority in the executive branch. Or the lower court will have to apply that standard to various allegations involving the president's official conduct. Some of those allegations raise unsettled questions about the scope of Article 2 power, but others do not. For example, the indictment alleges that President asked the Arizona House Speaker to call legislative into session to hold a hearing about the fraud claims. The president has no authority over state legislatures or their leadership, so it's hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on his power. The two-step analysis, considering first whether the statute applies and then whether the application to the particular facts is constitutional, is similar to the approach the special counsel presses to the court. It is also our usual approach for considering the validity of statutes in situations raising constitutional questions. An important difference in this context is the president is entitled to an interlocutory appeal of the trial court's ruling. A criminal defendant in federal court normally would have to wait until after trial to seek review. But where the trial itself threatens certain constitutional interests, we have treated the trial court's resolution as a final decision for the purpose of appellate jurisdiction. Okay, fair enough. So she wants to say it's not immunity. The question is whether or not it's constitutional, and she wants to give it interlocutory review, which is arguably a better way about about the problem. So I think this might be a better approach. So like, okay, we're going to say it's not immunity. We're just going to say it's constitutional, but we'll give you interlocutory review because this is positive. I'm like, okay, that makes sense. I think that might be a better approach. So she has some points. The present circumstances fall squarely within our precedent authorizing an interlocutory review. When a president moves to dismiss an indictment on Article 2 grounds, he makes no challenge whatsoever to the merits. He instead contests whether the Constitution allows Congress to criminalize the conduct, a question that's collateral to and separable from his guilt or innocence. Moreover, the president's executive branch authority would be significantly undermined if appellate review of the constitutional challenge were postponed until after conviction or sentence. The prospect of a trial court erroneously allowing the prosecution to proceed poses a unique danger to the independence of the executive. As the court explains, the possibility that the president will be made to defend his official conduct before a jury after he leaves office could distort his decisions while in office. Those Article 2 concerns do not insulate the president from prosecution, but they do justify interlocutory review. Okay, I mean, this might be a better way to go about it. This might be a superior way to go about it. It's like it may or may not wind up in the same place. She does construe official acts a bit, well, maybe more than a bit, but she construes it more narrowly, which is arguably correct. And she says, rather than immunity, we should view it as a constitutional challenge. And we should say that in this context, that gives you interlocutory review, which basically gets you presumably to a same or at least similar place. I think I might prefer this approach. I think I might prefer this approach. Yeah. But okay. I understand most of the court's opinion to be consistent with this view. I do not join Part 3C, however, which holds the Constitution limits the introduction of protected conduct as evidence. Okay, that's a pretty sharp change. That's a pretty sharp change from the majority opinion. I do not join Part 3C, however, which holds the Constitution limits the introduction of protected conduct as evidence in a criminal prosecution as present beyond the limits afforded by executive privilege. I disagree with that holding on the score, and I agree with the dissent on that score. The Constitution does not require blinding juries to circumstances surrounding conduct for which he can be held liable. Consider a bribery prosecution, a charge not at issue here, but one that provides a useful example, which I've already sort of illustrated that when we discussed it. The federal bribery statute forbids any public official from seeking or accepting a thing because of an official act. The Constitution, of course, does not authorize the president to seek or accept bribes, so the president may prosecute him if he does. Yet, excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of the charge alleging a quid pro quo, the jury must be allowed to hear both about the quid and the quo, even if the quo standing alone could not be the basis for liability. Yeah, I understand, and I think I at least partially agree with this concern. Maybe if it's like a necessary element, maybe that's in the exception. So, not if it's evidence, but if it's a necessary element, maybe that's how we square the circle. But she has a point. Okay. I appreciate the court's concern that allowing evidence of official acts to which the president cannot be held liable may prejudice the jury. But the rules of evidence are equipped to handle that concern on a case-by-case basis. Ooh, I don't know about that one. That's she's presumably trying to think about Rule 403, substantially more prejudicial than probative, I guess. I don't know about that one, Amy. I'm not sure about that one, with all due respect. That's a lot. Yeah, more importantly, a trial court can exclude evidence if its probative value is prejudicial. See Rule 403. See, I said that. I said that too. Can presidents still prosecute each other's families? Yes, because they're not the president, so that's no problem. Yeah, that's fine. This only applies to the president. The president's family are not the president, so that's fair. The balance is more likely to favor admitting evidence of an official act in a bribery prosecution, for instance, than one in which the protected conduct has little connection. Well, I would be a little bit stronger here if I were inclined to agree with Amy on this one, or Justice Barrett, I should say. Calling her Amy is a bit disrespectful. If I were inclined to agree with Justice Barrett on this one, I would say, no, the standard rules of evidence aren't enough. I would say that you could only do it if it were necessary, as opposed to merely evidence. So if it were necessary, because, for example, in the bribery statute, you have to be able to do it because it's necessary to prove the charge. So you have to show the official act as part of the bribe. So it would be necessary. So I would say if it's necessary, then yes. But if it's only evidence, then no. But she wants to rely on this, on the rules of evidence in a more general way, which is not enough for my taste. So I think she's right on the other thing, but not so much on this. No, I don't agree about that. Okay. The Constitution does not insulate presidents from criminal liability for official acts, but any statute regulating the exercise of executive power is still subject to a constitutional challenge. A criminal statute is no exception. Thus, a president facing prosecution may challenge the constitutionality of the act. If the challenge fails, he may face trial. So I think I agree. I agree with her alternate approach. And I think I even agree with her tighter drawing of the line. But I disagree with allowing it in as a general evidence. So I can't go that far. That's where I'm out. All right, so let's see if the dissent can persuade me that the majority is in error. All right, let's get started with the dissent and see where we end up. Can I do timestamps in some way? There's some way for me to do a timestamp. I can do a stream marker. It's a little late, but okay, I added a marker. At least they'll give me a clue where to look to potentially add a timestamp. I need to remember that marker thing exists so that I can do that on a more frequent basis. That'd be good. All right, where were we? Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle, foundation to our Constitution, that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Well, not quite, but okay. Because our Constitution does not shield the president from answering for the criminal and treasonous acts, I dissent. Well, treasonous is a really strong word since he wasn't charged with treason, but okay. The indictment paints a stark picture of a president desperate to stay in power. In the weeks leading up to January 6, 2021, then President Trump allegedly spread lies that there had been outcome-determined fraud in the election and he'd actually won. When dozens of courts swiftly rejected the claims, Trump allegedly pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, and ultimately cause the ascertainment of and voting by illegitimate electors, which that much was probably legal at the time, to be honest, because the states could do that. They changed it in the Electoral Count Act revisions, but at the time, it's probably illegal. It's alleged he went so far as to threaten one state official with criminal prosecution if he did not find the votes. Well, that's less legal. When state officials repeatedly declined to act outside their legal authority and alter the state elections, Trump and his co-conspirators purportedly developed a plan to disrupt and displace the legitimate election by organizing fraudulent slate of electors. As the date of the certification process neared, Trump allegedly also sought to use the power and authority of the Justice Department to bolster his knowingly false claims of election fraud by initiating a sham election criminal investigation and sending official letters falsely claiming the Justice Department had identified significant concerns that may have impacted the election outcome, while falsely presenting the fraudulent electors as valid alternatives to the legitimate electors. When the department refused to do as he asked, Trump turned to the vice president. Initially, he sought to persuade the vice president to use his ceremonial role at January 6 to fraudulently alter the election result. When the persuasion failed, he attempted to use the crowd of supporters that had gathered in Washington, D.C. to pressure the vice president to fraudulently alter the vice president, which might be legal, of course, because it's generally speaking legal to, say that, never mind. Were January 6th charged with insurrection? No, none of them were. None of them were charged with insurrection. But Biden presumably could order the AG to do it if he wanted to. I think you probably could charge some people with insurrection if you really wanted to. The statute's kind of broad. So if you really but no one was charged. That's true. The worst crime anyone was charged with was conspiracy for sedition, which of course the Proud Boys were convicted of. But that was the most severe charge. Well, yeah, that was the most severe charge. So yeah. I was trying to think if there's anything else, but no. Anyways, speaking to the crowd of January 6th, Trump falsely claimed that based on fraud, the vice president could alter the outcome. When the crowd then violently attacked the Capitol, Trump allegedly delayed in taking any step, which doesn't necessarily mean that's a crime. Instead, as a last desperate ploy to hold on to power, he allegedly attempted to exploit the violence in Capitol by pressuring lawmakers to delay the certification and ultimately declare him the winner. That is the backdrop on which this case comes to court. The court now confronts the question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should and invents an atextual, ahistorical, and unjustifiable immunity that places the president above the law. The majority makes three moves that, in effect, completely insulate the president from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority attempts to apply it to facts, expands the concept of core power beyond any recognizable bound. In any event, it's quickly eclipsed by the second move, which is create an expansive immunity for all official acts. Whether described as presumptive or absolute under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. Which, we don't typically look to motives in a law enforcement setting, so that's fair. Where was I? This is just as bad as it sounds, and it's baseless. Finally, the majority declares the evidence contains acts for which the president is immune, can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent, is nonsensical. Augmented by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text, history, and established under president's roles. Moreover, it's deeply wrong even so under its own factualist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary holding is unprecedented. Well, that much I think is true. I think it is unprecedented, but that doesn't necessarily mean it's wrong, because sometimes something's new, like this situation. But it is unprecedented. I think that's possible. Finally, this majority's project will have a disastrous consequence for the president and our democracy. The main takeaways of today's decision is all of the president's official acts, defined without regard to motive or intent, are entitled to immunity that's at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptively, cannot touch him. This official act immunity has no firm grounding in text, history, or precedent. Indeed, those standards, grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly undefensible. The majority calls for a careful assessment of the scope of the president's power under the Constitution. For that majority, the careful assessment does not involve the constitutional text. Well, I mean, they kind of talked about it a little bit. I would start there, which is a good place to start, to her credit. The Constitution text contains no provision for immunity from criminal prosecution for former presidents. Of course, the silence of the Constitution on this score is not dispositive. Insofar as the majority rails against the notion that a specific textual basis is required, is it attacking an argument that's not been made. The omission of the text is worth noting, however, for at least three reasons. First, the framers clearly know how to provide for immunity. They did provide for narrow immunity for the speech and debate clause. They did not extend the same immunity to the president. Fair. Second, some states' constitutions at the time of the framing specifically provided for express immunity to sitting governors. The framers chose not to include similar language in the Constitution to immunize the president. If the framers had wanted to create some constitutional privilege to shield the president, they could have done so. Fair. Third, insofar as the Constitution does speak to the question, actually contemplates some form of liability, the majority correctly rejects Trump's argument that a former president cannot be prosecuted unless he's been impeached. I agree that that's correct to reject that. The majority ignores, however, that the impeachment judgment clause counts against its own proposition. The clause presumes the availability of criminal process as a backstop by establishing the official impeachment and conviction shall nevertheless be liable. I don't know. I think it's putting too much emphasis on the word nevertheless, but okay. How does immunity compare with judicial immunity? It compares very well and arguably should apply the same way, right? Because it has long been understood, at least I understood, that judges were absolutely immune for their official acts. Now, there is a separation here because, for example, in the case of a bribe, we have prosecuted judges for that in the past and should. And because I would say the bribe is not an official act. And, well, the bribe for what? The bribe for the decision. So in that case, the evidence of the decision would be a evidence that would be necessary. So the majority's opinion appears to exclude that possibility, which seems a bit questionable. And so Justice Barrett's opinion goes too far the other direction, I think. But I would say if it's a necessary element, at least, it should be offered as evidence. So yes, there is absolute immunity, and prosecutors for that matter, as long as they're acting within their prosecutorial function. So prosecutors have absolute immunity within their prosecutorial function. Judges have absolute immunity within their judicial functions. So the concept of absolute immunity is not unheard of. And prosecutors, of course, are executive branch officials. So there's that. So you're not wrong for raising the question. Let's see, where were we? The clause clearly contemplates a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted from an inquiry, which implicates official acts almost by definition. Yeah, I mean, insofar as the impeachment clause goes, I would tend to agree with you. If the majority opinion is understood as impacting the impeachment clause in any way, I would not agree. So I think the impeachment clause continues to be, and I think that if having been successfully impeached, I think that everything's off the menu. So in that hypothetical, I think you could impeach, you could convict, you could charge the president with anything you want if he's impeached and removed. So yeah. Aware of its lack of textual support, the majority points out the court has recognized presidential immunities and privileges rooted in constitutional tradition of separation of powers and supported by history. That's true as far as it goes. Nothing in our history, however, supports the majority's entirely novel immunity from criminal prosecution for official acts. There's a footnote in the majority opinion allowing evidence in a bribe case. Oh, okay. Then that makes me feel better. So let's see. I'm on page 73. So I'll make a note to myself. 73. Let's see if we can go chase the footnote down. Justice Thomas has a footnote on the whole employee thing. Although a government official may also be a non-officer employee, I set that aside because it's difficult to see how an official exercising the Department of Justice's duties to enforce criminal law by leading a prosecution could be anything other than an officer. What the hell are you talking about? If the special counsel were a non-officer employee, the constitutional problems with its prosecution would only be more serious. What the hell are you talking about? I disagree fundamentally. No. There are a lot of people who prosecute that aren't officers. The U.S. attorney is not the only attorney in the federal districts. He's the U.S. attorney. They have lots of attorneys working for them. They're not officers either. What the hell are you talking about? They operate under the U.S. Attorney's Authority, which operates under the Attorney General's authority. What the hell are you talking about? Okay, never mind. That's some dumb. I don't agree with that at all. All right, let's see. Justice Barrett disagrees, arguing that in a bribery prosecution, for instance, any mention of the official act associated with the bribe would hamstring the prosecution. But of course, the prosecution may point to the public record to show the fact the prosecution performed the act. And the prosecutor may admit evidence of what the president allegedly demanded, received, accepted, or agreed to in return for this act. What the prosecutor may not do, however, is admit testimony or private records of the president or his advisors probing the official act itself. Okay. Allowing that sort of evidence would invite the jury to inspect the president's motivations for his official actions and second guess their propriety. As we explained, such an inspection would be highly intrusive. I'm not really feeling that much better by the footnote. The footnote doesn't make me feel all warm and fuzzy inside. I appreciate the majority's attempt to get around the problem, but I'm not sure that they satisfy my problem. Economath for $5 say, lol. She said presidential immunity is in the Constitution, but neither is judicial immunity. True. Al Janu says, where's judicial immunity found in the Constitution? It's not. So presumably Sonia Sotomayor believes that she can be prosecuted for her official acts. I guess. For her official acts, mind you. Not in connection with an illegal act, but just the official act itself. She could be prosecuted, apparently. Which is a hell of a thing, but that's apparently what Justice Sonia Sotomayor apparently believes. Turning my attention back to page 73, where we left the action. Is special counsel also an officer of the court? Yes. He's an attorney. Yeah, he's an attorney. Yeah, so he's an officer of the court too. But that doesn't count for the purposes of our discussion. I'm an officer. I'm not an officer within the meaning of the Constitution. That's not what we're talking about. But yes, he's an attorney. All right, let's see. Okay. Aware of the lack of textual support, the majority points out this court has recognized presidential immunities and privileges are rooted in the constitutional tradition of separation of powers and supported by history. That's true as far as it goes. Okay. Nothing in our history, however, supports the majority's entire novel immunity from criminal prosecutions for official acts. Okay. The historical evidence that exists on presidential immunity from criminal prosecution cuts decisively against it. For example, Alexander Hamilton wrote that the former president would be liable to prosecution and punishment in the ordinary course of law. For Hamilton, it was an important distinction between the King of Great Britain, who was sacred and inviolable, although, see Cromwell for a discussion on that issue, and the President of the United States would be amenable to personal punishment and disgrace. In contrast to the king, the president should be subject to the personal responsibility for his actions, standing upon no better ground than the governor of New York, and upon worse ground than the governors of Maryland and Delaware, who gave them some immunity. At the Constitutional Convention, James Madison, who was aware that some states' constitutions provide governors immunities, proposed that the convention consider what privileges ought to be allowed by the executive. There's no record of any such discussion. Delegate Charles Pinckney later explained that the convention which formed the Constitution knew well that no subject had been more abused than privilege, and so it was determined to limit privilege to what was necessary. You just said there was no discussion, though, just 5 seconds ago. You just said there was no discussion, and now you're quoting somebody. Is that part of the discussion that doesn't exist? All right, all right, never mind. Other commentators around the time of the founding observed that federal officials have no immunity from prosecution, drawing no exemption for the president. James Wilson recognized that federal officials who use their official powers to commit crimes may be tried by their country. If their criminality is established, the law will punish. A grand jury may present a petty jury. A petty jury may convict. Okay. Petty. And that's an alternative spelling, I guess. That's all right. Petty jury. All right, fine. It just threw me for a loop. I'm sorry. And judges will pronounce the punishment. A few decades later, Justice Story evinced the same understanding. He explained that when a federal official commits a crime in office, it is indispensable that the provision should be made the common tribunal of justice should be at liberty to interchange jurisdiction of the offense. For the purpose of inflicting the common punishment applicable to unofficial offenders. All right. Without a criminal trial, he explained the grossest official offenders might escape without any substantial punishment, even for crimes that would subject their fellow citizens to capital punishment. The historical evidence reinforces that from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. Okay. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity. With nothing on its side of the ledger, the most majority can do is claim that historical evidence is awash. Okay. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary. Moreover, far from dismissing that evidence as irrelevant, the Fitzgerald court was careful to note the best historical evidence clearly supported the immunity from damages liability that is recognized and relied in part on the historical evidence to overcome the lack of any textual basis for immunity. The majority ignores this reliance. How? Let me reread that because I'm not sure I understood it. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary. Okay. Moreover, far from dismissing that evidence as irrelevant, the Fitzgerald court was careful to note the best historical evidence clearly supported the immunity from damages liability that it recognized and relied in part on that historical evidence to overcome the lack of any textual support for the immunity. The majority ignores this reliance. What are you talking about? I don't understand. I honestly don't understand what she means. Do I have to read it a third time? It claims that the court previously has described the relevant historical evidence on the question of presidential immunity as fragmentary and not worthy of consideration. Okay. Yet the court has described only that evidence. Did the majority actually say it wasn't worth consideration? Is that what the majority said? I mean, I just read a majority opinion not that long ago. Did the majority say that it wasn't worthy of consideration? I don't think that's what the majority said. Is she setting up a straw man here? I think that she might be setting up a straw man. What is she talking about? I'm confused and grumpy. Moreover, far from dismissing the evidence as irrelevant, the Fitzgerald court was careful to note the best historical evidence clearly supported the immunity from damages liability that it recognized and relied in part on the historical evidence to overcome the lack of textual basis. The majority ignores this reliance. But if they had taken note of the reliance, it would have helped them, not hurt them. She gave page numbers. Okay. Yeah, fair enough. 38 and 39. All right, let's go back to 38 and 39, I guess, because you lost me. All right, we're back on we're on page 75. Let's go back to page 38. This is 38 as marked, so I have to go find it. All right, 38. As marked, as you can kindly see in the upper left page. All right. Okay, blah, blah, blah. All right. The principal dissent then cites the impeachment judgment clause, arguing it clearly contemplates a former president may be subject to criminal prosecution. But the clause does not indicate whether a former president may, consistent with separation of powers, be prosecuted for his official acts in particular. And the assortment of historical sources the principal cites are unhelpful for the same reason. As the court has previously noted, the relevant historical evidence is fragmentary in character. Yeah. The most compelling arguments, therefore, arise from the Constitution's separation of powers and the judicial understanding of that doctrine. What are you talking about, Justice Sotomayor? They seem to be saying the exact same thing you're saying. They didn't ignore it. They said the exact same thing. They're saying, okay, so you said the precedent says it's fragmentary. And they're saying it's fragmentary. So it's not particularly helpful. They're not ignoring it. They're just like, it doesn't help very much. Sonia Sotomayor has set up a straw man, and I'm irritated. The court's prior admonition is evidence of principal dissent. Some of the cherry-picked sources do not support the president in particular. And none of them indicate whether they may be prosecuted. The most compelling piece of evidence exists from this one guy, blah, 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 blah. So Justice Sonia Sotomayor has straw man the majority. Yeah. It claims the court previously described the relevant history as fragmentary and not worthy of consideration. Well, that's not what they said. That's not what they said. They just said it was fragmentary. And then in the case you cite Fitzgerald. It's like, okay, they said that it was, Fitzgerald said the best history clearly supports immunity from damage liability and relied on part of the evidence to overcome the lack of textual basis. So not only did they consider it, but if they had considered it along the way that you suggested, it would help them, not hurt them. So you're wrong twice. Because, first of all, they did consider it. And if they considered it the same way Fitzgerald did, would apparently be to say, as Fitzgerald did, quote, the best historical evidence clearly supports the immunity. And so if they had relied on that, it would help their case, not hurt them. So I don't know what you're talking about on any level. You've completely confused me. Now, it's true they were only talking about civil liability, but that wasn't your argument, right? You didn't be like, well, they're only talking about civil liability, and that shouldn't be understood to be reading on the criminal law, right? You just like, oh, it's fragmentary, and they said, well, the best history says there should be immunity, and they didn't consider that. I'm pretty sure they did, and they kind of relied on that, at least partially. Now, you could say they shouldn't rely on that because it's civil, but you're saying they didn't rely on that, which they did. So you're wrong 3 times. You're wrong that they didn't rely on it. You're wrong that they didn't rely on it for exactly what it said. And you're wrong on it that it doesn't strengthen their case unless you make the argument that it's civil, not criminal, which you didn't. So you're wrong 3 times in the space of a paragraph. That's great. Just fantastic news. Our country's history also points to established understanding, shared by both presidents and the Justice Department, that former presidents are answerable to the criminal law. Long settled and established practice. What are you doing? This doesn't make any sense either. This citation doesn't work. She says our country, we're wrong again, and we're in the next paragraph. We made it literally to the next paragraph. We made literally to the first sentence in the next paragraph, and she's wrong again. Help me. Okay. She says our country's history also points to an established understanding shared by both presidents and the Justice Department that former presidents are answerable to the criminal law. See, by comparison, this case. Long settled and established practice may have great weight in proper interpretation of the procedures. What's the problem? There is no practice when it comes to prosecuting the president. You say our history points to an established understanding that presidents are answerable, and the way that our history does that is by long settled and established practice that gives great weight in proper interpretation of the provision. What practice? What practice are you referring to when it comes to the president? What are you talking about? And she's not saying, by the way, that this is just generally true of criminal law in general, where she could be like, in criminal law in general, we have a long standing practice, and so we can read the president onto that. She's not saying that. She's saying specifically, it points to established understanding shared by the president that former presidents specifically are answerable by the historical practice of prosecuting the presidents, which has never happened. Uncivil is frustrated. You were doing okay up till now, and now Uncivil's mad. Consider Watergate, for example. I'm considering it in my head as we speak. I don't know how it helps. After the Watergate tapes revealed Nixon's misuse of official power to obstruct the FBI, Ford pardoned Nixon. Okay. Both Ford's pardon and Nixon acceptance of the pardon necessarily rest on the understanding they face potential liability. No, I'm not sure it does. I'm not sure it does. I think it could just be understood as trying to moot the issue. Like, there might be some problem, maybe, and maybe we can just moot the issue so we can all move along with our lives. So I'm not sure either granting the pardon nor the receipt of the pardon is an understanding, oh yeah, this criminal prosecution is totally going forward. Totes. First of all right. First of all, Nixon was about 5 steps from being impeached at best. And if he had been impeached, this all doesn't matter anyway. And so I don't know. I don't know what we're talking about. It doesn't matter. Okay. And even assuming that had been the understanding, which I don't think it is, but even assuming it was the understanding between Ford and Nixon, which is one hell of an assumption, that somehow is the understanding of the presidents in a collective sense, or the Department of Justice in a collective sense, is one hell of a reach. As opposed to, here is a politically expedient thing I can do to make the problem go away. Here's a magic button I can push that just makes the whole thing go away. And so no one has to figure it out. I think the magic button interpretation is a much better interpretation. Rather than, geez, I'm totally going to be indicted tomorrow. Yeah, this will get you off the hook. I think more like, let's just make the whole thing disappear is a much more interesting, much more correct interpretation. But, fine, sure. They thought that, okay, whatever. Whatever. Subsequent special counsel and independent counsel investigations have also operated on the assumption the government can criminally prosecute former presidents for their official acts when they violate the law. Okay. Citing something in Iran-Contra. Because a president, and certainly a past president, is subject to prosecution, the conduct of the president was reviewed by independent counsel against applicable statutes. It was concluded that his conduct fell well short of criminality, which could be successfully prosecuted. So you have one guy who's like, you know what? I think he can be prosecuted. Yeah, I don't know about that one. Indeed, Trump's own lawyers during the second impeachment assured senators that declined to impeach him for his conduct in January 6th would not put him in any way above the law. They insisted that the former president is like any other citizen and can be tried in a court of law. Well, I guess they were wrong. That's a legal argument, by the way. If every attorney's legal arguments were binding, then we wouldn't need courts anymore because we just say things and then they magically be true. That'd be neat. I'm an attorney. So using my powers of attorney, which apparently I have, I'd like to announce that is my official legal opinion that I cannot be prosecuted for any crime, whether federal or state. I feel reassured by my new grant of immunity to myself. That was fun and exciting. If my colleagues on the other side of the chamber actually think President Trump committed a criminal offense after he's out of office, you can go and arrest him. Now he's facing criminal charges, though the tune has changed. Being treated like other Sinians no longer seems appealing. He has different lawyers making different arguments. Wow, amazing. Wow. It's almost like, hear me out, guys. I know this is going to be really hard to deal with, but let me help you out. It's almost like his attorneys that were arguing in the impeachment made arguments they thought would assist their clients with respect to that proceeding. And it's almost like his attorneys with respect to this case are making arguments on behalf of their client they think will help him with respect to this proceeding. Also, by the way, as long as I'm here, just to put that extra schnell on the whole thing, federal law allows for mutually inconsistent pleading. Federal law allows for mutually inconsistent pleading. So not only is it different attorneys in different cases, one of which is political and one of which is legal, but even if it were literally the exact same attorney in literally the exact same court, the attorney can argue A and not A at the same time. So I'm just saying This is a really weird argument when it comes to federal law, because federal law allows for mutually inconsistent pleading. You don't even have to be consistent with yourself at the same time. This is also incidentally why federal law tolerates mutually inconsistent verdicts, as long as we're here to learn something. Because federal law allow for the tension. They just don't care. The attorney can argue A and not A, and the jury can find A and not A, and it's correct. So the federal law allows for mutually inconsistent pleading. They allow for mutually inconsistent verdicts. The jury said A happened and also said A didn't happen. Well, I guess it happened and it didn't happen. How can both those things be true at the same time? Because, well, that's just what we allow for. We allow for the logical inconsistency. That's just the federal law. Deal. Moving on. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers until now. Settled understanding of the Constitution are little use to the majority and so ignores them. I don't know that's true. To the extent there is any precedent, which I will agree with you, is principally only in the civil domain, and I will certainly agree with you that criminal law and civil law need not read onto each other and can at times be wildly inconsistent with each other, although probably less than most people would give credit for. They're more consistent in my view than inconsistent, but a different attorney might have a different opinion about that. But there's no particular reason they have to be consistent with each other. But it's also like there's no particular reason they can't be consistent with each other, which at least in my mind is more often true than not. It's more often true that the criminal law is consistent with the civil law, at least in a broad concept, right? I mean, we're obviously having to use like a more, a broader filter. We can't, get the microscope out. We're looking at this from a higher elevation, but, in a broad sense, they are more similar than different. So there's that. But like, it's all you have. It's all you have. All you have is the civil law precedent. It's all you've got. So you could say, fuck it. None of that's any good. And you could go in a completely different direction. But first of all, you don't have particularly great reasons to do it. Dissent. You can just make the best argument for the dissent, if you want to be intellectually honest, is that this is just a case of first impression. And that all the precedent that exists is really in the civil law context and none of it's any good. And therefore we're operating on novel ground. And therefore we have to make up an answer. And we're just going to make up an answer, and the answer is there's liability, which at least at that point is consistent with the criminal law in a general sense. So it's like, okay, there is no precedent. There is no precedent. We have to make up something. Generally speaking, people are held liable to the criminal law. Therefore, you're held liable to the criminal law because we don't have a really good reason to not do it. And that would be a more intellectually consistent argument than whatever this is. But they're over here trying to argue like there's this huge history and tradition based on literally not much. And also that it's inconsistent with the precedent, which to the extent you ignore the fact that there's the distinction, it is consistent with the precedent. So there is a more intellectually honest way to do it. It's a bit unsatisfying. It's a little unsatisfying because you're not operating on anything, but at least you're being honest about it. It's like, well, I don't have anything, so I got to make something up. Criminal law is generally a thing. There's no particular reason to give him immunity. Everyone else is criminally liable, so why not him too? End of discussion. That would be a more intellectually honest way to do this than whatever this is. I'm not a happy camper. Setting aside the evidence, the majority announces that former presidents are absolutely, at least presumptively, immune. The majority purports to keep us into suspense as whether this immunity is absolute or presumptive, but quickly gives up the game. It explains that at a minimum, the president must be immune from prosecution or official act unless the government can show that applying the criminal prosecution act would pose, and she puts in italics, no danger of intrusion on the authority of the inventor. None, no dangers, none at all. Now, I will agree with her that this is certainly a way to read this, and maybe even the most faithful way to read it. But I'm not sure it necessarily, strictly speaking, has to be read that way. You could read it as more, you could read it as not necessarily suggesting the narrowness that it does. You could just suggest it as more, as stronger language than really was. There's even valid ways to interpret this and being like, well, what does it mean to pose a danger? What does that mean to pose a danger? And that's open to some interpretation, right? So her reading is potentially correct. And I will fault her that the majority doesn't give any guidance on how to do this, which is very annoying. So I'll agree with her on that much. So +1 for you. So she says no danger, none at all, which is a way to read it. It's hard to imagine a criminal prosecution for president's official action that would pose no danger to the intrusion of the president, although the majority seem to suggest as much and even give examples of how they think that that might manifest. So I'm not even sure that that's necessarily a faithful reading, but okay. Nor should that be the standard. Surely some intrusion on the executive may be justified with an overriding need to promote objectivity within the things. Other intrusions may be justified by the principal constitutional duty to do justice. Okay. I suppose fair enough, but you're running into the same problem and arguably worse than the majority does. So you're like, you know what, the majority's language could be read for this really expansive possibility. And I think there should be some intrusions. Okay. You think there should be some intrusions. Can you help me figure out what that means? And apparently her answer to that question is the incredibly helpful. Some intrusions may be justified by an overriding need to promote objectives within the authority of Congress, and other intrusions may be justified by the duty of the judicial branch to do justice. Which sounds incredibly broad. Which I suppose is exactly what you're going for, but don't call it some intrusion. As like, oh, it's only some intrusion. What is the intrusion? Well, the duty of the Justice Department to do justice. That's the minor intrusion we're talking about. Don't tell me just the tip and then shove the whole thing. That is not what we agreed to, man. No deal. Miriam Scott Goddard becoming uncivilian. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in a criminal proceeding. According to the majority, any intrusion is too much. Well, you're arguing for basically all the intrusion. So that's okay. When a presumptive immunity is this conclusive, the majority's indecision as to whether the immunity must be absolute or was presumptive hardly matters. Okay, fair. Maybe some future opinion of this court will decide that presumptive immunity is sufficient and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute meaningful. I agree that there's a way to interpret this that makes it less meaningful than, I'm not sure whether or not that's what they have in mind or not. But okay. Today's court, however, has replaced the presumption of equality with the presumption that they're above the law for all the official acts. I don't like that rhetorical turn of phrase. I don't think it's a very good way of phrasing the problem. To put him above the law. I don't like that rhetorical phrasing. It's not doing it for me. Quick on the heels of announcing this astonishingly broad act of official immunity, a majority assures us a former president can be prosecuted for unofficial acts. Of course he can. No one questioned the ability to prosecute a former president for unofficial, otherwise known as private acts. Yeah, but the majority wanted to make it clear. So, why are you giving them a hard time for saying the thing? Why are you giving them a hard time for clarifying it? I mean, they didn't have to, but it was kind of nice they did just to make sure. I mean, strictly speaking, I suppose it's dicta, but it's nice that they said it just to like avoid the ambiguity. So why are you giving them a hard time? This unremarkable proposition is no limit. It does not hide the majority's embrace of most far-reaching. You're giving them a hard time for clarifying something. I agree that no one was contesting it, but just to clarify for the future, you're giving them a hard time, man. That's not nice. In fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial to almost a nullity. It says that whenever the president acts in a way that's not manifestly or palpably beyond his authority, he's taking official action. It then goes a step further. In dividing official from unofficial, courts may not inquire into motives, which is not like unheard of. And also, generally speaking, is not an element of the crime. It's not an element of the crime. Also worth noting. Motive is nice, but it's not required in any criminal prosecution except for hate crimes, which incidentally was one of the reasons that the attorneys were a little bit upset with hate crimes legislation, because they were upset that motive was being made an element of a crime. But, that's neither here nor there. But generally speaking, motive is not an element. The reason why you did something is not relevant to whether you did it. It can be helpful sometimes to tell the jury why, but it's not required. So I'm just saying. It's one thing to say that motive is irrelevant to questions of the scope of civil liability, but it's quite another to make it irrelevant to questions regarding criminal liability. It is irrelevant as to questions of criminal liability. It is irrelevant. It is irrelevant as to questions of criminal liability. Because you don't need it, and having it doesn't create liability. So it's neither necessary nor sufficient. So she said, maybe I'm misreading it, and maybe I'm being unfair, but she says something that might be incredibly dumb. She says, it's one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it's quite another to make it irrelevant to questions regarding criminal liability. But it is. It is irrelevant to questions regarding criminal liability. It is irrelevant. I'll tell you why it's irrelevant. For something to be relevant, by definition, it has to make a fact in dispute more or less likely. That's what makes it relevant. Right? Okay. So since motive is not the element of the crime, it is irrelevant because it's not an element. So having motive does not make it more or less likely that they committed the crime, strictly speaking. So it is technically irrelevant. So I don't know, man. Okay. That's all right. Under that rule, any use of official power for any purpose, even the most corrupt, indicated by objective intent of the most corrupt motive and intent. See, she confuses motive and intent, which frustrates the lawyer in me. That's just sloppy. She conflates motive and intent. Now, a lot of lawyers conflate motive and intent, to be quite honest. But she is a Supreme Court justice. We expect better. Just to illustrate it, just to make it clear, because I've been talking about it, let me give you an example. Suppose a person robs a bank. All right, the intent is to rob the bank. They're robbing the bank. Their intent is to rob the bank. They have gone into the bank with the intent to rob it and are in fact robbing it. Their intent is to rob the bank. Okay? What is their motive? You don't know. I have not given you enough information. Their motive is their reason, right? So I told you the person goes into the bank and is robbing the bank. They have intent to rob the bank. What's their reason? You don't know. Now you can make an intelligent guess, but you're guessing. And I don't need to know in order to prove liability. I just need to know that you went into the bank, you held up the gun, said, stick it up, it's a robbery. You put the money in the bag with the sack with the dollar signs on it and walked out the door. I don't need to prove why. It's not evident why. Maybe you did it for the money, but maybe you did it because, you were bored. Maybe you did it out of revenge because that bank, harmed you in some way. And so you did it out of revenge. Maybe you did it because you're trying to impress a girl. Who knows? It's like, okay, just, okay. All right, just, but she conflates the two and she treats them like they're the same, and it hurts the lawyer in me. They're not the same thing. Yeah. All right. Anyways, pressing on. Under majority's test, if it can be called a test, the category of action is that being deemed unofficial is distinguishing to be vanishingly small. Ultimately, the majority pays lip service to the idea that the president charged with enforcing federal criminal law is not above them. But then it proceeds to place the former president beyond the reach of federal law for any abuse of power. Okay, fine. Yeah, all right, fine. Ultimately, the majority pays lip service to the idea that the president charged with enforcing the law is not above them. All right, so how does the majority get its rule? With the text, history, and established understanding all weighing against it, the majority claims just one arrow to its quiver, the balancing test in Nixon. Well, I wouldn't go that far. I would say that it is a dominant factor, but I wouldn't quite go that far, but sure. Yeah. Yeah. But even the test cuts against it. The majority concludes that official act immunity is required to safeguard the independence and executive functioning of the executive branch, and by rejecting the branch's own protestations that such immunity is not all required and would in fact be harmful. In doing so, it decontextualizes the language, ignores important qualifications, important results that Fitzgerald courts would never countenance. In Fitzgerald, plaintiff Ernest Fitzgerald sued then-President Nixon for money damages. He claimed that while in office, Nixon had been involved in unlawful firing from his government job. The question before the court is whether the former president had immunity from such civil suits. The court explained that it was settled law that the separation of powers doctrine does not bar any exercise of jurisdiction over the president of the United States. To determine whether a particular type of suit against the president or a former president could be heard, a court must balance the constitutional weight or interest to be served against the dangers of intrusion of the authority of the branch. The court explained that when judicial action is needed to serve broad public interests, as when the court acts, not in derogation of separation of powers, but to maintain the balance, or to vindicate the public interest in an ongoing criminal prosecution, the exercise of jurisdiction is held to be warranted. Okay. Fair. The public interest in such private suits, the court concludes, comparatively weak. Therefore, the court held the former president was immune. In the context of federal criminal prosecutions of a former president, however, the danger to the functioning of the executive branch is much reduced. I don't know about that. Further, as every member of the Fitzgerald court acknowledged, the public interest in criminal prosecution is far weightier. Applying the balancing here should yield the opposite result. Instead, the majority elides any difference between civil and criminal immunity. Well, that is sort of where they end up, yes. Granting Trump the same immunity from criminal prosecution as Nixon enjoyed from an unlawful termination suit, that's plainly wrong. Well, I wouldn't go so far as to say plainly wrong, but, okay. I mean, okay. The majority relies almost entirely on its view of the danger of the intrusion of the executive branch to the exclusion of the other side of the balancing test. Okay. Its analysis rests on a questionable conception of the president as incapable of navigating the difficult decision his job requires while staying within the bounds of the law. There's a lot of law. It would be pretty hard. It also ignores the fact that he receives robust legal advice on the lawfulness of his actions. Yeah, but there's a lot of it. The majority says the danger of intrusion on the authority and function of the executive branch posed by criminally prosecuting a former president for official conduct is akin, indeed greater, to what led us to grant absolute immunity from civil damages. The president would be chilled from taking the bold and unhesitating action required of the independent executive. It is, of course, important that the president be able to deal fearlessly and impartially with the duties of his office. If every action the president takes exposes him personally to vexatious private litigation, the possibility of hamstringing the president is very real. If there are many facets of criminal liability, which the majority discounts, that makes it less likely to chill the action. Sell me. First, in terms of probability, the threat of criminal liability is much smaller. I think she's conflating the past with its assumptions on the past with the future. She's doing the housing crisis thing again. She's like, yes, the threat of liability is smaller because up till now it's never happened. So yeah, if you were trying to say what is more likely, a criminal prosecution or a civil prosecution, you'd have to say civil. I mean, the president or the executive are sued all the time for all kinds of stuff. Not so much with the criminals. So yeah, up till this second, the threat of criminal liability has been pretty small. But you're changing the fundamental premise, Sonia Sotomayor, with all due respect. You're changing the premise. And so the threat profile, you'd have to recalculate the threat profile. Don't do a housing crisis. Don't assume, having changed the threat profile, that it won't change in the future. That's a mistake. The court observed that given the visibility of his office and the effect of his action, the president would be an easy target for civil damages. Although the effect of the actions on countless people could result in an untold number of private plaintiffs suing for damages, the risk in a criminal context is only the former president may face one federal prosecutor in one jurisdiction for each criminal offense allegedly committed. Well, shit. that makes me feel better. Don't worry, guys. He can only face criminal prosecution once by one prosecutor in any jurisdiction in which he committed a crime. I feel better already. All right. The majority's bare assertion that the burden of exposure to federal criminal prosecution is more limiting than the president, then the burden of exposure does not make it true and it's not persuasive. I don't think you're recalculating the threat profiles appropriately. Second, federal criminal prosecutions require robust procedural safeguards not found in civil suits. The criminal justice system has layers of protection that filter out insubstantial legal claims, whereas civil litigation lacks analogous checks. And then she cites the Department of Justice manual like it's law or something. You do realize the manual has been written with the current state of the law in mind, which also includes the we don't prosecute the president implicitly. So I'm not sure citing the manual is going to be much help because you're changing a predicate that the manual is built on in potentially a fairly notable way. I think Sonia Sotomayor might be whistling at the graveyard, past the graveyard is what I'm trying to say. The grand jury provides an adequate check on felony prosecutions. Excuse me 1 second. Just give me a second here.
Oh, wait, you serious? Let me laugh even harder.
Thank you, Bender, for that thoughtful contribution to our discussion. All right. As she was saying, the grand jury provides an additional check on felony prosecution, acting as a buffer or a referee between the government and the people to ensure that charges are well-founded. If the prosecution makes it past a grand jury, the former president still has all the protections our system provides to criminal defendants. If the former president has an argument that a particular statute is unconstitutional as applied to him, he can move to dismiss the charges on that ground. Indeed, a former president is likely to have legal arguments that would be unavailable to the average criminal defendant. For example, he may be able to rely on the public authority exception for a particular criminal law or on the advice of the Attorney General of Defense. If the case nonetheless makes it to trial, the government will bear the burden of proving every element of the alleged crime beyond a reasonable doubt to a unanimous jury of the former president's citizens. If the government manages to overcome even that significant hurdle, then the former president can appeal his conviction, and the appellate review of his claims will be particularly meticulous. He can only seek this court's review, and if past practice is any indication, he will receive it. In light of these considerable protections, the majority fears a bare allegation of malice would expose the president to trial and conviction as unfounded. Bare allegations of malice would not make it out of the starting gate. That is only true if you understand that literally, which you have to be a little bit disingenuous to understand that literally. Yes, it's true. A bare allegation of malice is not going to suffice. You may need to cite a criminal law. That's true. Thank you. Technically correct is the best kind of correct, but no. Although private civil suits may be brought on little more than intense feelings, what the fuck? A federal criminal prosecution is made of firmer stuff. Okay. This is an interesting revolution to me. I apparently am a very bad legal educator, and I apologize to you. I am sorry. I've been a horrible legal educator to you for all these years. I really need to rethink the entire existence of my channel, because apparently it is the case that civil law, intense feelings, is a cause of action. I did not know that. I did not know intense feelings were a cause of action. There are no rules in the civil law system. There are no rules or laws or anything. Just the intense feelings. I'm going to amend all my complaints that I file in the future to make sure I bring a cause of action for the intense feelings. Justice Sotomayor says I have a cause of action. Does this mean that I can sue Justice Sotomayor, incidentally? Just out of raw curiosity? Because, if immunity is not a thing, because the Constitution doesn't provide it, and therefore you don't have immunity, one might suggest that my feelings that I'm expressing might be described by somebody as intense. So apparently I have a cause of action against Sonia Sotomayor. I was unaware of this. She doesn't have immunity and I have intense feelings, so good news, everyone, I guess. I will file in court tomorrow. Certainly, there has been, on occasion, great feelings of animosity between incoming and outgoing presidents over the course of history. Yet it took allegations as grave as those of the senator to have the first prosecution that restraint is telling. I'm going to beat my head against the wall. I'm going to get up and I'm going to beat my head against the wall. You are conflating the future with the past. You're doing the hot hand fallacy thing. You know, you're assuming that what has been true in the past will continue to be true even as you change a fundamental presumption. So yes, it's true. It took allegations as grave as these, it took to do it the first time. But, you know, maybe the second time maybe won't be as hard. It's not, but you know, there's no reason to be afraid. There's no reason to be afraid because it's never like there's been a situation in the past where the prosecution has been given a new tool they didn't have before by a court. And they said this will only be used in exceptional circumstances. And it has never been the case before in the history of criminal law that a prosecutor has, let's say, extended or distorted or warped the one time just for emergencies only thing into a somewhat broader proposition that impacts somewhat significantly beyond its originally conceived scope. That's never happened before. So there's no reason to be worried, people. This is a grave circumstance. This is a grave circumstance, and it will always be grave circumstances from here on out because prosecutors would never try to extend this or I can't even do the sarcasm anymore. It broke me so hard. That's great. That's great. If I could get a couple bucks in the tin for a mental health counseling, I could probably I should get Better Health as a sponsor or something. I don't know. Damn. Third, because of long-standing interpretations by the executive branch, every civil action or every sitting president has so far believed himself to be under the threat of criminal liability after his term in office and nevertheless boldly fulfilled the duties of office. You're an idiot. The majority insists the threat of criminal sanction is more likely to distort the president's decision-making. If that's right, then the distortion has been stating the president's decision-making since the earliest days of the Republic. Although it makes sense to avoid diversion of the president's attention during the decision-making process with needless worry, one wonders why requiring some amount of his attention going towards complying with federal criminal law is such a great burden. Did you know that the Congressional Research Service long ago gave up trying to even try to count the number of federal laws? But don't worry, the president won't be worried about it because he can comply with the federal law. Good Lord. If the president follows the law that he must take care to execute, it has not been rendered unduly cautious. How many federal laws do you think there are? Just out of raw curiosity. Like 5? I wish, but not so much. Some amount of caution is necessary after all. It's far greater damage if the president feels empowered to violate the law buoyed by the idea of future immunity. I'm deeply troubled by this idea, inherent in the majority's opinion that our nation loses something valuable when the president is forced to operate within the confines of federal law. Do you know how much federal law there is? Because no one does. Have you really thought that through? Yeah. Okay. So what exactly? So what exactly is the majority worried about deterring when it expresses great concern for the deterrent effect the threat of trial, judgment, and imprisonment would pose? It can't possibly be the deterrence of acts that are truly criminal. What is the difference between an act that's truly criminal and an act that's criminal? Is there one? I mean, what is the difference between an act that's truly criminal and an act that's criminal? Is truly criminal a different category of thing? Because if it is past my attention up to this point. What is the difference between truly criminal and criminal? And which crimes are truly criminal? I mean, this would be helpful to me as a lawyer, potentially, as I advise my clients. It would be helpful for me to be able to tell them which of the crimes are criminal and which of them are truly criminal, as I help to educate them about their potential liabilities going forward. So is there anywhere I can look up the truly criminal crimes so that I can... Is this a lawful law thing? Where do I look up the truly criminal crimes? With their truly criminal punishments, I guess. Are they tried in separate truly criminal courts? I could keep going on with this joke, but I think I'm going to move on now. Nor does it make sense for the majority to wring its hands over the possibility the president may stop and think carefully before taking action that borders on criminal. Oh, okay. Is that borders on the truly criminal or just regular criminal? I need to know. Instead, the majority's main concern could be the president will be deterred from taking such necessary and lawful action by the fear their successors might pin them with a baseless criminal prosecution, a prosecution that would almost certainly be doomed to fail, even if it made it out of the starting gate. This court should not have so little faith in this nation's presidents. Have you taken a look at the political climate around recently? Are you sure about that one? As opposed to falsely criminal laws. Yeah, that's helpful. Is there a list of the falsely criminal laws? Is that what it is? So which ones are the falsely criminal laws? Which ones are not the real criminal laws? Truly criminal when a Republican does it? Maybe that's the answer. As the court has said before in the context of criminal proceedings, the chance that now and again there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. I don't know what the hell that means. The concern that countless and baseless civil suits will hamper the executive may have been justified, but a well-founded federal criminal prosecution poses no danger. I'm sensing real whistling past the graveyard energy here. Yeah. This would be valuable information to our friend Nick Rekieta. Maybe he's not being charged with a truly criminal law. I don't know. I'm not sure which book to consult on that. Maybe his attorney will know which book to consult on that. About the truly criminal laws that may or may not exist. Maybe we've all been misunderstanding this thing wildly. Although I haven't even heard Robert Barnes to argue that they're not true criminal laws, but maybe he's missed a memo. We have a whole new exciting idea to explore. These aren't part of the truly criminal laws, guys. It's been a wild misunderstanding by literally every single person who's commented on it, but that's okay. I'm here to bring you the true education that they're not truly criminal laws. Holy shit. At the same time, the public interest in the federal criminal prosecution of a former president is vastly greater than the public interest in a private individual suit. All 9 justices in Fitzgerald expressly recognized the difference. The 5-justice majority noted there was greater public interest in a criminal prosecution than actions for civil damages. Chief Justice Berger's concurrence accordingly emphasized majority's immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting justices agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. At the very least, the Fitzgerald court did not expect the balancing test would lead to the same outcome in the criminal context. Well, they weren't really faced with the issues, so, I mean, their thoughts are like, and maybe they didn't, maybe they were also waiting for a truly criminal thing. Maybe they have a different idea what truly criminal is. Because, I'm not sure what the prevailing truly criminal precedent is. But, okay. Mind blown. Mind blown. True crime they make podcasts about? That is the most sensible answer that has been given in this chat so far. It's only truly criminal if there's a true crime podcast made about it. That's what makes it. That's why it's a true crime, because it's truly criminal. I like it. That's a good answer. I like that answer. Yeah. It's the way we know it's truly criminal is if there's a true crime podcast, because they only cover the true crimes, the truly criminal ones. Oh, okay. All right. That makes sense. All right. Thank you. I appreciate that answer. That's good. So if no one talks about it, if a criminal commits a murder in a forest, yeah. The public interest in prosecution is transparent. A federal prosecutor acts on behalf of the United States. Even the majority acknowledges that federal criminal law seeks to redress a wrong to the public as a whole, not just a wrong to the individual. Indeed, our historic commitment to the rule of law is nowhere more profound than our view that the guilt shall not escape or innocence suffer. The public interest in a criminal prosecution is particularly strong with regard to officials who are granted some degree of civil immunity because of their duties. It is in those cases where the public can see that officials exercising power under public trust remain on equal footing with their fellow citizens under the criminal law. Judicial immunity was not designed to insulate the judiciary from all aspects of public accountability. Judges are subject to 1983 damage actions, or they're immune to 1983, but they're subject to criminal prosecutions as any other citizens. Not for their official acts, they're not. At least that's what I thought. The public interest in the federal criminal prosecution of a former president alleged to have used his power of office to commit crimes may be greater still. The president represents all the voters of the nation, and his powers are given by the people under our Constitution. When the president uses the power of office for personal gain or as part of a criminal scheme, every person in the country has an interest in the prosecution. The majority overlooks this paramount interest entirely. Okay. Finally, the question of federal criminal immunity for a former president involves countervailing Article 2 considerations absent of Fitzgerald, recognizing such a immunity would have frustrated the executive branch's enforcement of the criminal law. Yeah, I guess. The president is, of course, entrusted with supervisory and policy responsibilities of the utmost discretion and sensitivity. One of the most important is the enforcement of the federal law, is that the president who's charged constitutionally to take care of the law be faithfully executed. Okay, I have to ask a question, which I may be dumb. But right, all this trust. all this trust in like the president and all the rest of it, we are right in the middle of an election season. And there is a non-zero chance that Trump will be reelected to office. Yet Sonia Sotomayor apparently is completely okay with trusting Trump's DOJ once it's been made clear that there's no barrier to going criminally after the former president. Trump, apparently Sonia Sotomayor is MAGA. Who knew? She has faith in Trump and his prosecutors that they will, using long-standing principles, having been advised that it's totally cool to prosecute a president for any of his truly criminal acts, whatever that is, that there is no, that you know, the Biden should be fine. Okay. I mean, I'm just stating, there's apparently, there's no indication in this opinion whatsoever. They're concerned about what might very well be a very foreseeable, immediate, pragmatic reality. Not someday, like tomorrow. You know? So, yeah, I don't know. Okay. The majority seems to think to allow former presidents to escape accountability for breaking the law while disabling the current executive from prosecuting such violations somehow respects the independence of the executive. It does not. Rather, it diminishes the independence, exalting occupants of the office over the office itself. There's a twisted irony in saying, as the majority does, that a person charged with taking care of the laws be faithfully executed can break them with impunity. In the case before us, the public interest and countervailing Article 2 interests are particularly stark. The public interest in the criminal prosecution implicates both the executive's interest in upholding the presidential election, investing the new president under the Constitution, as well as the voters' interest in democratically selecting their president. I assume that applies to Trump as well. I mean, I don't know, but yeah, okay. It's also, of course, implicates Congress's own interest in regulating conduct through the criminal law. Yet the majority believes the president's anxiety over prosecution overrides the public interest in accountability and negates the interest of the other branches in carrying out their constitutionally assigned function. It is, in fact, the majority's opinion that boils down to ignoring the Constitution's separation of powers. Okay. Where am I in this thing? 89 of 119? Dude. No. 30 more pages of this? Dude. I'm not going to make it. This is the end of Uncivil. I have this to go through and whatever other is Dissent to go through. I have 30 more pages of this to look forward to. This is the end of Uncivil Law. All right, fine. Finally, in an attempt to put some distance between his official act immunity and Trump's requested immunity, the majority asserts that Trump asserts a far broader immunity than the limited one they've recognized. If anything, the opposite's true. They've given him more? The only part of Trump's immunity argument the majority rejects is the idea that the impeachment judgment clause requires that impeachment and Senate convict preceded prosecution. That argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment clause argument is the idea that a former president who was impeached in the House and convicted in the Senate for crimes involving his official acts could then be prosecuted for those acts in court. By extinguishing that path to overcoming immunity, they think that they have extinguished that path. I don't think the majority really spoke to the issue, but okay. You think they did? By extinguishing that path to overcoming immunity, as nonsensical as it might be, the majority arrives at official act immunity even more expansive than one Trump argued for. I'm not sure the majority wrote about impeachment, but okay. On the majority views, but not Trump, a former president who abuses power that was so egregious and so offensive, even to members of his own party who was impeached and convicted, still would be entitled to at least presumptive criminal immunity for those acts. I don't think the majority opinion speaks to this issue, but okay. Separate from its official act immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere of constitutional authority. Feel free to skip over those pages of the majority's opinion. Okay. Well, with broad acts immunity covering the field, the substantially narrower immunity serves little purpose. In any event, this simply does not turn on conduct within the president's exclusive sphere of constitutional authority, and majority's attempt to apply core immunity of its own making expands the concept of core constitutional power beyond any recognizable bound. I don't agree with that. The idea of narrow core immunity might have some intuitive appeal in the case that actually presented the issue. If the president's power is conclusive and preclusive on a given subject, then Congress should not be able to act upon the subject. In the Youngstown concurrence, Justice Jackson posited the president's power of removal in an executive agency seemed to fall within this category. Other decisions of the court indicate the pardon power also falls within this category. In this case, however, the question of whether a former president enjoys a narrow immunity for exercise of his core power has never been an issue, and for good reason. Trump was not criminally indicted for taking actions that the Constitution places in the unassailable core of the power. He was not charged, for example, with illegally wielding the president's pardon power or veto power or appointment power or even removal power. Instead, Trump was charged with a conspiracy to commit fraud to subvert the election. It's true that the detailed indictment in this case alleges that Trump threatened to remove the acting attorney general who would not carry out his scheme. Yet it's equally clear the government does not seek to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. If that were the majority's concern, it could simply have said the government could not charge the president threatening use of the removal power as an overt act in the conspiracy, but it says much more. The core immunity that the majority creates will insulate a considerably larger sphere of the conduct that the narrow core of conclusive and preclusive powers that the court previously has recognized. The first indication comes when the majority includes the president's broad duty to take care the law be faithfully executed among core functions for which the president supposedly enjoys immunity. That expansive view of core power will effectively insulate all sort of non-core conduct from the criminal prosecution. Were there any other question, consider how the majority applies it newly minted immunity to the allegations of this case. It concludes that Trump is absolutely immune from the prosecution of any conduct involving discussions with his officials. All right, I need to use the restroom, and I also need a brief stretch break. And possibly, contemplating the decisions of my life that have left me up to this point. So I will be right back. Talk amongst yourselves or something. I guess I don't know. Whatever. We're in Dante's Inferno or something. Do whatever you do in Dante's Inferno, I guess. Okay, we're back. Thank you for the $2 super chat. Not a banned account. Thank you, Chair. Here's support your work. Well, Chair, one of Chair's arms does seem to be broken. So Chair does need the support at the moment because Chair may need a new arm. So yeah, Chair may need a new arm. One of Chair's arms seems to be broken. Not sure how it became broken, but it seems to be. So, yeah. Shall we continue? The core power, the core immunity that the majority creates will insulate a considerably larger sphere of conduct than the narrow core of conclusive and preclusive powers the court has previously recognized. Oh, you guys will like this, by the way, before we move on. I haven't told Joe this yet, but it's just too funny. All right. I have an ad account that I sometimes use to promote my channel. It doesn't really help very much. I put a little bit of money behind it for Karen Reed, and I'm still not sure that it really did anything and like promoting ads and promoting the channel and stuff like that. But I was like, well, maybe it'll help a little bit. I'm not sure it's worth the juice is worth the squeeze, but whatever. So anyways, I have an ad account that technically exists, and I ran some ads against it, and I had no problem running ads. And so I recently told Joe on stream, I think it was like last week or something, I said to him, how can I help you cross 100,000? What can I do for you? And I said, you know what I can do? I'll run ads on against your channel. I'll run ads against your channel on my account. And so I tried to do that. I tried to set up ads for Joe's videos, and every single one of them was disqualified by Google as relating to the election. Every single one of the ads was disqualified by Google as relating to the election. And if you're going to run election ads, they require different paperwork, which I haven't filed. So yeah. These are all old videos, by the way. Like one's dealing with like Fannie Willis, and one's dealing with whatever, and it's like I can't run ads against it. It's just too funny, man. Apparently his channel is so political. Oh man. Yeah, Lord. Where am I? That expansive view of core power will effectively insulate all sorts of non-core conduct from the criminal prosecution. Were there any question, consider how the majority applies its newly minted core immunity to the allegations in this case. It concludes that Trump is absolutely immune from prosecution for any conduct involving his discussions with Justice Department officials. That conception of core immunity expands the conclusive and preclusive category beyond recognition, foreclosing the possibility of prosecution for broad swaths of conduct. Under that view of the core powers, even fabricating evidence and insisting the department use it in a criminal case could be covered. Is that what they actually said? All right, I'm on page 91. Is that what they said, that it was a core power? Back to page 20. No, it's not quite what they said. They said the president may discuss political investigations and prosecution with the attorney general and other department officials to carry out his duty to take care of the law be faithfully executed. They didn't say it as a naked idea. They didn't say like the power. The majority didn't say the president's power that the law be faithfully executed as a core power. They said the power to discuss with the attorney general in order to carry it out is a core power. That's not quite the same thing. So it's another straw man argument. All right, fine. Carrying on. Back to page 91. Okay. It concludes that Trump is absolutely immune from prosecution for any conduct involving his discussions with Department of Justice officials relating to the duty to take care, not nakedly. That conception of core immunity expands the conclusive and preclusive category beyond recognition, foreclosing the possibility of prosecution for broad swaths of content, not if you read it the right way. Under the view of core powers, even fabricating evidence and assisting the department used in a criminal case could be covered. Okay. The majority's conception of core immunity sweeps far broader than logic borrowed from Youngstown should allow. The majority tries to assuage any concerns about its made-up core immunity by suggesting the government agree with it. That suggestion will surprise the government. To say, as the government did, that a small core of exclusive official acts, such as the pardon power, the power to recognize foreign nations, the power to veto legislation, and the power to make appointments cannot be regulated by Congress, does not suggest the government agrees with immunizing any and all conduct conceivably related to the broad array of core powers. That's not what the majority said either. The government, in fact, advises the court to leave potentially more difficult questions about the scope of any immunity that might arise on different facts for a decision if they're ever presented. That would have made sense. The indictment here does not pose any threat of impermissibly criminalizing acts within their conclusive and preclusive authority. Perhaps for this reason, even Trump discouraged consideration of a narrower scope of immunity, claiming that such immunity would be nearly impossible to fashion and would certainly involve impractical line drawing problems in every application. When forced to wade into the thorny separation of power disputes, this court's usual practice is to confine the opinion only to the very narrow questions of the decision. There's plenty of peril and little value in crafting a core immunity doctrine that they didn't seek and rightly has no application in this case. I don't know. Not content simply to invent an expansive criminal immunity for former presidents, the majority goes to a dramatic and unprecedented step further. You think if I got high enough, it would help? Oh, Lord. All right, let's press on. I'm not even sure what I could hypothetically get high on, since I don't have anything, but maybe if I hyperventilate enough or something, I don't know. Maybe that'll make it better. Or I hold my breath. I don't know. Yeah. Not content to simply invent an expansive criminal immunity for former presidents, the majority goes to a dramatic and unprecedented step. It says that acts for which the president are immune must be redacted from the narrative of even wholly private crimes removed into office. Maybe I should move to a state where like edibles are legal or something. Maybe that's what I need in my life. They must play no role in proceedings regarding private criminal acts, Even though the majority immunity analysis purports to leave unofficial acts open to prosecution, its draconian approach to official acts evidence deprives these prosecutions of any teeth. If the former president cannot be held criminally liable for his official acts, those acts should still be admissible to prove knowledge or intent in criminal proceedings of unofficial acts. For example, the majority struggles with classifying whether a president's speech in his capacity as president or his capacity as candidate. Imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposed, no matter what it takes to do. He then hires a private hitman to murder that political rival. Under the majority rule, the indictment could include no allegation the president's public admission of the premeditated intent. Right, okay. Cough medicine? Is that what they talk about, that purple syrup? Yeah, I've heard things. I've heard things. Or whippets. Come on, some whippets. Shit. Pressing on. The majority's extraordinary rule has no basis in law. Consider First Amendment context. Although the First Amendment prohibits criminalizing most speech, it does not prohibit the evidentiary use of that speech, including its use to prove motive or intent. Evidentiary rulings and limiting instructions can ensure evidence concerning official acts is considered only for the proper purpose in which it was admitted. The majority has no coherent explanation why these protections are sufficient in every other context would be insufficient here. Really? You can't think of any reasons? Sure? Okay. The majority hazards an explanation that use of official acts evidence will raise unique risk that jurors' deliberations will be prejudiced based on their views of the president's policies and performance while in office. That unique risk, however, is not a product of introducing official act evidence. It's simply the risk involved in any suit against the former president, including private act prosecutions the majority say it would allow. Okay. All right. That's fine. Today's decision to grant former president immunity for their official acts is deeply wrong. The only thing I'm literally thinking about right now, because the only real addiction I have is food because of my weight issues, the only thing I'm really thinking about right now, and I'm being serious, is how much pizza I can cram into my face to make the pain stop. Because that's my addiction, is food. And that's what I'm fantasizing about right now. How much pizza can I cram into my face until the pain stops? This vulnerable moment has been brought to you by Uncivil Law. Today's decision to grant former president immunity for their official acts is deeply wrong. As troubling as this criminal immunity doctrine is in theory, the majority's application of the doctrine to the indictment is perhaps even more troubling. Okay. In the hands of the majority, this new official act immunity operates as a one-way ratchet. First, the majority declares all the conduct involving the Justice Department and the vice president to be official conduct. That's not what they quite said. Yet it refuses to designate any course of conduct alleged in the indictment as private, despite concessions from counsel. Trump's counsel concedes, for example, the allegation that Trump turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenge sounds private. He likewise conceded the allegation that Trump conspired with another private attorney who caused the filing in court of a verification signed by Trump that contained false allegations to support a challenge sounds private. Again, when asked about allegations that 3 private actors helped implement a plan to submit fraudulent slates of electors to obstruct the certification proceeding, and Trump and a co-conspirator directed that effort, Trump's counsel conceded the alleged conduct was private. Only the majority thinks that organizing fraudulent slate of electors might qualify as official, or is at least so interrelated with other official acts that might warrant protection. Will I cut the dissent as a standalone? No. No one needs to be inflected with this. No. Oh, Lord. Second, the majority designates certain conduct immune while refusing to recognize anything as prosecutable. It shields large swaths of conduct involving the Justice Department with immunity, but does not give an inch in the other direction. The majority admits the vice president's responsibility presiding over the Senate is not an executive branch function, and further admits the president plays no direct constitutional or statutory role in the counting of electoral votes. If the majority refuses to conclude that Trump lacks immunity for his alleged attempts to elicit the vice president to use a ceremonial role for the fraudulently elected results. Instead, it worries that the prosecution for this conduct might make it harder for the president to use the vice president to advance his agenda in Congress. Such a prosecution, according to the majority, may well hinder the president's ability to perform its constitutional functions. Whether a prosecution for this conduct warrants immunity should be an easy question, but the majority turns it into a debatable one. Remarkably, the majority goes further and declines to deny immunity, even for allegations that Trump organized fraudulent elector slates, pressures states to subvert the election, and expose violence at the state. Well, they want the court below to figure it out in the first instance, and they've given lots of benchmarks, and yeah. So I mean, all right. Like they gave a lot for like what the core acts are, and they gave some good examples of how to delineate official acts from unofficial acts. So figuring out whether it's in category 1 or category 3 is doable. And then the immunity that should apply to 2 is a little bit vague. But I'm not sure what point I'm trying to make at this point. I'm not cohesive enough to make a point. I wonder if you could literally do some sort of IQ test at this point, and whether or not it would measurably reflect a difference in my IQ. I wonder if that's a thing. I wonder if you gave me an IQ test at the start of the stream and you gave me an IQ test now, whether or not there would be an appreciable difference. Because I feel like there might be. It's not conceivable that a prosecution for alleged efforts to overturn an election, whether labeled official or unofficial, would pose any danger to the intrusion of the executive, and the majority could have said as much. Instead, it perseveres on the threshold question that should be immaterial. Looking beyond the fate of this particular prosecution, long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upstanding the status quo that has existed since the founding. The new act's immunity now lies about like a loaded weapon for any president who wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world. When he uses his official power in any way under the majority's reasoning, he'll now be insulated from criminal prosecution. Really, we're doing this? Really, we're doing this? Do I literally have to say these words out loud? I guess I do. Orders the Navy SEAL Team 6 to assassinate a political rival? Immune. Organizes a political coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune, immune, immune. I think it's possible my consciousness has now slipped into some sort of liminal state, and I'm not happy about it. Let the president violate the law. Let him exploit the trappings of office for personal gain. Let him use his office, his official power for evil ends. Because if he knew that one day he might face liability for breaking the law, he might not be as bold as fearlessly like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. And every use of official power, the president is now a king above the law. Okay. The majority's single-minded fixation on the president's need for boldness and dispatch ignores the countervailing need for accountability and restraint. The framers were not so single-minded. In Federalist Papers, after endeavoring to show the executive designed by the Constitution combines all the requisites of energy, Alexander Hamilton asked a separate, equally important question. Does it also combine the requisites to safety, in a Republican sense, a due dependence of the people, a due responsibility? The answer was then yes, based in part upon the president's vulnerability to prosecution in the common course of law. The answer after today is no. Never in the history of our republic has a president had reason to believe he'd be immune from criminal prosecution if he used the trappings of our office to violate criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of the office misuses official power for personal gain, the criminal law the rest of us must abide by will not provide a backstop. With fear of our democracy, I dissent. Exciting. All right. Justice Jackson, what do you have us for us today? Justice Jackson, dissenting. Justice Sotomayor has thoroughly addressed the court's flawed reasoning and conclusion as a matter of history, tradition, law, and logic. I agree with every word of her powerful dissent. I write separately to explain as succinctly as I can, oh Lord have mercy if it's true, what the majority has done to alter the paradigm of accountability of presidents of the United States. I also address what that paradigm shift means for our nation moving forward. To fully appreciate the profound change the majority has wrought, one must first acknowledge what it means to have immunity from criminal prosecution. Put simply, immunity is an exemption from the duties and liabilities imposed by law, Black's Law Dictionary. Okay. In its purest form, the concept of immunity boils down to a maximum. The king can do no wrong, a notion that was firmly rejected at the birth of our republic. Today, to say that someone is immune from criminal prosecution is to say that, like a king, he is not under the coercive power of the law, which will not suppose him being capable of being committed a folly, much less a crime. Thus, being immune is not like having a defense under the law. Rather, it means the law does not apply to the immunized person in the first place. Conferring immunity, therefore, creates a privileged class free from liability for wrongs inflicted or injuries threatened. It is indisputable that immunity from liability for wrongdoing is the exception rather than the rule in the American criminal justice system. That is entirely unsurprising, for the very idea of immunity stands in tension with the founding principles of our system of government. It's a core tension of our democracy that the people are sovereign, and the rule of law is our first and final security. From their own experience and the deep reading of history, the founders knew that law alone saves the society from being rent by internecine strife or ruled by mere brute power from being, however disguised. A corollary to the principle sets terms for this case. No man in this country is so high he's above the law. No officer of the law may set that law as defiance with impunity. All officers of the law, from the highest to the lowest, are creatures of the law and bound to obey it. We have long lived with the collective understanding that decency, security, and liberty alike demand that government officials shall be subject to the same rules of conduct that are commands of the citizens. For in a government of laws, existence of government will be imperiled if it fails to observe the law scrupulously. These foundational presuppositions are reflected in a procedural paradigm of rules and accountability that operates within the realm of criminal law, what I would call an individual accountability model. The basic contours of that model are familiar because they manifest in every criminal case. Criminal law starts with an act of legislation which holds the power to define the crime and ordain the punishment. Criminal statutes are laws of general applicability that express the assent of the people that certain conduct is off limits in our society. When the federal government believes that someone has run afoul of a criminal statute, it decides to exercise its prosecutorial discretion to pursue punishment for that violation. It persuades a grand jury that there's a probable cause to indict. There, the government marshals evidence to prove beyond a reasonable doubt defendant engaged in prohibited conduct and possess the requisite state of mind. So far, I'm enjoying this book report. It's a good book report. For his part, the defendant stands accused, but is presumed evidence innocent until proven guilty. Notably, criminal defendants have various constitutional guarantees protecting their rights, including the right to a speedy and public trial, the right to have a jury decide guilt or innocence, the right to an assistance of counsel, and the right to confront witnesses against him. The defendant also has at his disposal many means to defend himself against a criminal charge. He can, of course, seek to hold the government to its burden of proof. And even before trial, in a motion to dismiss, he might make any number of legal arguments. He can assert, for example, the government's charging document does not give adequate notice of the charge against him, or the law he's been accused of is vague. He might further claim the law is unconstitutional as applies to his conduct, and he might maintain his conduct even if proved does not violate the law at issue. The defendant may also raise an attempt to prove affirmative defenses that would excuse the conduct. Generally speaking, affirmative defenses are determinations, often adopted by legislation, that certain conduct otherwise punishable is justified. You know, not for nothing, but typically in criminal law, we consider excuse and justification to be two different things. I'm just saying. Typically, we consider excuse and justification to be two separate concepts. And she conflates the two, which is super exciting. That might be the case, for example, where the legislature determines that under specific circumstances, the societal harm produced is outweighed by the need to avoid even a greater harm. And also, by the way, not for nothing, but I could be mistaken, and I'm sure there's legislation to the contrary in some examples, but as a typical matter, neither excuse nor justification is, well, at least it wasn't put in statute in the first instance. These are common law concepts. So the law sometimes repeats in statute what the common law reflects, but it's not really the legislature making the decision most of the time, but I digress. Importantly, a defense is not an immunity, even though defense can likewise result in a person being charged of avoiding liability. Consistent with our norms, well, avoiding liability for his criminal conduct. No. Okay, no. That's wrong, because you're presuming it's criminal. which some of those defenses are directly negating that proposition, right? So you're saying it can result in a person being charged with a crime avoiding liability for his criminal conduct. But some of your examples of defenses are saying there's no crime here. And if accepted, would be saying there is no crime here. So he's not avoiding liability for his criminal conduct. He's avoiding liability for his non-criminal conduct in those circumstances. Which also is what it excuses legally. Excuse means there's no criminal conduct. So you're not avoiding liability. There is no liability. But these are technical distinctions that I'm sure are not important. All right. Where was I? Importantly, a defense is not an immunity, even though defense can likewise result in the person being discharged. Okay. Consistent with our foundational norms, the individual accountability model adheres to the presumption that the law applies to all and that everyone must follow it, yet the model makes allowances for recognized offenses. Okay. One such defense is the special privilege that government officials sometimes invoke when carrying out their official duties. Yeah. All that to say is the government has long functioned under an accountability paradigm in which no one is above the law, an accused person is presumed innocent until proven guilty, assuming a crime happened at all, and criminal defenses may raise defenses, both legal and factual, that may, for example, mean that there's no crime. You know? For over 2 centuries, our nation has survived with these principles intact. With these understandings of how our system accountability for criminal act functions, it becomes much easier to see the majority's ruling in this case breaks new and dangerous ground. Departing from the traditional model of individual accountability, the majority has concocted something entirely different. A presidential accountability model that creates immunity and exemption from criminal law applicable to only the most powerful official in our government. Well, I mean, he is kind of someone who stands alone. That's true. So how does this new accountability model work? An initial problem is the lack of clarity regarding what the new model entails. The majority announces only its most basic contours, which is somewhat typical for the Supreme Court. They typically only sort of, that's more common than not. Usually the Supreme Court is just kind of gives you an outline and expects the lower courts to do the rest. That's more typical. Instead of no immunity, the individual accountability model, or an unqualified grant of absolute immunity of all official acts, the majority purports to adopt something of a hybrid. It holds that a former president may or may not be immune from criminal prosecution for conduct undertaken while in office, to be determined on a case-by-case basis. Okay. According to the majority, whether a former president is immune depends on how his criminal conduct is classified as among 3 possible categories. Okay. First, with respect to any criminal conduct relating to a president's core functions, those subjects within the conclusive and preclusive authority, the president's entitled to absolute immunity from criminal prosecution. Second, expanding outward from this core, regarding all other acts within the outer perimeter of the official responsibility, the president is entitled to at least presumptive immunity. And third, if the criminal conduct comprises unofficial acts, there is no immunity. Applying the majority's new presidential accountability model thus seems to involve bearing down on the indictment allegations and making sense of determinations about the nature of the conduct. From the structure of the paradigm, it appears that the first decision point is where the alleged criminal conduct involves one of the president's core powers. If so, and apparently regardless of the degree to which the conduct implicates that core power, the president is absolutely immune from criminal liability for exchanging in the conduct. If not, then one must proceed to consider whether the conduct qualifies as an official or unofficial act of the president. If the crime is an official act, the president is presumptively immune, from immune. But even then, immunity still hinges on whether there's any legal or factual basis for concluding the presumption of immunity has been rebutted. Alternatively, if the charged conduct is an unofficial act, a determination that, incidentally, courts must make without considering the motivations, the president is not immune. Okay. Which again, like, motivations are not typically what turns a criminal law. Right? So if you're trying to determine, motive is not usually an element here, guys. I mean, So, okay. The majority's multi-layer, multifaceted threshold parsing of the character of the president's criminal conduct differs from individual accountability model in several crucial respects. I got to do something about this light. It's so strong in my eyes. It's hurting me. It's hurting my eyes. I don't know what I can do to make it less severe or something. Maybe I need to change the color temperature down and readjust the camera. If I bring the color temperature down to like 3400, that's not so bad. And then I just have to readjust the camera to like compensate for that maybe. Instead of 3800 where it is now. Ah, my eyes hurt. Bring down the light a little bit. All right, pressing on. Where was I? All right. For the majority's multi-layered threshold, is problematic in several respects. For one thing, it makes it next to impossible to know ex ante when and under what circumstance the president will be subject to accountability for his criminal acts. For every allegation, the court must run the gauntlet first, no matter how well documented or heinous the criminal act might be. Thus, even on a hypothetical president who admits to having ordered the assassination of his political rivals or critics, or one who's indisputably investigates a successful coup, has a fair shot of getting immunity under the majority's new presidential accountability model. That's because where the president's conduct will subject him to criminal liability turns on the court's evaluation of a variety of factors related to the court's characterization of the act, specifically those characteristics that imbue the act with the status of official or unofficial minus motive, which isn't usually what the law turns on. Turn on a blue filter. I think I have blue filter on. I think I have it set in the monitor for a filter. But let me double check. Color temperature. Cool. Make the color temperature of the thing a little warmer. It's amazing how much that changes it. Advanced picture. I'm not sure where it is. Picture mode in it. I'm not sure where it is in the thing. Maybe later. I'm sorry. I'm definitely not the sharpest on Civil at the moment. I'm getting distracted. Thus, even a hypothetical president who admits to having ordered the assassination of his political rival or critics, or one who indisputably instigates an unsuccessful coup, has a fair shot of getting immunity under the majority's new presidential accountability model. That's because where the president's conduct will subject him to criminal liability turns on the court's evaluation of a variety of factors related to the character of the particular act, specifically the characteristics that imbue the act with status of official or unofficial. In the end, then, under the majority's new paradigm, where the president will be exempt from murder, assault, theft, fraud, or any other reprehensible and outlawed criminal act will turn on whether he committed the act in his official capacity, such that the answer to the immunity question will always inevitably be, it depends, which, is no stranger to law. Under the individual accountability paradigm, the accountability analysis is markedly less convoluted and leads to a more certain outcome. None of the same complications or considerations arise because, as I've explained, there are no exemptions from the criminal law for any person, but every defendant can assert whatever legal arguments and defenses might be applicable. Since no one is above the law, everyone can focus on what the law demands and permits and what the defendant did or did not do. No one has to worry about characterizing any criminal conduct as official or unofficial in order to assess the application of the immunity at the outset. The majority's new presidential accountability model is also distinct insofar as it accepts a basic starting premise that generally applicable criminal law does not apply to everyone in our society. In the majority's view, while all their citizens in the United States must do their job and live their lives within the confines of the criminal prohibition, the president cannot be made to do so, but must sometimes be exempt from the law's dictates, depending on the character of his conduct. Indeed, the majority holds that the president, unlike anyone else in our country, is comparatively free to engage in criminal acts in the furtherance of his official duties. That point bears emphasizing. Immunity can issue for presidents under the majority's model, even for unquestionably and intentionally egregious behavior. Regardless of the nature of the impact of the criminal conduct, so long as the crimes pursuant to powers invested exclusively in him or near to carry out the function, he is likely to be deemed immune from prosecution. They may not have been drunk when they said this, but at this point I'm slurring my words and my focus is off, like I've been drinking, which I haven't. So I've noticed that my words are slurring more and my focus is harder to find. So yeah, basically I'm intoxicated on the stupid, I think. It's not great. It's not fun. Where was I? I don't even know. Ultimately, the majority's model simply sets the criminal law to one side when it comes to crimes allegedly committed by the president. Before accountability can be sought or rendered, the judicial serves a newfound special gatekeeping charged with not merely interpreting the law, but with whether it applies to the president at all. Also, under the new presidential accountability model, the starting presumption is the criminal law does not apply to presidents, no matter how obviously illegal, harmful, or unacceptable a presidential's official behavior might be. Regardless of all that, the court must now ensure that a former president is not held accountable for any criminal conduct he engages with while on duty, unless his conduct consists primarily and perhaps solely of unofficial acts. The structure and function of these two accountability model are not the only differences. The model also assigns different roles to participants, and they ultimately generate different relationships to the presidency and the rule of law. I only have 12 more pages. I can do it. Punch drunk. Yeah, that's basically what's going on. Yeah. And punch drunk. Yeah, that's a pretty good way of putting it. Under the individual accountability model, duty-bound prosecutors initially exercise their discretion, decide whether to seek punishment for alleged violations of criminal law. And even if prosecutors decide to bring a charge, a jury of criminal defendant peers ultimately decides whether the defendant will be actually held to account for having engaged in unlawful conduct after a court has resolved any legal challenges and instructed the jury to requirements. So we're going to just trust the prosecutors, I guess. In contrast, under the majority's new presidential accountability paradigm, what the prosecutor or jury may not even matter, since courts take center stage once charges are brought against the president, marshaling their resources to conduct a complex and amorphous threshold immunization evaluation. Whether a former president will be entirely exempted from the dictates of the law requires a judicial assessment in the first instance of his criminal conduct and the circumstances under which he acted. Finally, and most importantly, recall that under the individual accountability model, an indicted former president can raise affirmative defenses just like any criminal defendant. That means that the president remains answerable to the rule of law insofar as he must show that he was justified or, excused to the extent that you think there's a difference, which the criminal law typically expresses a difference between those two concepts. They're very closely related, but typically expressed separately, but, whatever, let's say justified. In committing a criminal act while under the office of these given circumstances. In other words, while the president might be indeed privileged to commit a crime in the course of his official duties, any such privilege exists only when the people determine that the former president's conduct was in fact justified or, excused, notwithstanding the general criminal prohibition. Under the majority's immunization regime, by contrast, the president can commit crimes in the course of his job, even under circumstances in which no one thinks he has any excuse. And again, are we treating excuse and justification as the same thing? Because it seems like we are. Okay. All right. My vision is getting blurry. And I have a hangover. All right. Justice Sotomayor has already warned of the dire consequences that are likely to follow from the majority's decision. I also note with minor amusement that the number of people watching this has decreased dramatically as I've gotten more and more inebriated. I don't even know what the right word is at this point. I've thus far endeavored to merely explain what the court's rulings amounts to on a theoretical level. The court's abandonment of individual accountability model as applied to the president and introduction of a new presidential accountability model that authorizes the judiciary to exempt the president from punishment under the law, depending on an official or unofficial character of the criminal law at issue. Here, I will highlight two observations about the results that will follow from this paradigm shift. She likes the word paradigm for a lot. She likes paradigm a lot. Okay. First, by changing the accountability paradigm. Every time she says paradigm, take a drink, I guess. First, by changing the accountability paradigm in this fashion, the court has unilaterally altered the balance of power between the three coordinate branches of the government as it relates to the rule of law, aggrandizing the power of the judiciary and executive to the detriment of Congress. Second, the majority's presidential accountability model undermines the constraint of law as deterrent for future presidents who might otherwise abuse their power to the detriment of us all. Am I staying hydrated? I've gone through about 2.2 liters. Yeah, I've had like a half gallon of liquid since we've been starting. Yeah. Take a moment to stop. Okay. Yeah. This bottle holds 1.5 liters. It was full when I started, and I've refilled it. And I have drank, according to this, about 600 liters or 600 milliliters. So in addition to 1.5 liters, I'm about 2.2 liters of water since I've started streaming. I've had some water. How you guys doing? I'm not sure if coffee would help. I had some coffee earlier, and I think caffeine would only make it worse at this point. Let's figure out what Kurt wants on his pizza. Yeah, that sounds closer to me, man. That sounds closer to me. All right. Try some push-ups. I kind of have to pee again because I've been drinking so much water. Consider the structural implications of today's decision from the standpoint of separation of powers. Until now, Congress laws passed by the representative of the people bound the people and their elected officials just the same. Law, as we've explained, is the only supreme power in our system of government, and every man who accepts office, participates in its functions, is only the more strongly bound to submit to that same supremacy and observe the limitations which it imposes on the exercise of the authority it gives. With the adoption of a paradigm that sometimes exempts the president from the dictates of law when the court says so, this court has effectively snatched the legislature from the authority to bind the president or not to Congress' mandates, and has also thereby substantially augmented the power of both the office and the presidency itself. As for the former, it should go without saying that the office of the presidency, the apex of the executive branch, is made significantly more powerful when the constraints of criminal law are lifted with respect to exercise of the president's official duties. And after today's ruling, the president must still take care the laws be faithfully executed, yet when acting in his official capacity, he has no obligation to follow those laws himself. But whatever additional power the majority's new precedent accountability model gives to the presidency, it gives doubly to the court itself. For the majority provides no meaningful guidance of how to apply this paradigm or how to categorize the conduct. For instance, its opinion lists some examples of core constitutional power with respect to the president is now entitled to absolute immunity, a list that apparently includes the removal power, the power to recognize foreign nations, and the pardon power. However, the majority does not, and likely cannot, supply any useful or administrative definition of the scope of the core. For what it's worth, the Constitution's text is no help either. Article 2 does not contain a core powers clause. Really? Seriously? Really? Seriously? All right. Fine. So actually meets and bounds of the core presidential powers are really anyone's guess. Nor does the majority explain how to consistently distinguish between official and unofficial acts. Quite the opposite, in fact. While acknowledging there is a critical line that courts must draw in order for this new accountability model to work, the majority simultaneously cautions that making this distinction can be difficult, likely a gross understatement given the recognized breadth of the president's discretionary responsibilities under the Constitution. The majority likewise provides no guidance as to when, how, or why the president's presumptive immunity for non-core official acts might be rebutted, saying only that the applicable criminal law must pose no danger of intrusion of the authority and function of the executive branch. At most, to distinguish official from unofficial conduct, the majority advises whether the former president's conduct was manifestly or palpably beyond his authority. But that test can be illusory, as was evidenced by the facts of this case. With respect to the indictment's allegations concerning petitioners' attempt to assemble false slates of electors in conjunction with the events of January 6, for example, the majority admits that the alleged conduct cannot be neatly categorized, and the analysis therefore may be proved to be challenging. With this, at least, I could not agree more. This much is clear. Before today, none of these kinds of inquiries were necessary for criminal liability to be fairly assessed with respect to persons accused of having engaged in criminal conduct. And frankly, none is needed now, except as it relates to the present under the new paradigm the majority has crafted. Perhaps even more troubling, while Congress, the branch of our government most accountable to the people, is the entity our Constitution tasked with deciding, as a general matter, what conduct is on or off limits, the court has now arrogated that power unto itself, with the question pertains to the present. In essence, the court has now imposed its own preclearance requirement on the application of Congress's laws to a former president alleged to have engaged in crimes while in office. Who will be responsible for drawing the critical line between the president's personal and official affairs? To ask the question is to know the answer. A majority of this court, applying an indeterminate test, will pick and choose which laws will apply to the president by labeling his various alleged criminal acts as core, officially, or manifestly or palpably beyond the presidential authority. Well, I mean, that's just the legal test. That's kind of how that works, because we're trying to determine which category it falls into as a question of law. So yeah, ultimately, you're trying to figure out, yes, I mean, that's true. Ironically, then, while the purported seeking to transcend politics, the court today displaces the independent judgment of the political branch about, although not the president, because he's part of the political branch, but never mind, about the circumstances under which the criminal law should apply. Effectively, the court elbows out both the Congress and its prosecutorial authorities within the executive branch and makes itself the indisputable player in all future attempts to hold presidents accountable to generally applicable laws. The framers, however, did not make the judiciary the overseer of the government. To be sure, this court may sometimes have to intervene in determining where authority lies between the democratic forces in our scheme of government, but it has long been understood that we should be wary and humble of when to do so. The majority displays no such caution or humility now. Instead, the court today transfers from the political branches to itself the power to decide when the president can be held accountable. What's left in its wake is a greatly weakened Congress, which must stand idly by as the president disregards its criminal prohibitions and uses the powers of its office to push the envelope while choosing to follow or not follow existing laws as he sees fit. We also now have a greatly empowered court which can opt to allow Congress's policy judgment criminalizing conduct to stand or not with respect to the former president as a matter of his own prerogative. Which would have been true, incidentally, in any case, by the way, if they didn't do this, right? So even if we had gone with like the minority's idea, right, that the president is afforded certain defenses and he might have defenses that are not available to the typical person, right? Those defenses are ultimately questions of law. Those are ultimately questions of law. So the problem doesn't necessarily disappear, right? Because it's like, well, does this legally qualify as a justification or does this legally qualify as an excuse? It's still a question of law. So there's that too. Just saying. You know, okay. If structural consequences, oh, hello, Gio from California. It's quite sunny here in Texas as well. 97, mostly sunny. It's a beautiful day outside. Although here, to be honest, that's what my computer says. But to be honest, It's more like mostly cloudy at the moment, but whatever. Anyways, wherever I was. If the structural consequences of the paradigm shift mark a step in the wrong direction, then the practical consequences are a 5-alarm fire that threatens to consume our democratic self-governments. Well, points for flair, I guess. Is this like the restaurant in Office Space where the amount of flair is how good of an employee you are? What's the name of the restaurant in Office Space? There's no way I'm coming up with this piece of trivia right now. Is it like O'Charlie's or something like that? I forget. Whatever. It doesn't matter. The majority shoos away from this possibility, but Justice Sotomayor makes the point plain, and I will not belabor it. Here I'll merely observe that from a theoretical perspective, philosophers have long considered deterrence to be a key justification for adopting and maintaining systems that ensure accountability for criminal conduct. For that same reason, some commentators also maintain that decreasing the certainty of accountability for wrongful acts at least arguably reduces incentives to follow law. Under the individual accountability model, because everyone is subject to the law, the potential of criminal liability operates as a constraint on the actions and decisions of everyone, including the president. Schlotsky's? I'll take your word for it. That is not triggering a memory. I'll take your word for it. After today, that reality is no more. Consequently, our nation has lost substantial check on the presidents who would use their official powers to commit crimes with impunity while in office. So one might ask, what remains of accountability for the president? With today's paradigm shift, the majority leaves in place only the chance that this court might someday determine that criminal conduct in question was an unofficial act, or the government will somehow rebut the presumption of immunity that applies to the official acts, such that the criminal consequences might attach. With the parameters of the official and unofficial conduct known, I feel highly unlikely a sitting president would feel constrained by these remote possibilities. Chotsky's sounds more promising. All this leads to the point why exactly, as a majority conclude that the indeterminate core versus official versus unofficial line drawing exercise is a better way to address the liability for the president. Could it be the majority believes the obvious grave dangers of shifting from the accountability model to the presidential model might nevertheless be offset by the great benefits of doing so? Okay, sure. Chotsky's? Yeah, that pronounced Chotsky. Yeah, that sounds promising. Chotsky, yeah. That sounds promising. Some of the majority analysis, Some of the majority's analysis suggests as much. As far as I can tell, the majority is most concerned that without immunity, presidents might be chilled from taking the bold and unhesitating action required of an independent executive. The court's opinion candidly laments the application of law to presidents that might not be even-handed, and as that result, presidents might be less vigorous and energetic. But that concern ignores or rejects the foundational principle upon which the traditional individual accountability paradigm is based. Worse still, is that I'm still alive and reading this. Worse still, promoting more vigor from presidents in exercising their official duty, and presumably less deliberation, invites breathtaking risks in terms of harm to the American people that, in my view, far outweigh the benefits. That is not to say the majority is wrong when it perceives that it can be cumbersome for the president to have to follow the law while carrying out the duty to enforce it. It's certainly true that a scheme of government like ours no doubt at times feels the lack of power to act with complete, all-embracing, swift-moving authority. But any American who has studied history knows that our government was designed to have such restrictions. Our Constitution's separation of powers was adopted by Convention of 1787 not to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but to save the people from autocracy. Having now cast a shadow of doubt over whether, when, if ever, a former president will be subject to criminal liability for any criminal conduct he engages on while duty, the majority incentivizes all future presidents to cross the line of criminality while in office knowing that unless they act manifestly or palpably beyond their authority, they'll be presumed of publication. I mean, there is a point to be had there, to be honest. Majority also tells us not to worry because, like everyone else, the president is subject to prosecution in his unofficial capacity. This attempted reassurance is cold comfort, even setting aside the fact the court has neglected to lay out a standard that reliably distinguishes between official and unofficial. Well, they did give some benchmarks. They gave a lot more guidance on this issue than I think you're giving credit for, but okay, fine. Why? Because there's still a manifest inequity. Presidents alone are now free to commit crimes when they're on the job, while other Americans must follow the law in all aspects of their life, whether personal or professional. This official versus unofficial act distinction also seems both arbitrary and irrational, for it suggests the unofficial criminal acts of the president are the only ones worthy of prosecution. Quite the contrary, it's when the president commits crimes using his unparalleled official powers, the risk of abuse and autocracy will be most dire. So the fact that, unlike anyone else, the president is vested with sweeping power and duty actually underscores, rather than undermines, the grim stakes of setting the criminal law to the side when the president flexes those very powers. Thank you very much, Mrs. Ryan, for becoming an uncivilian. Your contribution is appreciated. Thank you. Two pages left. 2 pages left, and then I get to decide how to reward myself. I can do it. The vision John Adams enshrined in the Massachusetts Declaration, a government of laws and not of men, speaks directly to this concept. Adams characterized the document as an homage to the rule of law. It reflected both a flat rejection in positive terms of rule by fiat and solemn promise that every act of government may be challenged by an appeal to law. Thanks to the majority, that vision and promise are likely to be fleeting in the future. From this day forward, the presidents of tomorrow will be free to exercise their commander-in-chief power, foreign affairs power, and all the vast law enforcement powers enshrined in Article 2, however they please, including in ways that Congress has deemed criminal and might have potential grave consequences for the rights and liberties of Americans. To the extent the majority new accountability paradigm allows presidents to evade punishment for their criminal acts while in office, the seeds of absolute power for presidents have been planted. And without a doubt, absolute power corrupts absolutely. If one man can be allowed to determine for himself what the law is, every man can. That means first chaos, then tyranny. Likewise, if the government becomes a lawbreaker, if the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. I worry after today's ruling, our nation will reap what the court has sown. Stated simply, the court has now declared for the first time in history, the most powerful official in the United States can, under circumstances yet to be fully determined, become a law unto himself. As we enter this uncharted territory, the people in their wisdom will need to remain ever attentive, consistently fulfilling their established role of our constitutional democracy, and thus collectively serving as the ultimate safeguard against any chaos spewed by this court's decision. For, like our democracy, our Constitution is the creature of their will and lives only by their will. For my part, I can simply not abide the majority's senseless discarding. I'm so close. For my part, I can simply not abide the majority's senseless discarding of a model of accountability for criminal acts that treats every citizen of this country as being equally subject to the rule of law as the rule of law requires. That core principle has long prevented our nation from devolving into despotism. If the majority now opts to let down the guardrails of the law for one extremely powerful category of citizen, any future president who has the will to flout the Congress's boundaries. In short, America has a tradition relied in on law to keep the presidents in line. Starting today, however, America must rely on the courts to determine when, if at all, the criminal laws their representatives have enacted to promote individual and collective security will operate as a speed bump to the presidential action or reaction. Once self-regulating, the rule of law now becomes the rule of judges, with courts pronouncing which crimes committed by the president have to be let go and which can be redressed as impermissible. So ultimately, this court itself will decide whether the law has any barrier to whatever course of criminality emanates from the Oval Office. The potential for great harm to American institutions and Americans themselves is obvious. The majority of our colleagues seem to have put their trust in the court's ability to prevent presidents from becoming kings through a case-by-case application of indeterminate standards of the president's accountability. I fear they are wrong. But for all of our sakes, I hope they're right. In the meantime, because the risks in power the court has now assumed is intolerable, unwarranted, and plainly antithetical to the bedrock of the constitutional norms, I dissent. I no longer have to keep reading. I'm free. I'm free. Now, ideally, what I'd like to do at this point is what I would have typically done on similar streams. What I'd typically like to do at this point would be to try to provide you an idea of what I think, and then potentially field some questions that may or may not influence my answer or otherwise provide clarity. That's typically what I do at this point. I try to provide a cohesive set of thoughts and then potentially take questions to potentially test my ideas. That would be a normal thing to do. My brain is mush. My brain is mush. So I don't have a lot of confidence that what I say would be coherent or even necessarily reflective of what I think. So, yeah. Okay. Yeah, maybe we can do an AMA later or something. That's not a bad idea. Yeah. Yeah. I'm just gonna lean back in my chair for a minute. We can lean back in our chair together. Oh yeah. Oh yeah. All right. That was a lot. That was a lot of words. Looking at motive is also problematic from a factual posture because with the president in particular, you have mixed motives. So even if you were to look at motive, you would have a real problem with that as a matter of practice because the president often has mixed motives, some of which are political for himself. I mean, presumably every action of the president, or at least the vast majority of them, or at least a significant number of them, are somewhat calculated by either the president and or his staff to promote his political fortunes, right? So, but the minority also, in complaining about the lack of ability to look at motive, also doesn't really deal with the fact that like 99% of the time you'd have a mixed motive problem. And how do you deal with that? So it also doesn't deal with that problem as long as we're poking holes in the dissent like I need to, but you know, there's that. I agree with the minority in parts, at least, that there is definitely elements of the majority opinion that leave things to be desired. And I do appreciate their concern about the problem. And there is definitely a point to be had there, especially like with respect to exactly what the whole unduly burdens the executive thing means exactly. That's unclear. And potentially what exactly a core function is. They give some examples, but I mean, presumably a core function is one that the Constitution mandates, as opposed to there being an act of Congress. So I don't think it's as hard as they suggest. But you're just in a Youngstown Steel analysis. Basically, you're just in category 3 of Youngstown Steel. So you're just looking for what the Constitution gives the president without the need for statute. Would be a core power. So I don't think it's as difficult as they illuminate. What else can I say? I also share, I don't know if it's Amy Coney Barrett's point or the minority's point, but I also share the concern of the inability to use the official act insofar as it would be an element of the offense, bribery being like the most obvious example. It's like, okay, so if the majority's opinion can be understood to preclude the ability to use the act as a fact or an element, and they try to deal with it in the footnote a little bit, but the footnote left a little bit to be desired, I'm not going to lie. Especially if you can't use any like of his officials' statements to the extent the president like made a statement that would reflect his like criminal intent directly. I mean, I share some of the concerns there with some of the evidentiary issues as it relates to bribery, for example, would be the most obvious. And I assume there's examples outside of bribery. I just can't think of any. But I tend to agree with the majority on the more general point. Like, unless it's, let's say, core to the charge, unless it's an element of the charge, then using it as evidence to support the charge raises too many problems. So I agree with the majority there, I think. I also like Amy Coney Barrett's suggestion better, that the better way to frame this is by phrasing it from a posture of constitutionality versus immunity, which basically winds you up in arguably the same place, but I do like it as a cleaner concept. So I do like her suggestion that instead of saying the president is immune, we say, if we're going to go down this road, we simply say that it's an unconstitutional as applied, and then we allow for an interlocutory. And that gets us to largely the same place, but I do like it. It's conceptually cleaner for me. I do like that idea. And it makes more sense. It's, I think, from first principles to say that this is like an unconstitutional burden on the president, rather than the president is immune for illegal acts. I think it's a better way of conceiving it, to be honest. So I think I agree with Amy Coney Barrett's suggestion along those lines as being cleaner. Although she goes much further than I would on the evidentiary issue. She seems to not have a problem with the evidence coming in wholesale to show an evidence of the crime. And I think the majority's consideration is more well conceived. What else? I definitely think the minority is wrong when they are so discounting of the possibility of future prosecutions. Because up till now, for whatever combination of reasons, this dam has not been broken. And it just strikes me as fundamentally absurd. It just strikes me as completely absurd to be like, okay, if we're going to break this dam, don't worry, because only cases that are this serious, assuming this case is that serious, but only cases that are this serious or more serious are going to be covered. That's just not the way that law has worked basically ever. You don't do a just this time thing like in common law. That is a really bad idea. Just as a general proposition, it's okay this time, don't worry about it. In the future, it'll only be like this. Just this once. Just this once is pretty much a universally bad idea in common law. It is just a really bad idea. So that's, and they're like, it's no big deal because prosecutors will use the same discretion that's got us up to this point. There's no reason to think that's true once you've changed the premise. There's no reason to believe that. I don't know. So I'm sort of left in this middle area about official acts. This is where I don't know. And part of the reason I don't know is because the Supreme Court didn't give me a lot to work from in the first place, which makes my life more difficult. Right? Because they only gave me this one sentence about, making sure it doesn't unduly burden the executive, whatever the hell that means. It's like, I don't know exactly what that means, and I don't know how to apply that, which makes my life more difficult trying to figure out whether I agree with it or not. So, and the minority is at least right insofar as that portion of the application seems ripe for problems. There's no hope. There's no hope of Trump being prosecuted anytime in the near future, or really probably ever, because the court is going to have to go through what's going to have to be an incredibly complicated finding. It's going to take months to do it. And then, of course, there's the appeal. And then even assuming there's the conviction, there's the appeal on the conviction. So there's no chance of Trump being prosecuted anytime in the near future, or possibly ever, because this thing will be tied up. This thing will be tied up for years. Because it's the first time you've ever had to do it. That's the real problem. That's the real problem, right? If this were just like normal criminal law, it wouldn't be so bad because we've done it, 100,000 times. So trying to do it the 100,000th and first time isn't so bad, but it's literally the first time you've ever done it. You're trying to create everything from anew, and as a district court, there's no way you're going to get it right? There's just no way you're going to get it right. You're definitely going to get it wrong. There's no hope. You're definitely going to be overturned. There's no hope of getting it right. The real problem is, like, even assuming that Trump should be prosecuted for these offenses, it's like, how do you create a general principle from that doesn't wind up breaking everything? That's the real problem. The minority's answer to that problem is fundamentally trust the prosecutors, trust the DOJ. That's their answer. That's not really a great answer, because you've changed all the incentives in the future. So it's like, assuming that prosecuting Trump should be legally permissible, how do you keep this inside a box that prevents everything from going to hell? And the minority doesn't really seem to have any answer for that, which is incredibly annoying. And it's certainly possible that the majority goes too far the other direction. But I don't feel like the minority really sufficiently wrestles with the problem, despite the time they've had for it. So I don't know what I think. I don't know what I think. Partly because my brain is mush. I think they're mostly right about the core acts. I think defining the core acts is easy enough. That's just Youngstown Steel Part 3. We've been doing that. We have that for like since the 40s. So we've got that down. That's easy enough, just what the Constitution gives them. And I would say that, yes, the president should be essentially immune, except insofar as the official act would be a element of a crime unto itself, and bribery would be the most obvious example. So I think bribes for pardons should be illegal. I think bribes for an ambassadorship should be illegal. But otherwise, I think there's immunity. I think they're mostly right there. I definitely agree there should be no immunity for private acts. And then official acts, whatever this middle ground is, the Supreme Court didn't give me a lot to work from. Their language can be read extremely expansively, but I'm not even sure that they intend that. They seem like more like they're leaving it open for the future, so that basically no matter what a court does, it's basically the wrong answer. So they basically punted. And then they'll blame the lower court for getting it wrong, which is very annoying for the lower court. My brain hurts. And also, I agree with the dissent insofar as the majority opinion could be understood to apply to impeachment, which obviously makes no sense. Which is also part of the problem. It's like, yeah, I mean, I don't think the president should enjoy immunity for anything if he's impeached. I think that's probably right. So to the extent that you understand the majority, although the majority opinion doesn't really mention impeachment, they don't not mention it either. They don't carve it out, which is annoying. The majority doesn't really mention impeachment either way. It's not like they say, well, even impeachment, but they don't say except impeachment either. So the majority sucks balls for, not clarifying that issue. And then I suppose you do have the potential problem is like if you make the conclusion that the president has no immunity for anything, assuming he's successfully impeached and convicted, if you make the conclusion he has no immunity for anything in that situation, then there is sort of a question about why does he have immunity if not that situation, which is a bit unsatisfying. So I don't know whether immunity applies in impeachment or not. It definitely doesn't preclude Congress from impeaching. That much I'm sure about. So they can continue to impeach him for whatever reason they want. That much is clear to me. They can impeach him and convict him for any reason they want. That much is clear to me. But does that mean that his criminal liability is now total? Does that mean, it seems like it does, but the majority opinion's unclear on this point, which is annoying. Not immune for the specific act they're being impeached for? That's even a bit unsatisfying, to be honest. Because suppose for some reason that new information, suppose you do have a president who's impeached and convicted for a specific thing, and then suppose at a later time, new information comes to light about another horrible thing they did. What are we supposed to do? Impeach and convict him again? That seems a bit ridiculous. It's like we've already done everything we can do to him, right? We've already kicked him out of office and disqualified him from office. So what it's like, yeah, that doesn't really, I don't think that makes sense. All right. I will now attempt to take some of your questions / comments. Go get a calzone. Calzone sounds pretty good. When you need to have immunity for practical reasons, or you end up with presidents being charged with treason for making diplomatic connections to hostile states, you mean within the context of impeachment? I think that's Congress's prerogative. I think that's Congress's prerogative. I think their power to impeach and convict is absolute. So because you don't need to impeach him, it's fairly clear, and I don't even, and the scholarship agrees, like it doesn't need to be a crime to impeach. Impeachment refers to political crimes, not legal crimes. So you don't need to cite a legal crime to impeach. You can do it for anything. You can do it for anything. Anything will be fine. The only barrier there is the fact that the political will to do it, and you need 2/3 of the Senate is the big problem. So, but that's the barrier. Is the political. Can I impeach an ex-president to allow them to become sued? See, I think you can. Yeah, I think you can. What little discussion there is in the scholarship supports it. You can impeach someone. Yeah, you can impeach someone even if they're not the president anymore. It's like disbarring someone who's not a lawyer anymore, which the courts do that too. Yeah. Just because you gave up your law license will not necessarily mean that the bar won't disbar you anyway, because they're pissed. So yeah, I think they can. What else? Does this ruling return an understanding close to the understanding of the origin of the country? I don't know. There's not a lot of on it anyway. And the majority, it's not clear what they had in mind. There's not a lot of discussion on this point. The minority also does have a fair point that, they obviously knew how to write an immunity provision, and they did it for Congress with the speech and debate clause. So they knew how to write an immunity clause, and they didn't do it for the president. So that might imply something. I don't think I like this decision very much, because I think it leads to a sea of confusion. I don't think I like this opinion very much, because it's a sea of confusion. It's kicking the can down the road, just with many extra steps. I think that's what's going on. I think it's just an incredibly, insanely complicated, wordy document that that hides the fact that it's just a massive punt. I think it just might be a total massive punt. And there's really a decide not to decide, to be honest. Sucks. The minority is right that there's a whole nebulous middle land of uncertainty. And it's going to lead to incredibly insane nightmares of legal interpretation for the foreseeable future for Trump. He's a relatively old man, so his odds of dying before there's resolution is pretty high, to be quite honest. It's going to take forever. The upshot of it, though, the upshot of the practical is, I don't see how there can be a trial of Trump in DC or Georgia because there's still immunity, right? There's still immunity. So and so many of his official acts are built into that indictment. Holy shit, dude. Holy shit. Right? So they have to redo all that indictment, and that's not easy. Plus even when they redo the indictment, there's going to be a fight over whether it's right or not. So Georgia's going nowhere. DC, at least with DC, I don't think they have to redo the indictment. So they got that going for them. But it's still going to be a nightmare for the foreseeable future. New York, the New York conviction should now be vacated because a lot of evidence was offered that is now no longer valid, and that case is still ongoing. It's a live case. Its appeals have not been exhausted, so it's live. So the conviction should be vacated. Any other charges New York wants to bring are impossible. New York probably won't vacate it, but they should. And if they don't, they might get a writ of mandamus from the federal district court at this point. Who the God knows? The only case that could really proceed is the documents case in Florida. Is really the only case that could go forward, but for a variety of reasons, depending on who you believe, because the judge is trying to screw it over because she's a Trump heartthrob or something. That case is stymied in procedural hell for independent reasons, independent of this case. So yeah. So that's the upshot for Trump for the foreseeable future. How does it undo the New York conviction? Because the New York conviction is now based on a whole bunch of evidence that was legally improper. Because the U.S. Supreme Court just said, if it relates to his official acts, if you assume he has immunity, then you can't use it as evidence. You can't use it as evidence. And they used a lot of things in that trial that relate to his acts, even core acts. So there's a lot of things in that trial that are now no longer valid evidence. They convicted him on a whole bunch of evidence that's now not evidence. And there's so much of it that you can't possibly do there's no hope of doing a harmless error analysis, right? So sometimes you can do a harmless error analysis. So if they had only used one thing, then you could do a harmless error analysis and be no harm, no foul. But there was so much of it that permeated that trial. There's no hope of doing a harmless error analysis. So the only remedy is to vacate and go back to trial. At which point, then you'd have to redo all this stuff, from the beginning in that trial. So it should undo it as operation of law, because the conviction is now based on an intolerable amount of evidence that should never been presented in the first place because the law just changed just now. Not sure how the Docs case can go forward because it relates to his possession of documents after he was in office, so it doesn't relate to official acts. That's why. Yeah. And if the idea is that he, as an official act, gave himself the documents somehow, that's a defense as opposed to an immunity. Because it's now arguing basically he had permission, which is a defense. So the documents case should be able to go forward. Yeah. Plus, I don't even think the defense works because Donald Trump himself was caught on tape saying, I could have declassified it, but I didn't. Could have declassified it, but I didn't. So I'm not even sure that the judge has to allow the defense, because you only have to allow a defense that's cognizable at law. And and Trump's over here on tape saying, I could have declassified, but I didn't. Most precious documents could have declassified. I didn't. I'm not sure that they have to allow the defense that he gave authorization to himself because he's on tape saying he didn't. I'm not even sure the judge has to allow the defense. It might not even be cognizable at law. That's how bad it is. It's fucked up. Him speaking could be an official act. No, it can't, because at the time he said it, he wasn't president. So, no. But thanks for playing, no. Can he retroactively declassify them? Well, he can just pardon himself and make his life easier. But it's moot if he becomes president. The charges are necessarily frozen against him for 4 years anyway. And, it's like, so if he becomes president, it's moot. It's just like, plus he can pardon himself, plus whatever, it doesn't matter. And the recording wasn't the document he's referenced, not the one he was charged with. You might be right. I couldn't swear to it. He was charged with a whole bunch of documents. I thought one of the documents he was charged with was the document he was referring to. But if you're correct that it wasn't one of the documents he's charged with, then fair enough. But I haven't been following it that closely. He was charged with a whole bunch of stuff, so if he was referring to a document that he wasn't charged with, then, okay. Then fair enough. Maybe then the defense would be cognizable at least. So, yeah. Just to illustrate the point about a cognizable defense versus a non-cognizable defense, I forget who told me the story. I'm pretty sure it was one of our law tubers, but I couldn't tell you which one. I'm pretty sure one of the law tubers told me this story. It might have been Gosney, but I couldn't swear to it. They told me about a defendant who was charged with murder, and he argued self-defense. And apparently, if I understand the story correctly, the defendant took the stand in his own defense, and the prosecutor decided to cross-examine him. And apparently, during cross-examination, something like the following exchange took place. The prosecutor said, okay, so you carry a gun. It's like, I sure do. Carry a gun a lot? Yeah, I carry a gun a lot. All right, why do you carry a gun? Well, so I can feel safe. Does carrying a gun make you feel safe? It sure does. Yeah, so you feel real strong and protected by a gun. I sure do. I feel real strong and protected by having a gun. It makes me feel real strong and protected. I'm not afraid of nothing. I'm not afraid of nothing when I carry a gun. And the self-defense case evaporates instantly as he now destroys an essential element of the defense, which is namely his subjective sense of fear. The judge did not give the self-defense instruction, and he was convicted because self-defense was never offered to the jury, because the defendant said, "I ain't afraid of nothing when I'm carrying a gun." Fantastic. Yeah. Yeah. It's subjective. It's not objective, it's subjective. Self-defense, you need both. You need both objective and subjective. You need the reasonable man and you. The reasonable man would feel fear, but also you have to feel fear. And he said, "No, man, I'm not afraid of nothing when I'm carrying a gun. I'm not afraid of nothing." It's like, okay, so you have no subjective sense of fear. So, poof. Poof. Yeah, don't do that. Don't say things like that. That'd be great. Yep, that'll do it. That'll do it. Is this a therapy session? Maybe a little partially, yes. I'm still trying to work through it a little bit and talk about the legal reasoning and stuff like this. I found the decision, my overall conclusion is I find the decision wanting. I think the majority's critiques of the majority are mostly correct. The minority, well, there's significant problems with the majority, as highlighted by the minority decision. The minority doesn't really have a good answer, though. Their answer kind of sucks. Amy Coney Barrett is the closest to something that makes more sense. So if I have to pick a winner today, I guess I'm going Amy Coney Barrett on this one. Although I think she goes too far on the admission of the evidence, because I think it raises too many problems. I would have preferred a more cautious, even if it would be basically like a note to 403, like I could live with that. Like, even if it's not categorically excluded, like say something like the court should be exceptionally careful under Rule 403 to allow the admission of any evidence because of the political nature would be substantially likely to be unduly inflammatory. And so the court should be exceptionally careful in admitting any evidence over a 403 objection. I could live with that. But Amy Coney Barrett went too far in that. But otherwise I think she's fine. I'm gonna go with ACB on this one. The man on the tram, you got it. Yeah, it's the man on the something specific tram. It's a specific tram. I couldn't tell you which one, but in London it's a specific name. It's like the Osmond tram or some bullshit. Yeah, it has a specific name, but in London it's the man on the something. Yeah, you guys have the same concept in Australian law. The man on the bus. Yeah, the average, ordinary, normal man. You got it. Yep, you call it something slightly different. You guys have a cooler name. You guys have a specific line or something. We don't have that. We're not that cool. Has it been 6 hours? Has it really been 6 hours? Oh, shit, it has. Yeah. Wow. I lost complete track of time. I lost complete track of time. Holy shit, it's been 6 hours. Oh, dude. I had no idea. It's been 6 hours. I had no idea. Oh, man. Man on the Bondi tram. That sounds right. That sounds right. I'm going out to lunch now. I'll leave this up. I'm going to chew on this some more and think about it some more. Maybe listen to some left-lean views or something on the issue. Try to get a broader perspective. And I'll think about it some more. My brain is melt. My brain is melt. If you've enjoyed this channel, please make sure to hit subscribe. I feel like I really earned it. If you give a like, that'd be appreciated. And did you know for a mere 99 cents a month, you too can become an uncivilian? It's true. Merely by hitting that join button, you can help to support the channel so that uncivil law can continue to exist and stuff. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.